Lordship's kind permission. Lords, one fresh matter for
All fresh
GMCPC.
matters, give it
Fresh
to the
matters
court
kudi.
of...
Lord, tomorrow for this reason.
Yes.
Lord, tomorrow for this reason.
I'll come. Yes. Yes, tomorrow, yes. Fresh matters, again, don't make a mention. Give it to the court officer, yes. Fresh matter.
Fresh matters.
Ask the court officer what is happening. Yes. Is it a pending matter? Fresh matters, why are you mentioning? Give it to the court officer. Process all fresh matters to the court officer. It will come.
My lords.
Yes. Tell the court what is the urgency? Why are you mentioning it? Which year is the MFA? Huh? MFAs will come. One on Thursday they will come. Your matter will also come on some Thursday.
Lord,
Yes.
day after tomorrow case is posted for arguments. Lord, tomorrow, my lord, one matter, fresh GMCPC matter. IA is rejected, my lord, filed for
When was the
production
IA?
production of product
When was the IA rejected?
19th, my lord. 2 days back, my lord.
Yes, tomorrow. Yes.
Tomorrow.
GMFC matter. Lordships.
Interim order vacated. Interim order passed on 5/1/2026. And immediately next defendant appeared. And on the memo filed for interim order vacated.
Problem is all matters to come up tomorrow. How is it possible? At least one of you tell me.
Now the defendants are.
No, for everybody, everything is urgent. Everything should come tomorrow. Is it possible for the court to hear all the matters? Take all the fresh matters. We will see.
Fresh matters
My
kudi.
lord.
The list will come.
Tomorrow there is an auction, my lord. Petition GMFC
What
matter.
was the auction notification?
Last week, my lord.
Huh?
Today we got, my lord.
So whenever you file, it is urgent tomorrow. Give it to the court officer as per the convenience of the court, it will come.
Tomorrow,
I
madam.
can't take it as per your convenience.
At least tomorrow, my
Yes,
lord.
no.
Your lordship, there's a pending matter.
Court officer, give it all the memo to the court
Posting
officer.
memo kudi. Yes.
My lord,
My
submission,
lordship, my lords, pending matter, my
my lord.
lords.
Submission.
Give it to the court officer. Every day we can't go on like this mentioned. Matters can't be urgent every day.
Submission, my lord.
Give it to the court officer. I'm not going to
This
listen
is
to any of the mentions. Give all the memos.
Lordships, one matter for tomorrow, election matter. Election matter, right to vote.
You see, we will see.
Tomorrow, 26th is the election. If petition becomes effective.
Why were you waiting till now?
No, election was declared the day before yesterday. That is the difficult. 26th.
We will see.
Tomorrow at least.
Your lordship,
Election
there's a
will-
pending matter in which
This
stay
could be the
order.
result of mentioning every day with, like this, without any urgency, all matters to be listed. When the memo is moved, when the court asks why did you move the memo? No reason for that. Just like that, everybody is moving and wasting time for half an hour in the morning. Take all the memos, we'll see. As per the convenience of the court, it will come.
One
Call
hour.
the list.
List number 1. Page wise adjournment from admission. Page number 7, seal number 34. Page number 8, seal number 35 to 41.
My lords, serial number 37, my lords,
Yes.
seeking for short accommodation. It may be taken in the next week.
37. Irangoda K. Kabur.
Please,
Is this matter in the month of March?
please, my lords.
My lords,
Just of learned counsel for the appellant.
my lord, serial number 34, my lords.
Yes.
The connected matters were of the division match, my lords. So kindly this matter,
It is submitted that the connected matters are listed before the division bench. What is the number? Give it to the court.
it's in the cause list, my lords.
Where is it?
In 34.1, my lords.
Division bench, I'll post along with 102948 of 2022. Yes,
Please, my lords.
yes,
Page number 8, seal number 35.
Serial number 35.
35.
No, Subhash Badi, respondent side.
no petitioner appellant will move a memo, respondent will come and ask for time.
Ma'am, my senior Subhash Badi sir is out of station. That's why next day to.
My lords informed. They have informed.
Why did you move this MFA of 2023?
My lords, it's urgency. They have not deposited.
See,
They have not deposited at the compensation amount, my lords.
They have not deposited the,
Please, my lords. Compensation amount awarded by the tribunal.
this matter tomorrow.
Please, my lords.
Yes.
Page number 9, serial number 42 to 48.
Lord, serial number 48, for the respondent, my lords, senior has some meals,
Mahantesh R. Patil.
not well, my lords.
They have an interim order in this?
Please, my lords.
You have an interim order?
Suraj.
Please, my lords.
At the request of land counsel, the appellant, this is matter in the month of March.
My lords, in this
Interim order
matter, in all of the matters, there's an urgency, my lords. All the matters, we've challenged the compromise decree before the Lok Adalat, my lords. Only the contesting respondent is Sir, my lords, and due to their inconvenience, my lords, may have it on Tuesday, my
If you
lords.
have a stay, what could be the urgency for you? When you have a stay, not necessary that all matters should be heard and decided now itself. Yes, just in the month of March.
In this matter, possession is discussed by the respondents area. The one of the petitioner in the connected matter about compromise with the respondent and the property is given.
There is a stay of the compromise decree. There is a stay. in this-
Please.
So what is the urgency?
They are applying the property.
Who are you?
I am one of the respondent in the regular appeal. Without my signature, compromise decree has been declared by the one of the respondent and the appellant in the regular appeal. I am not participating.
This is matter on 10th of February.
10th.
Please, my lords. Interim order, may kindly.
Yes, interim order earlier granted is extended.
Grateful.
Page number 10, serial number 49 to
My
51.
lords, serial number 49. Serial number 49. Some
49.
49. Some serial, some
Singraj
personal
Murali.
inconvenience, my lords.
2024 matter, not even notice is issued. When the matter comes up in the
My
list.
senior is
you
out
ask
of
for
station
time.
due to some
No, we will
personal-
see. We will not adjourn. If senior is not there, junior should be ready to argue the matter. Yes.
Page number 11, serial number 52 to 60.
Serial number 55, my lord.
55.
I'm withdrawing the petition, my lord. I'm filing the memo. 55.
Serial,
Nandish Patil.
Memo is filed that on instructions received from the client on 19/1/2026 through email, the petitioner wants to withdraw the writ petition. What is this alternative remedy?
My lords,
What is the alternative remedy?
my lords, he will approach the concerned police, my lord. Bank account was freezed. After, my lord, that we filed the writ petition before this
You're
honorable.
asking the liberty, we have to look at the file. Please wait till the matter reaches.
Please, my lord.
Yes.
Serial number 56, your lordship.
Serial number?
56.
Yes.
Weeks accommodation may kindly be granted. I appear for the petitioner, your lordship.
Why?
Personal inconvenience, your lordship.
If you have personal inconvenience, I can grant only in the month of March. Because every matter can't come in the list every day.
See a
That's the
shutter.
difficulty. Ask, you please find out. If that's the case, please mention when the matter is called.
Please.
My lords, serial number 57, my lords.
Serial number
57, a week's accommodation.
50?
57,
57.
57.
I already
Raj
said
Murali.
I have already refused the request. No, this matter also. All these matters, not even notice is order. They are in the list.
Kindly request for a week's
We will
accommodation.
see.
please,
We will issue notice.
Page number 12, serial number 61 to 69.
My lordship.
66 minutes.
Yes.
We have, I appear for petitioner, though we have moved the memo, file has been misplaced. Madam. May I request it on?
Why did you
Tuesday?
move the memo then?
Lords, we have moved them, but file has been misplaced, my lords, yesterday. I request it on Tuesday, my lords. We'll reconstruct and argue that matter.
These are very unreasonable on the part of the
Tuesday
advocate. To move the memo and say that the file is misplaced. You should have looked at it unless and until there is a,
Yesterday we have-
how will you argue?
Yesterday file has been misplaced. Lords.
Is this matter after 2 weeks?
My lord, serial number 68, my lord.
60?
8.
Yes.
1 week according.
No, 1 week for fresh
Right.
matters. Yes.
Page number 13, serial number 70 to 78. Page number 14, 79 to 84.
My lord, serial number 83,
Yes.
subsequently for R1, my lord. So personal inconvenience, next week, my lord, other petitioner side.
Form to the
Of them
council for the
party?
Yes,
petitioner.
yes. Next
Yes,
week.
Mrs. Matter in the month of March, at the request of land council, the respondent. If interim order is there, extend. Yes.
Page number 15, serial number 85 to 87. Page number 16, 88 to 1894.
Yes, serial number 90, your lordship. 90, 90. I appear for respondent number 2, your lordship. I seek week's accommodation, your lordship.
91,
92,
92.
90, 91, sorry, 91, 91, your lord. Sorry.
Why
90,
you
Your
want
Lordship.
adjournment?
90.
Why you want adjournment?
I have misplaced my file, Your Lordship.
Huh?
Day before yesterday, I have misplaced
Why
my file.
misplacing the file is very common for the court or
No,
what?
no, no,
Every
no.
day everyone is misplacing the
But
file.
I'm for petitioner in this matter, my lords.
I request on 30th, Your Lordship, it will be meeting. 30th.
If anybody wants adjournment, it has to be on a long date. If you're prepared for that, ask for adjournment.
For
No, on
convenience of the
30th, my lords, what has happened on the last date of occasion, there was an interim order. Due to inadvertence, the same was not extended. The matter is
Yesterday,
being
because
proceeded in the trial court, my lords.
now the matter is coming up in the list.
Please, I'm ready with the matter as of now also, my lords.
It's for time.
Please,
And
some
again, by tomorrow,
inconvenience.
everybody will stand in the queue for the memos.
Lords, on 30th.
30th, Your Lordship, I am
Any
seeking
short
30th,
my
it will be
lords.
discussed.
Should also have the time on
Please,
30th.
Lordship, I agree.
List this matter on 30th.
Much obliged.
Please.
Much.
Page number 17, seal number 95 to 101. Page number 18, 102 to 105. Page number 19,
Ma'am, 102, serial number 102.
Yes.
102.
Ma'am, kindly give the next date. Senior is out of station.
This is matter in the month of March. Yes.
Thank you.
Page number 19, 106 to 110. List number 2. Page was adjournment from page number 6, seal number 19. Page number 7, 2021.
22, my lord, serial number 21, my lords.
21.
Day before yesterday matter, my lords were directed to list the matter before yesterday. The appointment of court commissioner has been dismissed by the trial court, my lords have granted the stay. My senior thereafter submitted, there is some misconvenience.
That's why it has come up.
My lords, kindly have it on Friday, my lord, senior has some personal inconvenience.
This is matter on 11th of February.
Lords, there is
My lord,
emergency, my
serial,
lord.
Yes.
my lord, serial number 20, serial number 20, list 2, serial number 20. We have a respondent, counsel on record is not keeping well.
Have you informed the other side?
I'll inform him right now.
No, you have to inform and then make a mention, or else you have to wait for your turn. Yes.
Serial number 22.
He's here, he's here.
22.
List number 2, serial number 20.
Yes, 20. This is matter
My lord,
on
one submission.
19th of February.
Interim order may kindly be extended. my
Yes, it will be extended. You don't have to.
And my
ask
lord,
for
I
it.
have already served the copy, my lord, but it is showing it's not.
We will see when the matter comes up on that day. Yes.
22.
This party.
What do you
Short
want?
accommodation.
Why?
I am not well.
This is matter in the month of March. Once again.
Interim order may kindly be.
Interim order earlier granted is extended till then. Yes.
Lord, serial number 16. Serial number 16, my lord. Kindly 1 week time, my lord.
16, my lords, I appear for the respondent. It is an appealable order, my lords. Order passed by the District Consumer Forum is under challenge, and that too it is under challenge on merits, my lords. I have filed for vacating IA. And similar matter, my lords, 1,02,080 of 26. My lords.
Will not adjourn. Yes.
My lord, serial number 25 and 26, both are connected matters, my lord. In another connected matter, your lordship has given date for tomorrow. These two matters are through oversight listed today, my lord. All three connected matters maybe have it tomorrow, my
What is that number?
lord. Chetan Tilim. I will write it. I will write it and give it.
Yes. Post along with so and so.
My lord, serial number 24.
My
I
lord,
am for the
serial-
petitioner.
Serial
Kindly-
number?
24, my lord. I am for the petitioner. Short accommodation, my lord.
List in the month of March.
Interim order extra, my lord.
Have you informed the other side?
My lord, copy.
I am for the respondent.
Please, my lord.
Yes. Interim order requested if it is there extend. Yes.
Serial number 28, my lords. I am for the petitioner, my lord. Senior has some health issues today, my
Move
lord.
the memo.
So Lord, I have moved the memo, my lord.
Petitioner, why should we adjourn the matter?
Senior had got some throat issue, my lords, today. May I seek on Monday, my lords?
My lord, it is relating to consumer court, my lord. Alternative remedy is available. It is an appealable order, my lord.
Maybe take
Friday,
on-
my lord, it may be kept on Friday.
This is matter tomorrow. Please call the next.
My lords, on kind permission, my lords. In serial number 1, my lords, list number 1, serial number 23, it was listed yesterday. I sought 1 week accommodation to withdraw the petition. Since I have challenged the interim order, subsequently final order came to be filed, my lordship. But on oversight, it is listed today itself. I have to take signature of party. It may be posted next Wednesday, my lordship. List number 1, serial number 23.
My lords, list number 1, serial number 32. my
Already
lord.
over. I
Sorry,
cannot
my lord.
go back.
It is
No.
hearing on IM. my
Please
lord.
wait. Call the list.
Grateful.
List number 1, being spoken, serial number 1.
There is a small mistake crept in the minutes, the cost title minutes. Instead of zone 10, 3 minutes, 10 is being written minutes. That minutes, for that reason, minutes, the respondent 3, they did not accept the interim order. Therefore, I moved. I beg your pardon, but there is a mistake on our part also. Because in the cost title, mistake 10 and it's 10 minutes. So only correction.
First of all, you have to correct this.
Yes, I've sought both minutes in the cost title and in the interim order. In the memo minutes, I've stated so. Lordship permits me minutes, I'll make the correction.
Memo is fine. Stating that in the cost title, instead of mentioning zone 3, it is mentioned as zone 10, and the petitioner wants to amend the correct the cost title, and also this is on
in the order also it is same as the interim.
once. Then you have to, the petition has to come.
Sorry.
You correct it. You have to first correct it.
Yes.
He has to file an application seeking for amendment.
I'll correct it. Lordship may say the same may be carried out in the interim order also.
No, without you doing this, I can't say that first.
Yes, I'll do it. Lordship may kindly pass it or then Lordship pass.
Yes, next.
Preliminary. Serial number 2. Sangram.
Yes.
My lord, the petitioner had challenged annexure K, my lord, an order passed under section 73 subclause 9 of the GST Act, my lord.
Your lordship, there is appealable provision, your lordship.
Let's see. First of all, let us see. Where is your prayer? Prayer.
My lord, annexure.
You are questioning an order passed by Deputy Commissioner of Commercial Taxes.
Yes, my lord. My lord, it is passed under order section 73 subclause 9.
Give the act.
My lord, as per the provisions of the GST Act, my lord, if any adverse order is to be passed without giving an opportunity of personal hearing, the same cannot be passed, my lord. In this case, the objections to the show cause notice were filed by the petitioner on 25 section 75(4), section 75 subclause 4, my lord. An opportunity of hearing
An opportunity of hearing
Yes.
shall be granted where a request is received
in writing from the person
chargeable with tax or penalty, or where any adverse decision is contemplated against such person. This is passed under section 75.
This is a mandatory provision, my lord. My lord, the present order is passed under section 73 subclause 9, and the procedure that is contemplated is not followed by the respondent, my lord. My lord, this is on technical grounds. My lord, as far as on merits, my lord, the petitioner has set up a power plant, and before setting up the present power plant, it had already set a power plant with 20 megawatt capacity, my lord. In the year 2018, when it started commissioning the said power plant, it had applied before the advanced ruling authority to seek clarification as to whether they are entitled for input credit on the capital expenditure which is incurred by the company on installation of the solar power plant. For that, the advanced ruling authority of the respondent has passed an order saying that we are entitled for the input credit as per section 16, my lord. The same activity is now carried on by the petitioner with a lesser capacity of solar plant, which is also at the same place. My lord, now for 20 megawatts, they are allowing the same expenditure, but for 10 megawatts, they are denying it. So this is clear discrimination and non-application of mind, because the same authority, the higher authorities say that you are entitled. And now without considering the advance ruling, which is passed in the same SSC, same GST number. And therefore, on merits also, my lord, they are not given an opportunity of personal hearing. They have not considered the advance ruling. Therefore, the said order deserves to be quashed.
Your Lordship, as there is the appeal provision, Your Lordship, the Honorable Court in coordinate bench will take that, sir.
My lord, I'm also relying on two judgments of the bomb. I have
Under
yesterday
section
relied on the-
107, appealable provision is there, Your Lordship. Para 3 of the order.
What do you say on the alternative remedy?
My lord, when the order is patently illegal, even if there is an alternative remedy available, this honorable court in WP number 8050 of 2024.
That's a whole controversy everywhere.
My lord,
Same contention. you can-
Wow. Every order that is.
no, my lord,
appealed,
where it is patently,
some error on the.
well, patently illegal because they are not following the advance ruling in the case of the same SSC, where the GST number is same.
Why the, under 107, we cannot decide all this?
No, my lord.
Why?
Because now the authority, the appellate authority also is below the rank of the advance ruling authority. When the higher authority, if the High Court decides and says that you are entitled for benefit, the appeal to the senior court by the junior judge, that is not an alternative remedy that is available. The advance ruling authority is above the appellate authority under section 107.
Your Lordship.
My lord, my lord, in similar situation where an order.
Your Lordship, whatever the contention he states.
That is the settled law. For that, we don't
Please, Your
require
Lordship.
judgments for when there is, even if there is an alternative remedy where whether a writ petition can be entertained or
No,
not.
my lord, in this case also, order passed under section 73(9) itself is quashed. In WP number 80.
Not required, yes.
Your Lordship, the contention which he is taken, Your Lordship, that may be raised before the appellate authority also, Your Lordship.
Didn't hear what his submission is.
Please, Your
He
Lordship.
says, that advance.
Advance ruling authority.
Please, Your Lordship.
Authority is,
But when appealable remedy is available, Your Lordship, without going into that contention, Your Lordship.
The present writ petition is filed. Seeking the following prayer. The facts of the case are: the petition is a public limited company registered under Karnataka Goods and Service Tax Act 2007. The petitioner is primarily engaged in the business of manufacturing cement and electricity generation from solar power. The petition has two cement manufacturing units, one at Lokapur and another at Kalburgi. In the year 2017, the petitioner installed a captive solar electricity power plant in Bisrahalli village of Koppal district. The petition has received government order from GOK to set up and produce electricity by GO number 381 NCE 2016, 82 to 2017, whereby the petitioner was authorized to set up renewable energy based on solar electrical power plant of 20 megawatts capacity. The plant was commissioned and operative with effect from 1/4/2018. Petitioner for the purpose of setting up power plant at purchase capital goods under the state and central electricity regulation. The petitioner was required to seek permission for setting up of captive power plant under into agreement with power transmission authorities. After the solar plants were commissioned, the petitioner approached the authority on advance rulings in KGST/CGST Act seeking clarification on eligibility of input credit under section 16 and 17 of the GST, CGST in respect of input, input services and capital received towards erection, installation and commission of solar power plant at Pisrahalli, Koppal district. The authority passed an order under section 98(4) of the CGST Act 2017. After receipt of the advance ruling, the petitioner has been regularly filing its GST returns relating to the power generated by the petitioner in its solar power plant of 20 MV capacity. After that, the petitioner has obtained the permission for another captive solar power plant of 10 megawatts capacity at Bisarhalli, Koppal district in 2021-2022. And it was operational during the financial year 2021-22. The petitioner is using the power generated from the solar power plant for its manufacturing activity in furtherance of its business. The advanced ruling authority has held that ITC availed by the petitioner on solar plant setup is admissible as electricity generated under 20 megawatt capacity is captively consumed by the petitioner. As a 10 megawatt solar power plant is also set up by the same SSC under the same GSTN at the same location, connected to the same grid, and the power generated is exclusively transmitted to the same civil plants. The ITC availed is admissible by the petitioner. In August 2025, the respondent during the course of its audit for the period April 2021 to March 2022 has observed that the petitioner was ineligible to claim input tax credit on solar power plant product, ineligible to claim the input tax credit on insurance and financial services, ineligible on work contracts, construction and vehicle repairs. And a letter was addressed on 6/9/2025 under section 65(6) of the GST Act, read with 101 within brackets 4 of the KGST rules 2017, calling upon the petitioner to file objections if any. Petitioner had filed his objections on 12/9/2025. Thereafter, the respondents have issued the form on 12/9/2025 under section 73(5) of the CGST/KGST Act. And the petition has filed its reply on 18/9/2025. Thereafter, the respondent issued from on to 27/9/2025. There is a so-called notice under section 73(1) of the Act, read with rule 142(1) of the CGST rules. In response to that, the petitioner has replied on 23/10/2025, requesting to withdraw the show cause notice in its entirety and confirm the ITC claimed by the petitioner, and also requested not to raise any demand for tax, interest and penalty, and dropping the proceedings under section 74. It is a case of the petitioner that the respondent, without following the procedure prescribed under the GST Act and without giving any opportunity or personal hearing as contemplated under section 75(4) of the GST Act, has arbitrarily passed the impugned order dated 12/11/2025, disallowing the ITC claimed by the petitioner and directing the petitioner to remit the sum of rupees 7,23,74,871 as tax liability for the financial year April 2021 to March 2021, which by the petitioner to come before this court Learned counsel appearing for the petitioner submits that section 75(4) of the Act contemplates that an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. It is the argument of the learned counsel that the procedure contemplated under section 75(4) of the Act was not followed by the respondents. It is also submitted that though there is a remedy available to the petitioner under 107 of the Act, that is not an effective alternative remedy for the petitioner, as the authority who has to grant the adverse ruling is superior to the appellate authority. In those circumstances, the petitioner has come before this court and by filing the writ petition in spite of an alternative remedy, as the same is not an efficacious remedy. It is submitted that just because there is an alternative remedy, that itself would not be a ground to disentitle the petitioner to knock the doors of this court under 226 of the Constitution of India. The learned counsel for the petitioner, some of his arguments saying that both on the ground that there is the respondents have failed to follow the procedure under section 75(4) of the Act, and also the fact that the authority who has refused the advance ruling is superior to the appellate authority. Hence, it is submitted that the writ petition, the impugned order needs to be set aside. Next para, Leonard CGP appearing for the respondent submits that the petitioner has an alternative remedy under section 107 of the Act, and she relied on the order passed by a coordinate bench of this court in that petition number 108727 of 2025, dated 5th January 2026, and submits that the petitioner has to be delegated to the appellate authority and the petition is not maintainable. Next para, having heard the learned counsel for the learned counsels on either side, there is a material on record. Section 75 of the CGST Act deals with the general provisions relating to determination of tax. Section 75(4) reads thus, extract 4. So section 75(4) makes it clear that an opportunity of hearing shall be granted where a request is received. Admittedly, in this case, an opportunity of personal hearing is not afforded to the petitioner. When it comes to the effective alternative remedy as submitted by the learned counsel for the petitioner, when the authority who has refused the advance ruling is inferior to is superior to the appellate authority, in those circumstances it cannot be held that in those circumstances and in the facts and circumstances where the petitioner where there is no in the facts and circumstances, it cannot be termed as an effective alternative remedy. In that view of the matter, this court deems it appropriate to pass the following order. The order dated so and so, passed by so and so, is set aside, and the matter is remanded back to the, which authority is the
Respondent.
respondent? Only respondent.
Only respondent.
The matter is order is set aside, and the matter is remanded back to the respondent and the respondent by affording an opportunity to the petitioner, by affording an opportunity of personal hearing to the petitioner as contemplated under section 75(4) shall pass appropriate orders. Accordingly disposed.
Obliged.
Yes, next.
Seal number 3, orders matters. Ravi Kumar Gokakar, Sanjay S. Katgiri.
Kindly pass over, my lordship. He is held up in the quota number 2, 3, my lordship.
Pass over.
Pass.
Yes, next.
Seal number 4,
It is
Nurada
stated-
Deshpande.
It is stated that the value of the appeal is more than 15 lakhs. And let's this matter before the division bench. Next.
Seal number 5, Jagdish Pat.
Also same.
Please. Same.
Yes, 6.
Seal number 6, Jay Shetty. Partition.
Needful is done, my lordship.
Why the memo is moved for that? Who has moved the memo? So what is happening? I'm not able to understand with the advocates. Because you have done the needful, why should there be a memo for this? And why do you want a matter to be listed to tell the court that you have done the needful? The memo is moved by the advocate. Now, when the matter comes up, it is stated that the needful is done. The court is not able to understand why these kind of memos are moved by the advocate. List this matter in the month of May. In the month of June. List this matter in the month of June.
Seal number 7, 14%. Nana. Seal number 7.
Respondent, my lords.
Yes.
Viresh Budihar.
Lordship, I am Mr. Nana Dhondiwa Desai, party in person. I am contesting this case for last 10 years. So I want to place you the truth. Mr. Anand Apugwal from Belgavi, he has collected some money from fixed deposit money from 3 societies and defaulted 300 crores and changed as the investor. And I am the only person I filed this case under KPI Act. All investors, they are filed in the consumer court. This is a very tragic, sir. Because even a special court tell me, you will get the money under KPI Act. You cannot get the money under Consumer Act. So therefore, this is a.
So what is the prayer you are seeking?
Kindly see the page number 7. Page number 7 order.
Let me see. Let me see.
Page number 7 order.
Competent authority to disperse rupees 6 lakhs to so and so and other fixed deposit claim of so and so. As per affidavit filed. Yes.
Lordship, this authority, Your Lordship, who is appearing, Viresh Budihar, where the amount is deposited. Your Lordship.
Yes.
They are
I beg to appear for the respondent, please, my lord.
Yes.
My lords, the prayer, my lords, of the petitioner is that he has to be paid, my lords, in preference and priority over all other depositors. My lord, my very humble submission, my lords, is that under the scheme of the act, my lord, I had to go before the Honorable Special Court, and under the district, my lord, directions of the Honorable Special Court, I shall have to, my lord, disburse the amount in an equitable manner to all the eligible depositors.
So where is the special court now?
Lord, the special court, my lords, is in Bangalore, my lords. By the concurrence of the Honorable Chief Justice, the state government, my lords, has constituted a special court. In fact, my lords, the party in person petitioner had approached the Honorable Special Court with the very same relief that is now being sought in the instant petition. The Honorable Special Court, my lords, has been pleased to pass an order that no such priority can be given. Lord, as a matter of fact, my lords, any orders passed by the special court shall have to be challenged before, my lords, the division bench in a first appeal under section 16. But my lords, I am also a state. I will not stand on hyper technicalities. But my lords, the prayer that is now being sought, that dehorse the non-payment to others, I have to be paid in preference over all other depositors. Lords, in my very humble submission, my lords, is not sustainable, my lords.
My leadership, I will place only the truth. With 2 minutes I will explain. Because I'm an experienced man in the last 10 years. I'm contesting Supreme Court, High Court, Mumbai last. I am MPID Act, like KPI Act in Andhra Pradesh. So only page number 7, this honorable court passed the order in contempt petition and directed me. That time money was not available in the High Court also and special court. So therefore, I request the court, all property orders, some properties are sold, 4 crores are deposited. Court directed me, Mr. Desai, you file any final order, we will remove, modify. Lordship, don't worry, I allowed to file the affidavit for disbursement of money. Kindly give direction to the competent authority and special court. This order is 7. Now go to the 9th page, page number 9. It's very important. After that procedure I followed, I filed a miscellaneous application in special court along with this affidavit 7. Kindly see there. 7/9/23, the affidavit. All original, everything I enclosed. I argue the matter in the special court. And this competent authority, they not, because they are having, I don't know what is their problem. From the beginning, they are not follow the order of this court as well as special court, Belgaum. That time, special court was Belgaum, 3 years. I done very fastly minimum because I am experienced man. Therefore, investors should all get the money. Therefore, immediately all property attached by the special court. Special court directed Mr. Desai. Still, competent authority not obeying the order because they are not appear in the court. 3 years they not appear. Then I filed the writ petition in this honorable court as per direction of this court. Competent authority appointed, but never appear in this court also as in Belgavi. Then the special court in 22 was appointed. The Belgaum special court transferred to Bengaluru. Then this court allowed me, you go there and file your similar affidavit along with a miscellaneous application.
What happened to that? Where is that order?
Huh?
Where is that order of the special court? Have you filed in this?
No, that I had done the procedure, everything. Special court has, even if you want.
So what happens is, if the special court rejects your request.
No, I agree. Even High Court, this contempt petition, given direction to special court, I appear, I argue the matter, and special court has taken all the record on the court. Everything. I argue the matter. 3 days I was in the special court. Only requested, Lordship, kindly see the Supreme Court judgment, this court judgment, last 10 years, everything. I fully satisfy the court. But it is investor money. Kindly see my age is 80 years. I'm coming all the way. And what is the problem? And all 2,93,000 crores of property I have given the detail personally, along with the help of this court and special court Belgavi. Very active. All police officers, they called the meeting. They told me, you don't worry, we'll attach all property and we'll produce before the special court. And special court has attached all the things, but in between the court was transferred to Bengaluru. It is inconvenient. As per even I argue this matter, that notification, everything, even that notification also they have misguided me. 3 notification by Revenue Department. First Revenue Department, they are issued, every district there should be a special court and competent authority. Then they have changed it. Then again they have modified. For this I have filed 3 writ petitions in this court. So, sir, this is what is this going on? Law officer, all these things, they misguided the Chief Justice. Because this is the first case. My leadership, because Bangalore is long here. Otherwise, I would have appeared before Chief Justice. I know the experience. In Mumbai High Court, I have done same thing. Because it is the investor money, even Supreme Court has directed. Nobody, not a single investor should have deprived for his hard-earned money. I am 80 years old. 50 years saving I invested, sir. I am from Belgaum properly, but I was 50 years on the service in Mumbai. So therefore, after that I filed this. The only thing is that you request the competent authority, even Buddhya also, you cooperate with the investor. Don't defraud them. It is a very bad thing. It will come like a boomerang, because we should not harass to anybody. And even
When was the special court constituted?
My lords,
When was the special court constituted?
2021, my lords. 2021, my lords, the Honorable Special Court has been constituted, my lords.
So from 2021 till 2026, nothing is happening.
My lords, Special Court, my lords, has considered, we have auctioned the properties, my lord. We have called for the claim applications. My lord, there's a direction by the Honorable High Court that the date should be extended for considering the claim applications because we had rejected some of them, my lords. So now the claim applications is going on. In fact, my lord, the petitioner has not even filed a claim application.
No, he's a senior citizen. Why can't his claim be considered?
My lords, in all humility, my lord, there are several depositors who are more aged than him. Some of them, my lords, have unfortunately breathed their last. But my lord, there is no provision under the law that one depositor either.
Why is it taking such a long time? 21 to 26.
My lords, some matters are pending before the Honorable High Court, my lords, and the party in person says that he has given a list of properties that could be attached. I only wish, my lord, it is as easy as that. We have been contesting the matters tooth and nail. My lords, the Honorable Special Court in some matters, my lords, has been pleased to confirm, my lords, the attachment, and that has been stayed, my lords, in the Honorable High Court.
So far?
My lords?
No amount is disbursed so far to anybody, to any of the.
No, please, no, because the claim applications are now being considered, my lord. In fact, the last date was over, my lords, but my lords bench, the coordinate bench of my lords, has directed us to reconsider some of the claim applications. So unless, my lords, we consider all the claim applications, my lords, we will not be in a position to distribute the money in an equitable manner. My lords may indicate the date. Well, it's about 4 crores is, my lords, I'm going to understand, but I'll file an affidavit exactly, my lord, how much money we have. I'll file the affidavit, my lords.
My ladyship.
I will not rebut every argument that the party in person is doing. I can understand, my lord.
Process needs to be the speed up the process.
Please, my lord, unfortunately, my lord, may very humbly submit. Even if at all the process is complete, the petitioner will not be eligible. My lords, I have filled up the form and sent my officer to his house to give some details. Lord, the petitioner says, I will get the money only from the court. Lord, if he doesn't fill the application forms, if he doesn't give us the details that we have done, we have filled up his own form, my lords, except for his signature and some details that only he can have. We have filled up the form.
No, that I will clear. Whatever she is telling, I will clear. First of all, see page number 9. It is very important. In the final order of contempt petition, the petitioner requests, amongst other, for expedition of the business of the amount received from sale of property must necessarily.
Please understand.
No.
Court understands your problem and what is the relief you are seeking.
No.
But please understand, like you can't come before in a writ court and say that give a direction to the special court to disperse my amount. That can't be done. Not only you, there are so many depositors who are there whose dispute or whose claim is being considered by the court.
No, I understood. Only this order, final order, if you go through
There
this.
is no final order.
No.
No writ court.
This
can direct
court
the special
only,
court to do
this court
something.
only give direction to them. His party in person, in 10 years, he is contesting alone. Not a single person has helped him. So his money should be paid on the receipt.
Then you file a contempt for that.
Another important, Lordship, kindly see the KPI Act, there is no provision of banking transaction. There is a cash also included. In Mumbai High Court also, cash it is. All Supreme Court have presented.
Whatever it is, your remedy is before the special court. Special court rejected your request.
No, rejected means what? Rejected because pro rata. That time it is beginning.
If at all any order is passed, your remedy is not before this court.
The High Court has directed special court as well as the competent authority.
High Court has
The request may be considered.
Division bench has passed to file a contempt for the division bench order, because what is possible, what this court can do with the powers vested with this court, the court can do. But we can't have a solution for every problem of every
only
person.
2 minutes, I will.
Yes.
So in page number 9, I have filed the miscellaneous application in the special court along with the affidavit dated 7/9/23 with all fixed deposit 96, everything enclosed. I placed before the court, argue the matter 3 days, fully satisfied the court. And court has taken everything. No, 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 one more. One more. When the matter,
Depositors.
only just
Just
kindly,
because you have come to
kindly
High
hear
Court, we
me.
can't consider your case.
Now, when the matter is in the contempt petition passed the order. Contempt is whatever I have given in the special court's miscellaneous application along with the affidavit of FDR. They are misguided, they are not produced in the court in spite of the order of this court. This is a very grave. FDR, fixed deposit receipt. 3 copies I served to one Mr. Budhiyar, Competent Authority, Special Court, and real truth I argue the matter before Special Court also. Therefore, High Court also heard my say. High Court has
I can't pass any order. If you want, I can give the reasoning. why
only,
I can't,
only to,
or else
only,
I'll adjourn the matter.
I just
can't grant
humble
any-
prayer, kindly give direction to submit the status report in this court. Status report. How many properties are sold?
This is matter in the month of March. Yes, next.
Seal number 8.
Madam, next date,
March.
28.
March 4th.
No, madam, next week I am coming, 28
If you
January.
come, what is going to happen? Because I am not inclined to grant any order in this.
No, what is, the-
Petition is not maintained.
what is the date now? What is the date?
March 4th.
March 4?
Yes.
It will be too long, madam.
I can pass orders today also.
At
But you are
least,
not- I
at
don't
least you
want to discuss your writ petition,
give
that's why I'm
direction
granting
to
your
produce,
time.
because every time they used to give me a status report, this time they are not given.
You are wasting your time. In this case, here, nothing will happen. You have to go before the special court or question an order that is passed by the special court. You will not get any relief. That's what I'm saying. If you're not convinced, I'll adjourn the matter, nothing else. Well, this is matter on 4th of March.
4th March.
Fourth.
Okay.
Yes,
Seal number 8. Anil Kumar H.
Please, I filed memo for withdrawal, my lords, due to some
Give
technical
that
defect,
withdrawal
my
memo.
lords.
With a liberty to file a suit.
Please, my lords.
The memo is filed seeking to withdraw the writ petition with a liberty to file the suit. Memo is taken on record. The petition is permitted, the petition is dismissed as withdrawn with a liberty to file a suit as per the Limitation Act.
Acha, please.
Seal number 9.
Please, for petitioner, ma'am, I served the copy, my lord, through hand summons to the contesting respondent, my lord. The 4 to 7 are, they are not contesting, my lord. Even though trial court, they are not contesting. They are the formal party, my lord. I served the memo.
None appears to the petitioner, neither process fee is paid. As a final chance to pay the process fee for issuance of notice to respondent 1 to 7.
My lord, I served the copy through hand summons as per this honorable court.
Where is
my
the
lord.
order of hand summons?
Last occasion, lordship is given the direction. 11/12/2025.
So, to whom you have served?
Trial court advocate, my lord. I
No,
served.
no, which respondent?
Respondent 1 to 3, my lord. They are the contesting respondent, my lord.
1 to,
3, my lord.
where is the memo?
Memo is
A
there.
memo is filed stating that the hand summons are served to the council for respondent 1, 2,
3.
and 3. And what about the memo to these other respondents? That they are not,
please.
notice to them is not necessary.
No. They are,
The memo,
please, I'll give it, my lord. Sorry. Please, sorry.
why it should be
Please,
in
please,
different
dispense
steps?
memo is there.
A memo is filed stating that respondent number 4 to 7 are formal parties and they are not contesting the OS, and hence notice to them is not necessary. Accordingly, memo is taken on record and notice to 4 to 7 is dispensed with. Yes,
Please.
argue.
Week's accommodation.
This is matter in the month of March.
Interim order, actually.
Huh?
Interim, there is an interim order, my lord.
Then you argue.
I have not gone
This
through.
is matter Without going through that, you filed it and you got an interim order.
I'm sorry, my lord.
This is the matter on 10th February.
Please, please.
Yes. Interim order only granted is extended till then. Yes.
Seal number 10,
My lord,
R.K. Kulkarni.
my submission is in respect of order dated 9/1/2026 has been challenged. It is a typewritten portion. So other portion which are there in the order sheet are not relevant. I am not relying on
Office
that.
objection at serial number 24.
9/1 and 20
Office objection.
Where is?
24, serial number 24. The objection at 24.
All party. Not great party.
10.
Impugned order is of 9/1/2026. It is in typed portion.
No, where is office objection? As there is no claim against JDR number 2 and 3 with trial court or not, they should be made as a parties, then you should, there should be a note below. You cannot, you can't,
My lord, only the decree holder has been made a party. Because
when,
it is,
when a particular order is challenged, all the parties,
that is 9/1,
where is the order?
9/1, my lord. Without their, yes, my lord, page number
Of
42,
impugned
page
order.
number 42. Without there being any application by the decree holder, the trial court has proceeded to pass an order of attachment of movables.
In the EP, whoever are the parties, they should be parties to this writ petition. If you are not, according to you, so and so is not a necessary party, you will give a note below saying that these parties are not necessary for this application.
I have made the note before the cost title itself, my lord, in the writ petition. In the
see.
writ petition itself, I have made the,
Where is that? You have made only the decree holder.
yes, my lord, because other two are the, along with me, the judgment debtors.
They should be shown, Mr. Counsel, that's what I'm saying.
I have made the note, my lord, as there is no claim against the JDR number 2 and 3 before the trial court,
This you
are
should-
not made as
this
the
you should
parties.
This you should do after showing them as parties, not without making them parties. The office objection is upheld, the petition shall comply with the same within a week. Yes, next.
Seal number 11, R.K. Kulkarni.
It is also for the same reason, my lord, because only the
Office objection is upheld, shall comply within a week. Yes, next.
28, my lord.
Whenever, once the office objection is complied, this is the matter.
Hearing on I, seal number 12.
Please. Lordship. Dismiss for my lordship, depart my lordship, dismiss for depart my lord. And I filed application for recalling of power.
1011 days
Please. Recently,
from the delay.
my lordship, I have filed
Your filing wakalat will not change the nature. We can't condone the delay of 1011 days. What is the reason stated? Please.
Earlier
look at,
advocate,
the IA.
earlier advocate has not intimated to the parties, my lordship.
Where is that? Where is the condemnation delay petition?
Para number 3 of the affidavit, my lordship.
Please read.
Please, my lordship. The above said petition was listed before this honorable court. Objection on 2/2023. On that day, this honorable court was pleased to pass an conditional order that if the not complied by the petitioner, petitions dismissed without reference to bench because of earlier counsel has not cooperated for the compliance. We have asked my counsel that why you have not complied, sir. And he stated you were not provided information at that time. The honorable court dismissed the non-compliance about order.
Entire affidavit, not even a whisper about when did you receive the information from the, when did your client has received it? When did he come to know? When did you file? Nothing. Just
I will file better affidavit, my lordship.
then counsel for the petition seeks time for filing a better affidavit. Let's just matter after 4 weeks. Yes.
Obliged, my lordship.
Bill number 30. Thegde.
Please, my lord.
Yes,
My lord, I
order.
filed application for withdrawal of the writ petition with a liberty to urge all contention, my lord, and direct the trial court to dispose of the suit in a time-bound manner, my lord. original
In a
list.
withdrawal petition,
Alla,
all these orders will be passed by the court.
ಅದಕ್ಕಾಗಿ I filed.
Cannot pass in a withdrawal petition, the court will not direct the trial court to dispose of the matter.
My lord, exceptional circumstances, my lord, under Article 227, my lord. My lord,
The withdrawal petition, what
Allah,
is the
Allah,
227?
I stated the special circum. My lord,
If you want such an order, argue the matter. In the writ petition, I can pass, not on a withdrawal petition.
my lord, my submission is that, my lord. My lord, I can argue, my lord, but the notice is not complete, my lord. But my submission is that, my lord, suit is pending since from 2014.
You are an advocate.
Yes, yes.
So you can't make such a request which the court cannot do. While dismissing, while giving a liberty to withdraw, will the court pass any further orders?
My
Saying
lord,
that dispose of the writ petition.
my lord, I am seeking liberty, my lord. I am seeking liberty to urge all contention before the.
Only to that we can grant.
My lord, as expeditiously as possible, my lord. That is sufficient.
The present petition is filed seeking to withdraw the writ petition with the liberty to raise all the contentions before the trial court. Accordingly, the memo is taken on record.
My lord,
And petition is permitted to, and the writ petition is dismissed as withdrawn, and the petition is at liberty to raise all these grounds before the trial.
My lord, application is filed. Application, memo, application is filed.
IA 125 is filed.
My lord, as expeditiously. Next
Yes,
is,
next.
next is same.
Yes, next.
Same.
Same.
Please.
15.
Please.
Your Lordship, 15, yesterday petitioner has filed a withdrawal of the memo, Your Lordship. Yesterday petitioner has filed a withdrawal of the memo. And I have submitted, Your Lordship, I will inquire and Your Lordship, it may be withdrawn, Your Lordship. Please.
The memo is filed. Seeking to withdraw the, where is that memo?
IA 1 of 26, Your Lordship,
IA?
for dismissal of petition.
The memo is filed. An IA is filed, IA 125 seeking to, in the earlier petition also, that's an IA. IA number 125 is filed seeking to withdraw the writ petition. It is stated that the writ petition has become infructuous, and the petitioners want to withdraw the writ petition. Accordingly, IA number 126 is allowed, and the writ petition is dismissed as withdrawn.
Please.
Yes, next.
Number 16. Category 16.
Recall of BNP, non-compliance first time.
26/11/2024 order, recall, it's 376 days delay, for that a memo.
To produce the deposit memo, that is only one objection. I deposited the amount 4,53,490.
I number 1 of 26. I number 1 of 26 is filed to condone the delay of 376 days in filing the recalling application. An order was passed by coordinate bench of this court that the office objections to be complied with in a week, failing which the approach shall automatically stand without further reference to the court. Then counsel appearing for the appellant suppressed that due to oversight, they could not comply with the objection, and the appeal is dismissed for non-compliance with the same. It is submitted that as per the orders passed, they have deposited the amount of, stay is there in this.
I deposited 4,53,498 on 16/12/24 and before tribunal.
So and so is a deposited so and so. Accordingly, considering the reasons stated, I number 1 of 26 is allowed by condoning the delay of I number 1 of 26 is allowed delay of 376 days in filing the application, recalling the application is condoned. Consequently, I number 2 of 26 is allowed, and the order dated 26/11/2024 is I number 2 of 2026 is recalled, and the appeal is restored to file. The petition, office objections are still there.
I may be permitted to comply the office objection.
Office
Within
objections
10 days, I
within-
will comply.
Within a week, or else the appeal shall stand dismissed. Yes.
Serial number 17, Vijay Kumar Kothi.
Appear for claimants, my lord. There
I
is a
number
6 day
124 is
days
filed to
delay for
condone the delay of 67 days in filing the appeal. Condone. Admit final hearing PCR.
Only small point involved, my lord.
PCR.
This is a wife and minor daughter filed claim petition for enhancement, my lord. There
It's
is
a case of death.
It is case of death, my lord.
Tomorrow. Let it come tomorrow.
Please.
Yes, 19.
Serial number 18, Prashant Matapati, CBMD.
Lord claimants, my lord,
Of 2024 to condone the delay of 199 days on condition, the usual order. Admit final hearing PCR. Yes, 19.
PCR. Serial number 19, SM Kalwad.
It's an appeal by the beneficiary, my lord. Challenging the award of the reference court, wherein, my lord, the reference application filed by the claimant itself is barred by time, my lord, as per section 64(1), my lord, sub first proviso. He is supposed to make an application within 30 days after the receipt of the award notice. Here in this case, my lord, he has filed it after 30 days, not filed a reference application within
The
30.
order 50% deposit.
Please, much.
It is submitted that the claim petition is
Is barred by time
claim petition.
in
is
violation of
barred by
section
limitation.
64(1) of the Act.
Barred by limitation, and without considering the same, the court has granted the compensation. Same day shall be stay of all for the proceedings on the condition that 50% of the amount shall be deposited and the same shall be kept in fixed deposit. There are the usual orders in LAs. Same order. You take notice for?
For
Respondent number 1, mil.
Respondent number 1, HCGP takes notice and issue notice to the second respondent.
Please, there are 5 respondents, my lord.
Issue a notice to respondents 2 to
5, my lord.
2 to 5. Yes.
Prashant Matapati. Prashant Matapati.
serial number 20, my lords, I filed for enhancement, and 20.1, my lords, filed by the insurance.
Case of death or injury.
Injury, my lord, the party is also present, my lord. He's amputated, my lord, right leg is, my lord.
In fact, on the last occasion, this honorable court is pleased to observe, there is a order also mentioned in the cost list, my lord. On 26/11/2025, this honorable court has made observation that there is no material placed on record to show that claimant continues to be under medication and that because of the injuries sustained in the accident, the amputation of right leg has happened. This will be taken up for final disposal itself, my lord.
Please, my lord.
Right, matter will be
When?
after some 3 weeks.
This is the matter on 24th Saturday. Yes, next.
24.
24, my lord, the 24, my lord,
This is February.
Saturday.
This is a matter on 12th February.
My lord, some urgency, my lord, 24th, my lord.
24th of this month.
28th, my lord.
Second
Not
week of,
early, it's not possible. This is a matter on 2nd February.
Please, my
my
lord.
lord, second week of February, my lord.
My lord, there is
They have the urgency.
his
Told
legs,
the
my lord,
director
for a
of-
moment. He is also present, my lord.
Yes.
Complete his leg is, my lord, gone. He was amputated.
Then third, my lord, third.
3rd February.
Third.
Yes, 21.
21.
I appear for the claimant.
The came.
Delay of 132 days.
Is condoned on condition.
And other 2 matters are to be listed, Your Lordship.
Post of final hearing, call for the TCR, list along with so and so. Yes, 22.
Serial number 22.
Insurance company appeal, my lord, sir. Insurance company appeal, my lords. ECA matter, my lords. My lord, challenging the liability, my lords.
Yes.
My lords. The respondent, my lords, filed the complaint after the extent of 4 months, my lords.
My lords, I am a proxy counsel, my lords, operating on behalf of Ashok Naik, my lords. Delay may be condoned, my lords.
They also prepared appeal, my lords.
125 is filed to condone the delay of 264 days. Condoned because this is company, no condition. Next, I number 125 is filed to condone the delay of 108 days. This is condoned. This also without any condition because they already their delay is there.
My lords, ECA matter, my lords, already award amount deposited before the tribunal, my lords.
It is submitted in 22 MFA in 22. It is submitted that already the amount is deposited. The claim petition is filed with a delay. Considering the same, they shall be stay of all further proceedings on the, stay of all further proceedings.
My lords, call for TCR. Call for TCR.
Already said.
Please,
Yes,
please.
next.
Please, sir.
Please, members.
Seal number 23. Seal number 23. Arunal will open.
No representation is this
Jadhav?
matter in the month of March.
Seal number 24. By Lakshmika.
Lordships, in this, I'm appearing for the appellant, your lordships. In this, claim petition has been dismissed, your lordships.
Why did you move a memo? Tell the court, why did you move a memo if the claim petition is dismissed? Notice is also not audited. Why should you move a memo for this? Everybody is abusing the permission that is granted by the court.
We apologize, your lordship.
Notice to the respondent.
Sure. Seal number 25. By
All the
Lakshmika.
matters, just like that you moved a memo. Notice to the respondents.
Seal number 26.
Your lordship, in 26 companies also preferred appeal, your lordships. It may be.
What's wrong with so and so?
Long. Number.
From next time I will dismiss without a reason if a memos are moved like this.
Seal number 27.
I apologize, your lordships.
Priti Shashank.
My lords, insurance company appeal, my lords, challenging the on quantum.
It's a case of death or injury.
Death, my lords.
How much is granted?
My lords, 28 lakh 76,533, my lords.
According to you, what is the admitted amount?
My lords, the future prospect added 40%, my lord. It is not correct, my lords. 25%.
It is submitted that the court had considered 40% to future prospects, and the appellant is not, and the claimant is not entitled. And questioning the same, the insurance company is before this court. They shall be stay, considering the submission, they shall be stay on the condition that they shall deposit 20 lakhs. And on such deposit, the respondents are at liberty to withdraw as per the conditions laid down in the award.
Please, ma'am. My lords, before tribunal, we deposited, my lords.
Wherever you want, you can
Please,
deposit.
please, ma'am. Please, ma'am.
Yes.
Seal number 28. GN Raichur.
I am for the appellant, my lord. Amount has been deposited. I will produce the receipt, my lord, within a week.
By 3rd of February, if the proof of deposit is not filed.
Definitely, madam.
The
I will not,
petition
and I will take steps to R2, R1 and R2. No, not in station. They are not in address.
Seal number 29. Priti Shashank.
Insurance company appeal, my lords, challenging the liability, my lords. That time of accident, my lords, driver had no DL, my lords.
It is submitted with the response for the appellant that there is no DL to the, when did the accident take place?
My lords, accident occurred on 31/12/2022, my lords.
20?
22, my lords.
Then how does it matter if there is a DL or not?
My lords.
It doesn't matter. If there is no DL, pay and recover will apply.
Please, my lord.
How much is the amount?
My lords, amount,
Case
my
of
lords,
death or injury.
my lords, is minor death, my lords. 5 lakh,
How much is granted?
7 lakh 40,000, my lords.
The insurance company shall deposit. It is submitted that there is no driving license. This accident has happened in the year 2022, that is before the amendment. Considering the submission, there shall be stay of all further proceedings on the condition that the respondent shall, the appellant shall deposit 5 lakhs, and on such deposit, the respondents are at liberty to withdraw as
My
per the
lords,
conditions.
my lords, please,
laid down in the law.
challenging the liability, my lords.
Liability on the driving license is not a ground
My lords.
for an accident that has happened in the year 2022.
Next week, maybe dispose, my lords.
If you, then I will not grant stay also.
My lords.
Yes, next.
Seal number 30. CS Shutter.
This appeal is filed challenging the award passed by the tribunal, my lords. There's a delay of 300 days, my lords.
Why the memo is moved?
Please, my lords.
Why the memo is moved?
Memo is moved because we are seeking the stay, my lords. EP is filed, my lords, in the trial court.
With 303 days, you were happy. Suddenly you realize that you need a stay.
They have filed the EP, my lord. We are ready to deposit 50% of the amount, my lords.
It's a case of death or injury.
Yes, my lords. Death
Or injury.
Yes, my lords.
It's a case of death or injury.
Death, my lords.
How much is awarded?
6,25,000, 50,000 is awarded, my lords.
On
They had,
what ground you
they
are
had
before-
claimed,
what ground you are before this court?
my lords, our only, main ground is there's no eyewitness, my lords. Trial court only on the basis of the evidence of the petitioners before the tribunal have passed the award, my lords,
Require
without,
eyewitness
without
for an
evidence.
accident.
Please, my lords.
To require eyewitness.
There's no eyewitness, my lords, only on the basis of the evidence of the children, my lords.
No, in no MEC matters, there will be eyewitness to the accident.
Our contention is, my lord, she was also equally at fault, my lord, so she has not seen the road while crossing.
What evidence you have adduced? Let's see.
We have not produced any evidence, my
Then
lord.
why how can you say that there is a contributory negligence? It is submitted that there is no eyewitness to the accident. There is a contributory negligence on the part of the claimant. Considering the submission, they shall be stay on the condition that they shall deposit 5 lakhs. And on such deposit, the
It's 50% of the compensation.
The respondents are at liberty to withdraw the amount as per the conditions laid down in the award. Yes.
My lords, we may kindly be permitted to take issue notice on the counsel appearing for the respondents.
Issue notice to the respondent.
Please.
Number 31, Preeti Shashank.
Insurance company appeal, my lords, challenging the quantum as well as contributory negligence, my lords. That time of accident, my lords,
You are questioning the liability on what ground?
my lords, contributory negligence as well as quantum, my lords. That time of accident, my lords, deceased, there is no permit to, my lords, tribunal granted 40,69,000, my lords. 14,69,000.
14 lakhs.
Please, my lord.
It is submitted that there is a contributory negligence on the part of the claimant which was not considered by the tribunal. And what is the other ground?
Other one, my lords, as well as quantum, my lords.
The amount of compensation that is awarded is on the highest side, considering the same 10 lakhs, 4 weeks, conditions as per the order in the trial. Yes, next. 32.
Bill number 32, Gurudeva Gachinmat, T.N. Reddy, Reshma.
My lords, I'm for the cavator, my lords, in this matter. I'm seeking
Papers are not, sir.
week's time, my lords. Week's time, my lords.
No representation on behalf of the petitioner. The list is matter on 24th February.
Much
24.
Yes, 33.
Seal number 33, iske kayak mat.
Insurance company appeal only on quantum.
How
There
much
are
is
two
awarded?
wives,
How much is awarded?
21,84,000.
Your liability is
And our liability is 17 lakh.
17 lakhs.
17 lakh. Only deduction, 1/5 they are deducted, we are seeking 1/3.
Repeated amount is 17 lakhs.
Yes.
Land council appearing for the payments of this, instead of deducting 1/4.
1/5 deducted, 1/3 ಆಗ್ಬೇಕಾಗಿತ್ತು.
Instead of deducting 1/3, court had deducted 1/5. And the insurance company is on the question of contract. Considering the submission stay 17 lakhs on such deposit, same. They are entitled to withdraw as per the conditions laid down in the award. Notice to respondent. Yes.
Oh, bless.
Admission matter, seal number 34 and 35 adjourned, seal number 36. DM Patil, PS Shutter, Kavya.
Appearing for the appellant, my lord, seeking for enhancement of compensation. My lord, it's a case of amputation. My lord, tomorrow?
Tomorrow, my lord.
Tomorrow, my lord, tomorrow.
Please.
Yes, next.
Tomorrow.
Please.
Seal number 37 adjourned, seal number 38. Anjaneyam.
What, this is 36, what you call now? 36, yes. Yes.
Seal number 37 adjourned, seal number 38. Anjaneyam.
For the respondent.
I'm for the respondent, number 2.
Suresh.
It's coming up for admission.
It is dismissed against the insurance company.
Admit force of final hearing, call for 3CR. Yes, 39.
Seal number 39. Harishas Maigur.
My lords, it's a case of injury, my lords. The claim petition was dismissed, my lords, on the ground that,
Admit final hearing, 3CR. Yes, 40.
please, my lords.
Seal number 40. For Lakshmikant Reddy. For Lakshmikant Reddy.
A memo is moved, but there is no representation on behalf of the appellant. This is matter in the month of April. 41.
Seal number 41.
Claimant's appeal for enhancement.
It is claimant's appeal for enhancement.
Respondent.
Please.
Notice, issue notice.
Yes, 42.
Seal number 42. 42, Prashant Matapati.
What's claimants appeal for enhancement?
Notice.
What's R1 mallards may K Anand Kumar and R2 mallards NR Kuppelur, because another two matters mallards they have appeared.
No, that's why we'll post it along with the connected matter.
Please, please,
This
please,
is
ma'am.
matter along with the connected appeals.
Number good.
Give that. Next 43.
Still number 43.
Please, ma'am.
Yashmi Kattimane. 43.
No representation. This is matter in the month of March.
March.
Is 44.
44.
Company have been only a liability. There is no license. Happened lorry driver.
When the accident had happened. Accident, date of accident.
Date of accident. Twenty-three 11/20.
23. Then it doesn't matter. Pay and recover will apply.
No license at all.
Then also.
Apparently lorry driver.
Also pay and recover will.
And,
What is the amount granted?
4 lakh. And injury is only one fracture. However, disability not treated.
Half of the amount. Like
Yes.
counsel for the appellant insurance company submits that the driver of the offending vehicle is not having offending vehicle or the claimant. Offending driver. is
Offending
not having
driver.
driving license. And further. And what is the other ground?
And the disability taken as higher side.
And the disability was taken on the higher side, considering the same stay on 50% of the amount on such deposit, the respondent is at liberty to withdraw. Yes, 45.
Sorry, Millard. 43, Millard.
You were not there, what to do?
Yes, Millard.
Take that.
Held up in the court.
43.
Yes. Similar matter, Millard, in the already is Millard. In the
Similar order. Yes, so and so takes notice, same order. Yes, 45.
45, I am for the appellant, my lord. The appeal is by the insurance company challenging the involvement of the vehicle itself. Motorcycle, they themselves have fallen and implicated our mixer the vehicle.
And also for the appellant insurance company submits that they're questioning the involvement of the vehicle itself. And it is a self-fall, considering the same 50%. In this matter, no permission to withdraw. Yes, 46.
Bill number 46.
46.
Notice to respond, yes.
Yes, Lord.
Chippy Naik.
And
Yeah,
47
my
also.
lord, the response.
46, who appears?
Number 46.
I appear for one of the respondents, my lords. Respond number 1 and 2.
For the appellant, who appear?
Myself, I may.
In 46, sir.
Yeah, in 46, I may appear.
Yes,
In 47 also, Lordship.
yes.
So,
Both are connected?
yes, yes, Lordship.
Yes, let's see. What is the impugn order? Where is the impugn
Lordship,
order?
impugn order on page number 16, Lordship. Page number 16. Lordship, the lower court has not considered.
Page number?
Page number 16, Lordship, 16. Impugn order on page number 16.
You are the defendant or the plaintiff?
But
You are the defendant or the plaintiff?
I'm plaintiff, Lordship.
What is the suit for?
Lordship, suit for the declaration. Suit for the declaration, cancellation, permanent and mandatory injunction and damages, Lordship.
IA for?
I for Lordship order 13 and rule 1 and 2.
Came to be dismissed.
That is dismissed, Lordship.
Yes, please come to the reasoning part. Let us read. Let's read from paragraph number 7.
Lordship, page number?
Paragraph 7.
Paragraph 7 of the Lordship.
Para 7 of the impugned order.
Okay, paragraph 7. Yes, Lordship. Reasons.
Yes, read.
In order to get out of temporary injunction petition, parties have to show that the prima facie case in favor of the parents and convenience lies in favor. Further, they have shown that the temporary injunction order sought to granted, they will put the heavy repairable loss which cannot be compensated in terms of money before going merits of the case. I would like to discuss the prima facie case in balance of convenience injury. Prima facie means the court must satisfied with that the applicant has raised the bona fide dispute and needs to be investigation and the decision on merits, and fact there is a probability of the applicants being entitled to relief claimed by her, and the burden is on the plaintiff to prove that there is a prima facie in their favor While determining whether the prima facie case has been made out, relevant consideration is whether the evidence is read. It is possible to arrive at the conclusion its conclusion and not whether what is the only conclusion what could be arrived on evidence. 8. Balance of convenience before the granting injunction. The court must satisfy that the hardship likely to be caused to the applicant by refusing the injunction is greater than that likely to affect the opponent. If the weighing conflicting probabilities, the court is of opinion that the balance of convenience is in favor of the applicant, it must be granted injunction. Irreparable injury. The applicants must satisfy that the will suffer irreparable loss injury if the injunction is refused, as there is no other remedy by which they are protected from the consequences apparent the injury. The grant of injunction is an equitable relief and it can be exercised when the judicial intervention is necessary to protect the applicant, and injunction can be granted irreparable where there is no pecuniary standard measuring. By keeping all these cardinal principles in mind, I have gone through the pleading and documents produced by both the parties. Plaintiff has filed the present suit for the relief as many as 18 reliefs such as declaration to effect that the will alleged be executed by one Ramakrishna is null and void and the cancellation of the same. The alleged sale deeds executed by the defendant number 8 and 6 are null and void. Sale certificate issued by the bank authorities in favor of defendant number 2. The sale deed executed by the defendant number 2 in favor of defendant number 1 null and void. Further, the sale deed executed by the defendant number 8 in favor of the defendant number 7 is null and void, and also sought permanent injunction in nature of the for relief restraining the defendants for making any further reconstruction damaging the suit properties, and also sought for the mandatory injunction for restoring the plant, curry leaves, shrubs, custard apple, hibiscus plants, pimple trees, ashoka trees, coconut trees, berry trees in the suit properties, and the temple existed in the suit properties. The Karyawa temple, the idol of Karyawa in the original position, also sought to or damages. The plaintiff specifically pleaded the property where belonged to one Ramakrishna Govind Bongade. He died leaving behind his 7 sons, that is Satyananand, Brahmanand, Nityanand, Vivekanand, Nivrutti, Prahlad, and Manohar. The plaintiff is the daughter of 4th son Vivekanand. It is specifically pleaded that the Vivekanand and his family members are in the physical and actual possession of the suit property since from last 70 years. Defendant number 1 and 2 have started the construction and dug ground with the help of JCB along with the other persons to demolish the Bongade family temple of Karyawa, an idol Karyawa situated in the suit properties, and also cut the trees of Karyawa shrub, curry leaves, shrubs, custard apple, hibiscus plants, people, ashoka trees, coconut trees, berry tree. Hence, the plaintiff consent to file the present suit challenging the will alleged to be executed by the deceased Ramakrishna Govind Bongade dated 10/3/1986, and on the basis of said will on 31/1987, the names of the beneficiary under alleged will have been entered, and hence she is challenging the same. Upon perusal of the plaint averments itself, particularly para number 26, the plaint, it is specifically pleaded that the defendant number 8, that is Shri Nitin Manohar Bongade, had sold the property described in para number 4 to the defendant number 7, that is Srimati Kamlabai.
Yes, I have seen. You can make your submission.
Lordship, now this Bongade family temple is demolished first, and there is a illegal construction is going on. Firstly, without any permission, he has started the construction without any permission. He has dug the ground about the 40 feet without any permission. Then we have, sir, go through the records. Then we have find out that the will, impugn will. So we have challenged the will and others also. Same the time we have approached the court. Court has given the status quo and stopped the illegal construction now, which is totally illegal. After that, proceeding is going on. We have filed the order 39 rule 1 and 2 application. In that, this order is passed. Now by this order, see, merit is not discussed, but by this order now, what is the illegal construction is what he has did. Now by this order, now illegal construction is maybe legalized. So suppose the order is not in my favor or order is in other opposite favor, my whole suit may be infractitious, Lordship. The whole object of the suit may be infractitious, Lordship. So this is my main submission, Lordship. Now, second submission, Lordship, after he obtained the building permit, again he has started before 1 month. But in that there is a basement which is illegal and which is not part of the building permit also. That is with me, Lordship. So it is necessary to consider, Lordship. So by this order now, with the help of this order, illegal construction become legal construction. So there is no such kind of any document on record to show that the illegal construction is a legal construction. So my submission, Lordship, if the Honorable Court has set aside the order, then injustice may be stopped, Lordship. That is the ma'am. And what about my family temple, Lordship? That is a Karyawa temple. What about that is also one of the important issue. So Honorable Court may be set aside this order in the interest of justice, Lordship.
Yes. My lords.
What is your submission?
My lords, in this case, after appearance, now the plaintiffs have challenged the will of the year 1986. The plaintiffs have become owners of the property and have been in possession of the same since the year 2007. The present application has been filed in a suit where 18 reliefs are claimed, my lords. We don't know what will be the result of the suit, but after appearance, the plaintiffs, the present defendants have also taken the permission of the court and obtained permission and continued the construction. Rightly or wrongly, my lords, the plaintiffs have approached this court at a very belated stage. Already the construction has reached the roof level, my lords. Therefore, my lords, if the injunction is granted, greater hardship would be caused to the defendants. Therefore, the court below has rightly held that the plaintiffs are not entitled for the injunction and no prima facie case has been made out, my lords. 2 applications were filed and both applications have been rejected and both MFAs are before this honorable court. Other than that, another writ petition is also pending in this regard.
Other application.
No, so, Lordship, that is for the status.
Next MFA.
So that is against defendant number 2, Lordship.
Give that also.
That is
R7, Lordship.
7, Lordship 7. That is Kamalabai Shantilal Parmar, Lordship.
This is against defendant number 7. This is
7.
against defendant number 1 and 2.
1 and 2, yes, Lordship.
Please come. Agreed with orders passed in I number 2 and I number 3 in OS number 774 of 2023, dated 1st December 2025 by so and so. The plaintiff is before this court. As the plaintiff and the respondents are one and the same, this court is disposing of the 2 appeals by way of a common order. The plaintiff, the petition herein, had filed a suit seeking, where is the plaint? Plaint.
Yes, Lordship. That is on.
Seeking
That is on page number, Lordship, 27.
as many as seeking a declaration that the will dated 10/3/1986 in favor of defendant number 8, 10 and 11 is null and void. And also sought several reliefs to declare and also sought a declaration that the sale deeds that are executed are null and void, sought a permanent injunction against defendant number 1 and 2, restraining them from demolishing any part of the suit properties. Injunction, restraining them from creating third-party rights. An injunction against defendant number 7, mandatory injunction against defendant number 1 and 2, and also a direction to defendant number 1 and 2 to plant curry leaf shrubs and other trees. With all this, along with this, altogether, he has sought for 18 release from the court. IA number 1 is filed, IA number 3 is filed, seeking an injunction against defendant number 7, restraining him from demolishing any part of the sued property, which came to be dismissed, and against that, MFA number 10016 of 2016 is filed. Then IA number 2 is filed, seeking an injunction against defendant number 1 and 2, that came to be dismissed, and against that, MFA number 10015 is filed. It is a case of the plaintiff. It is a case of the plaintiff that the properties described in para number 3 and 3A are standing in the name of defendant number 1 and 2. Defendant number 1 and 2 are intending to construct the building in the sued properties to cause heavy loss to her by colluding with each other. Hence, the present application is filed. And it's a case of defendant number 1 and 2 that the plaintiff has no right over the property, and the property stands in the name of defendant number 1 and 2. The sued property is a property of defendant number 8. He sold the said property to defendant number 6 by registered sale deed dated 18/6/2012. Since the date of the purchase of the said property, they are in possession and enjoyment of the same. The defendant number 6 obtained the loan from State Bank of India, that is defendant number 3 to 5, by mortgaging the said property. The defendant number 6 has become the defaulter. Therefore, the defendant number 3 to 5 bank authorities have taken action against defendant number 6 by initiating the proceedings under the Surface Act and put the property in auction sale after issuing public notice. The said property was adjacent to the property of defendant number 2. Therefore, defendant number 2 purchased the said property in the auction, and a sale certificate was issued in favor of defendant number 2 on 13/10/2018, and a sale deed was registered on 19/12/2018, and the defendant number 2 was put in possession of the property. Since from the date of the purchase, the defendant number 2 was in possession of the property. As he was in need of money, he sold an area of 791.50 square feet out of CTS number 2491 to defendant number 1 to the southern side of the said property to another property of defendant number 9 is existed. It is stated that the defendant number 1 and 2 are trying to move a building application permission before the concerned authority. And due to the change of authorities, it is taking time. It is their case that the petitioner plaintiff is not entitled for any relief. It is not entitled for injunction. The trial court, by order impugned, had dismissed the both the applications that are filed by the plaintiff seeking injunction against defendant number 1 and 2 and defendant number 7. While dismissing both the applications, the court has observed that the bill was executed on 10/3/1986 On the basis of the will, the mutation has been effected on 31/1987. And the properties are bequeathed in favor of defendant number 8. And some of the properties, 2 properties, which are not the suit scheduled properties, have been bequeathed to defendant number 10 and 11, who are none other than the brothers of the plaintiff. The will contains 4 properties, wherein 2 properties have been given to defendant number 8, and another 2 properties are given to defendant number 10 and 11, who are the grandchildren of the testator. The petitioner plaintiff is challenging only with respect to the 2 properties which are given to defendant number 8. But the plaintiff challenging the entire will, but other 2 properties have not been shown as suit scheduled properties. The court has observed that the will is executed in the year 1986, and after the death of the testator, the properties have been mutated in favor of the beneficiaries. After lapse of more than 28 years, the plaintiff is challenging the alleged will. Except the plaintiff, none of the children or grandchildren have challenged the alleged will till today. The court observes that from the plaintiff, it suggests that plaintiff on one hand challenging the alleged will, and on the other hand claiming preemption rights over the suit properties. That itself suggests that the alleged will is acted upon, and as per the alleged will, the beneficiary under the will are residing in the properties bequeathed to them. If at all the plaintiff has right over the suit properties, she could have claimed the partition in all the suit properties, but without filing the proper suit against the proper suit. The present suit is filed against the defendants, seeking temporary injunction against defendant number 1 and 2. The beneficiary under the will has sold the properties to defendant number 6 and 7 way back in the year 2007 and 2012. And the bank also issued the surface proceedings. And in the surface proceedings, the defendant number 2 has become, the sale deed is executed in his favor. The court has come to the conclusion that plaintiff has not made out a prima facie case to grant temporary injunction against defendant number 1 and 2 and defendant number 7. The court also came to the conclusion that if the injunction is not granted, no irreparable loss would be caused to the plaintiff. But if the injunction is granted, irreparable loss would be caused to the defendant, and accordingly dismissed both the applications. Next file. When counsel appearing for the plaintiff submits that now, by virtue of the order that is passed by the trial court in dismissing the application that was filed seeking injunction, the illegal constructions that are raised by the defendants are in a way legalized, and with the under the guise of these orders, they are vigorously going forward with the construction. If they proceed with the construction, that would cause a lot of hardship to the petitioner. All petitioner plaintiff and all these aspects were not considered by the court in its proper perspective. Anything else?
Lordship, self-certificate is a mere document, Lordship. That not, self-certificate cannot transfer the ownership, Lordship.
Is that?
Self-certificate.
It is submitted that the sale certificate will not confer any right and title on defendant number 2.
Oh, yes.
And the court ought to have granted injunction as sought for by the petitioner plaintiff. Then counsel appearing for the defendant number
7. 1, 2, and 7.
1, 2.
One, this is, I think advocate is appear for 1 and 2, I think.
1, 2, and 7, my lords. There are 3 respondents.
Counsel appearing for defendant number 1, 2, and 7, who are the contesting defendants and against whom the plaintiff has sought for injunction, submits that the plaintiff has come before the court questioning a will that is executed in the year 1986.
86.
In the year 1986, it is submitted that from that day, the much water has flown and rights have accrued in favor of the parties, in favor of the defendants, and the defendants have started the construction. That construction also is almost on the verge of completion. At this stage, any injunction, and at this stage, an injunction cannot be, if the injunction is granted, it would cause hardship and prejudice to the rights of the defendants. Considering all these aspects, court had rightly dismissed the IA that's filed seeking injunction. It is submitted that there are no grounds to interfere with the order passed by the trial court. Next part. Having heard the counsels on either side, there is a material non-record. The plaintiff has filed the suit seeking declaration and also injunction, and also sought for the cancellation of the sale deeds. All the reliefs are 18 in number. Admittedly, the will that is sought to be set aside is in the year 1986. Right from 2012, the names of the parties are mutated and they have been in occupation of the property. There is no dispute in that regard. What is the entitlement of the petitioner? As rightly observed by the court, for grant of an injunction, temporary injunction, the plaintiff has to prove that he is a prima facie case. Balance of convenience is in their favor. And if the injunction is not granted, it would cause irreparable loss and hardship to the plaintiff. From the prayers that are sought and the pleadings of the petitioner could not make out a prima facie case for grant of injunction. In fact, considering the evidence, the court has rightly held that the balance of convenience and irreparable loss are in favor of the defendants, and rightly dismissed the IA that is filed for injunction, restraining the defendant number 1, 2, and 7. This court did not find any reasons to interfere with the well-considered order, and accordingly, both the appeals are dismissed.
Lordship, one submission. Whatever the illegal construction before the status quo, that become now legal as a Lordship.
That we can't help it. Yes.
So kindly consider Lordship that also.
Yes.
Yes, thank you.
Preliminary hearing matter, seal number 48, adjourned, seal number 49. 49, Raj Mardi. 49.
Yes.
For the petitioner, my lord. This case, my lord, that the petitioner is it is a NWKRT.
The relief, why a notice is not ordered till now? It never listed.
No, it is for the non-compliance of office objection, my
It's
lord.
already dismissed for non-prosecution on 18/11/2025.
And after that, we have filed a recalling application.
Let's see what is the relief that you're seeking.
In this case, my lord, that the respondent workman is working as a conductor in the petitioner corporation. On 26/3/2004, he has non-issuing a
Directly set aside the award. Yes. Who appears for the respondent?
respondent is a private party, my lord.
Notice to the respondent.
Please.
Seal number 50, MR Hiremath, Shivasayam Patil.
I seek for a week's accommodation.
Why?
Because the evidence is going there, my lord.
Huh?
Evidence is going there, my lord. Evidence, plaintiff's evidence is going there. Hence, if there is any conclusion by that evidence, we can.
No.
That
How
is the
does
ground
it
for.
matter?
This is the murder.
For matter, there is no stay. Why don't we
No,
hear
ma'am.
this matter?
We are the defendant, my lord. I filed application under 14A, my lord, 6, order 6, 14A, my lord, the change of the address, my lord. And that came to be rejected. Now, before this honorable court, that is a defendant, my lord.
That's what I'm saying.
Please.
There is no interim order in this.
No, 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 my lord.
It is an interlocutory order.
Please, my lord.
Why should the writ petition be pending here? That's what I'm saying.
Please, my lord.
No, the case is proceeding.
Yes, my lord. Yes, my lord.
So
Only
let's
thing is,
see.
my lord, evidence is going there.
What is the impugned order?
Please.
Let us see what is this impugned order. Page number.
Page number 96.
Page number 96, my lord. The its order portion starts from the page number 93, my lord.
Let's read the order.
Yes, my lord. That's the my lord. May I read, my lord? I number 36. Advocate for the defendant number 2 filed this application to change the name of address of defendant number 2 as per application. Counsel for the plaintiff filed the objection stating that the present application is not maintainable and prayed for to the dismiss the application. Heard on I number 36 during the argument, counsel for the defendant number 2 relied on the certain citation of Honorable High Court of Gujarat in order 11/2019. The present suit is filed for the relief of declaration and injunction. Now the present application is filed by the defendant number 2 to change his name and
How
address.
can you change your name? You can change his address, that's fine. How can you change your name? What is your name?
Actually, the plaintiff here, my lord, himself is declared that he is the Pitadipati of that Mata. Himself is declared as Mata.
He is claiming his rights through the will. So the plaintiff has filed a suit for declaration. Now changing his name in the past title, and he will put the name in all other things. So
No, let's see the cost.
Is this a,
Let's see the plaint.
yes, my lord. That is a plaint.
The name?
Page number 29.
It's a suit of 2010.
Please, my lord.
And you realized in 2020 that your name should be changed.
Please.
How can it be allowed?
Yes, because of it is. Yes. My name is Gursiddhaya Patraye Hiremat.
Present, the agreed by the orders passed in I number 36. In OS number 21 of 2010, dated.
My lord, my name is there as per my will, my lord. Will is there. My name is now is changed, my lord. Hence, I filed application.
When your name is changed, how it is changed?
No, the plaintiff is wrongly shown my name.
That what are you doing from 2010 to 2020?
I'm in the possession. I'm the Mata the Pitadipati. I'm the Pitadipati. But himself is declared that I'm the Pitadipati, that Mata.
Will is in question.
That is will in question, my lord. Will, but the plaintiff has not challenged that will, my lord. Without challenging the will, he himself is filed this suit for declaration, declared that he is the Pitadipati of the Mata. But will is there, my lord. Without challenging the will,
that is on the merits of the matter.
Yes, my lord.
That is on the merits of the matter.
Yes.
Now you say your name to be changed in 2020. Why?
Because after death of that, my lord, kindly see my application, my lord. That is it.
Where is that? Where is that petition?
Yes, my lord. It's page number 87, my lord.
What do you say?
I say that, my lord,
The respondent.
Madam, please.
What do you say?
My lord, he cannot, unless the trial commences, trial is held, and he is claiming on the basis of the will. The earlier Pitadipati has been expired. Now, if he changes his name and he puts his name in all over, he becomes self-acquired, Swamiji, only by name. Unless his will is proved, let him prove the will and succeed in the matter.
He is a defendant in the suit.
Please, ma'am. And I am claiming that.
You arrayed a particular person as a defendant.
And he expired, ma'am. Respond. Defendant number 1 expired.
And
He has executed will in favor of him. So on the basis of the will, he is claiming to be Pitadipati of Mat. So by changing his name in the suit or anything, he cannot become Pitadipati of Mat. He cannot be head of the Mat.
Then who will be the defendant? No, defendant is no more.
Please, ma'am.
No, no.
Now he has assumed the charge of earlier Swamiji. He is claiming to be Swamiji. So now if his name is changed, in all the records he will change his name.
No. What is the name of the defendant?
Please.
Originally, what is the name of the defendant?
Please, ma'am. He claims to be defendant number 2. His name is Gursidaya
No,
Patraya Hiramat.
he was not, earlier he was not the defendant.
He was the defendant, but he is claiming to be the head of the mutt on the basis of the will.
What
And
is your suit?
now,
for?
if you please see the affidavit,
What is the suit for?
suit for declaration
Declaration that?
and permanent injunction. And the prayer is regarding the mutt.
No, declaration that? What is the
That
declaration?
plaintiff is the Uttaradhikari or mutt of head of the
Uttaradhikari of the mutt.
mutt of.
And who is the first defendant?
This first defendant has expired earlier, Swamiji.
I know. So what was he? How did you array him as a first defendant?
He was claiming as the head of the mutt. So that there was a dispute regarding the head of
So
the
there
mutt.
was a dispute between you and the first defendant with who is the Uttaradhikari of that mutt?
Please, ma'am.
Then why this second defendant is arrayed on what capacity?
He claims to be the Pitadhikari on the basis of the will. That is under question. It has to be held.
Initially, you made him a second defendant, or later he was arrayed as a defendant?
No, initially he is arraigned. Initially he is arraigned. So now after his death, he enters into the shoes of the defendant number 1, and he claims to be the head of the mutt.
That's how it has to be, that array of party he should be
That is
shown
under
as
that is
Pitadhipati of, that is what he wants to
that
change.
is under dispute, and he wants to change his name.
How your name should be reflected in the cause title?
No, original my name is Gursidaya Patra Hirimat. And original Pitadhipati is died.
So you should be now.
I am the next Pitadhipati because of based on the will, who is made by that deceased person. So based on that will, I am the Matadhipati. Now my name would be.
No, it is a declaration by the court now, saying that you are the Matadhipati. Agreed with the orders passed in I number 36 in OS number 21 of 2010, dated 26/7/2024. The defendant is before this court by so and so. The defendant number 2 filed an application to change the name and address of defendant number 2 as per the application. The same was objected by the plaintiff, stating that the same is not maintainable, as the second defendant, relying on a will, alleged will executed by the defendant number 1, claims to be the Uttaradhikari of the mutt. The plaintiff is disputing the same. Unless and until the same is proved, the name cannot be changed. The court has observed that as per Rule 6, Order 6, Rule 14A of the CPC, every pleading shall be accompanied by a statement in prescribed form regarding the address of the party. As per sub-rule of this rule, from time to time, the address can be changed. This provision was inserted to facilitate and quicken service of the process of the court and to prevent any contention of non-service. And as per Order 6, Rule 14A of CPC, it is necessary to provide the changed address, but by way of application, defendant number 2 wants to change his name also. This is not permissible under Order 6, Rule 14A of CPC, because under this rule, only address of the parties can be changed from time to time. Hence, the application as filed by the defendant is not maintainable as per Order 6, Rule 14A2 of CPC, and accordingly, court had dismissed the application. When counsel appearing for the petitioner defendant submits that by virtue of the will, as a defendant is no more, he has become the Matadhipati of the said matter. As such, he wanted to change his name, and the court, without considering the same, had dismissed the application. When counsel appearing for the plaintiff submits that there is a dispute between the plaintiff and the defendant, who is the Uttaradhikari of the mutt. Now, basing on a will executed by defendant number 1 in favor of defendant number 2, the defendant number 2 wants to change his name and claim himself as the Uttaradhikari of that mutt. It is submitted that in a way, the petitioner, the defendant wants to be declared as a Uttaradhikari of the mutt, which cannot be permitted unless and until the pending suit is decided by the court and the court had rightly dismissed the petition. Next para. And they dismiss the petition, there are no grounds to interfere. Having heard the counsels on either side, there is the material on record. An application is filed under Order 6 Rule 14A2 of the CPC, seeking to change the address as well as the name. The court had, considering the amended rules, has held that the purpose of the amendment and the purport of Order 6 Rule 14A2 of CPC is to facilitate and quicken the service of the process and to inform the court if there is any change of address. But Order 6 Rule 14A2 does not permit the petitioner to change the name. And apart from that, in the factual matrix of the case, where the whole dispute is with regard to who is the Uttaradhikari of the mart, the petitioner, defendant cannot be permitted to change his name and to say that he is the Uttaradhikari of the mart. The considered opinion of the court had rightly considered and dismissed the application, and there are no grounds to interfere. Accordingly dismissed. This court has not expressed any opinion on the merits of the matter, and uninfluenced by the expression of this court, the court shall decide the application. Yes. Shall decide the suit on the merits of it. Yes.
Number 51, Somapur.
Do that.
Somapur.
There is no representation on behalf of the petitioner. List this matter for dismissal tomorrow on the top of the list. Yes.
Number 22, sorry, number 52.
This also on the top of the list tomorrow.
Tomorrow, top of.
For dismissal.
Still number 53. R.H. Changdi.
Please, my lord. Appearing for petitioner, my lord. Petitioner challenging the order passed by the trial court, my lord, on I number 3, filed under Order 16, Rule 1 and 2, summoning for the production of documents, my lord. The suit was filed for the relief of permanent injunction, my lord, and relying up this plaintiff, my lord, relying upon the registered lease deed, my lord. The respondents are trying to evict the petitioners, my lord, and he has produced the Xerox copy of the lease agreement, my lord. At the time of evidence, at the time of marking of the documents, he is required to summon original document which is in the custody of respondents, my lord.
Please come to the impugned order.
Please, my lord. At annexure E, my lord.
Start reading from paragraph 7.
Please. The plaintiff has filed the suit for permanent injunction against the defendants. The plaintiff has filed the above application at the stage of further chief examination of PW1. No doubt the order 16 of CPC indicates the parties to the suit may be required, and a party may be entitled to require any other party of the suit to give evidence or to produce the documents. The expression any other party thereto is indicative of the parties to the suit, or say the parties other than summoning the parties, which may include the opposite parties. In other words, the plaintiff may summon the defendant as witness and require him to produce the document. Similarly, the defendant may summon the plaintiff. The Honorable High Court of Karnataka in Syed Yassin vs. Syed Shah Mohammad Hussein's case made observation that it is open to the court if in its opinion summoning of the other parties or opponent is likely to result in abuse of process of the court, it may refuse as well. It is also no doubt true that ordinarily the practice calling upon the opposite party has been held and considered to be unhealthy practice, and also the division bench of the High Court of Karnataka in Mallan-Gowda versus so and so has observed the practice of calling upon the opposite party as a witness on.
What purpose you want the document?
My lord, we are relying on the lease deed, my lord. The respondents tried to evict the petitioners during the subsistence of the lease deed.
No, the defendants have accepted the tenancy.
My lord.
The defendants have accepted.
Please, my lord. But at the time,
you require the document.
at the time of evidence, my lord, during marking of the evidence, I need to mark those documents, my lord.
No. Why do you require to prove the admitted facts? They have already admitted that you are a tenant.
Please.
Why do you want the document to show that you are a tenant?
Please.
Yes, please come. agreed with the orders passed in I number 3, invoice number 70 of 2022 dated 30/8/2023. The plaintiff is before this, by so and so. The plaintiff is before this court. The plaintiff is a tenant in the suit scheduled property. And when the defendant wanted to evict the plaintiff, he had filed a suit for permanent injunction. According to the defendant, plaintiff is a tenant and a lease deed was executed. The present IA is filed to summon the defendant, to summon the documents, the original lease deed dated 3/7/2020 and lease agreement dated 1/9/2021. The tribunal, the trial court by order impugned had dismissed the said application. While dismissing the application, the court has observed that in the present case in hand, the plaintiff wants to summon the defendant to produce a original rent agreement and documents relating to assessment register or documents relating to construction of the suit premises. If the plaintiff wants to produce the documents, he would have obtained certified copies of the said document. In the present case, the defendants have clearly admitted in their written statement regarding the tenancy of the plaintiff in the suit premises. The court observes that it is well settled law that admitted facts need not be proved. Hence, in the present case, the question of proving the tenancy does not arise. When that is the case, the question of summoning those documents are not necessary. And also, ordinarily the practice of calling the opposite party as a witness is an unhealthy practice. Hence, the court has dismissed the application. When counsel appearing for the petitioner submits that he wants to mark this document during the course of evidence, and for marking the said document, he has filed this application. The court, without considering all these aspects, has dismissed the petition. If this application is allowed, no prejudice would be caused to the defendant. Next paragraph. Having heard the counsel for the petitioner, there is a material on record. The petitioner wants to call for the defendant as a witness and also summon the documents in support of his case that he is a tenant. And according to him, to establish his case, he requires to mark these documents. The defendant in the written statement has categorically admitted that the plaintiff is the tenant. When that is the admitted fact, the question of plaintiff proving the same would not arise. And for proving the same, he doesn't require to call for the defendant as a witness and call for this documents. The trial court has rightly considered and dismissed the IA, and this court finds no reasons to interfere. Accordingly dismissed.
Please.
This 55.
Number 54. G. N. Raichur.
My lord, this is by the insurance company challenging the condonation of delay as per 166(3), my lord.
No. What is this? AC means? Oh, this is an interlocutory application.
Interlocutory.
Yes.
166(3), mandatory, no application shall to be entertained. Shall word has been used as a shall. It is before the Supreme Court now, my lord. The finding.
With regard to the limitation under the MB Act, there are 3 matters which are directed to be listed of one advocate, insurance advocate. When are they coming? We'll give a date for this. You ask him, one insurance advocate appears. He has 3 matters. I've given a date. Maybe Tuesday, Monday or Tuesday. Look at it, post this matter along with that. Yes, next.
27.
Yes.
27. Seal number 55.
Hello, serial number 55, my lord. I have filed IA for application for my lord. Memo for withdrawal.
Yes, take that.
As the facts are concerned, my lord.
No, let's select the withdrawal memo.
Lord's memo is filed in the counter. That is my office copy. Please.
What is the alternative remedy available to you?
My lords, now the bank account is freezed. A complaint has been filed. So, my lord, I'll approach the magistrate under section 457.
If the present writ petition is filed seeking to withdraw the petition or to avail the appropriate alternative remedy, the memo is taken on record and writ petition is dismissed as withdrawn with the liberty to avail the appropriate.
Please.
Yes, please.
Seal number 56. CS Shekhar.
Impleading application of the petitioners, your lordship, hearing has been rejected. Respondent number 1 is the plaintiff, who has filed the suit for specific performance against the respondent number 2, who is the father of the present plaintiff, present petitioners, your lordship.
No. Respondent number 1 is a plaintiff.
Please, your
Suit is
lordship.
for specific performance.
Please, your lordship.
You are a third party.
I'm the son of the respondent number 2. My father has executed an agreement of sale with the plaintiff, your lordship. My contention is suit schedule property are the joint ancestral property, your lordship. Being the children, have the right and title over the suit schedule property. We have filed the application for impleading. Same has been rejected by the trial court. Your lordship may kindly see the impugned order at annexure EF.
You have sought for a partition.
Please, your lordship, on that.
You can file an independent suit. Now, in the suit for specific
will-
performance, court will decide only the dispute between the contracting parties.
It will create a multiplicity of the proceeding, your lordship, and there are every
Because
chances
the
that
nature of a partition suit and the nature of this are altogether different.
there are every chances.
No, according to the defendant, it is his self-acquired property. Now you are
He
saying.
has not taken that contention that there is a self-acquired property by even by the defendant.
Having executed agreement of sale, he will anyhow, he will sell with you.
There is,
Let us see the order. Because
Please, your lordship.
we can't expand the scope of a
Your-
specific performance suit.
Your lordship, there are every
Now, the court
chances
will
that
decide, the court will decide the rights of the parties in a specific performance suit. You could have as well filed a suit for partition, and as well you could have made this person as a respondent.
Please, your lordship, there are every chances that the defendant, my father and the plaintiff might enter into and compromise, your lordship. Hence, your lordship also may kindly
let's
see
see
the
the order.
impugned order,
Number
page number 44, your lordship.
40?
44.
Yes.
The facts from the another case has been depicted in this present matter, your lordship. Lordship, I may permitted to read para number 2, your lordship.
That, yes.
Page number 44, impugned order. The plaintiff in his affidavit submits that he has filed the suit for the relief of declaration and permanent injunction against the defendant. Your lordship, this is a suit for specific performance. Trial. It is submitted that suit property is originally belonging to Srimati.
Where are you reading?
Sulojan. Please, your lordship.
Where are you reading?
Page number 44.
44, from the beginning.
Para number 2, your lordship.
Para number, it is submitted that.
It is submitted that suit property is originally belonging to. And before that one para, your lordship, the plaintiff in his affidavit submits that he has filed the suit for the relief of declaration and permanent injunction. The impugned order itself, your lordship, is depicted from some another matter. This is not the facts of the parties. These are not the facts of the parties, your lordship. It is submitted that
The party also belongs to Srimati Sulochana.
this is not the facts of the party. Sulochana is not nowhere party, and this is not the contention by the
What
plaintiff.
is this?
From Gadag, your lordship. Additional senior civil judge and JMFC court at Gadag. The matter is just been copy pasted in the impugned order, your lordship. These are not facts of the present parties.
When it comes to this order,
Please, your lordship.
the plaintiff filed the suit for the relief of specific performance of contract.
Please, your lordship. And here it has been mentioned as.
Forget about it. We will read from here. We come to 45.
Please, your lordship.
Whatever it is, we'll read from here.
Please, your lordship. It has been dismissed. Application has been rejected on a ground that as the suit is for.
Let's read from here. These are the facts of your case.
Please, your
Peruse
lordship.
the application, objection and.
Objection and case filed, and also peruse the citation produced by the counsel for the plaintiff. The plaintiff has filed this suit for the relief of specific performance of contract on the agreement executed by the defendant in the favor of plaintiff. The said suit is for further cross of PW1. At this stage, the proposed defendant number 2 and 3 filed this application, stating that suit schedule property is the ancestral and joint family property of the defendant and these applicants. They have share in the suit property, and the defendant number 1 illegally agreed to sell the suit schedule property to the plaintiff. As stated by the counsel for the plaintiff, if the application is allowed, the nature of the suit will change. The scope in the suit for the specific performance of contract is whether defendant number 1 agreed to sell the suit property and the plaintiff is ready and willing to perform their part of the contract. The said dispute is between the vendor and the agreement holder. The scope of the suit cannot be expanded for the partition. The counsel for the plaintiff at the time of argument, please, Your Lordship.
Correct. Please come. Agreed with
Your
all.
Lordship, I may be granted some time. I'll produce some citation with regard to this.
No, that is settled law. You
Please.
can't do it. It's settled law. You can't even, if it is, I would have granted you time, but you can't.
Liberty may kindly be granted to the present applicant, Your Lordship, to file an independent
It's
case.
always there. I'll
Even
observe that and
it may be
agreed with
kind.
orders passed in I number. I number, what is I number?
I number 11, Your Lordship.
Agreed with orders passed in I number 11 invoice number 306 of 2021, whereby the application that is filed by the petitioners under order 1 rule 10 was dismissed. The petitioner third party is before this court. The first respondent has filed a suit for specific performance of an agreement of sale against the second respondent herein. The second respondent is none other than the father of the petitioner.
Please, Your Lordship.
None other than the father of the petitioner. According to the petitioners, this is a joint family property, and the father cannot execute an agreement of sale in respect of dependent number 1. As such, they have filed an application under order 1 rule 10 to implead themselves in the present petition. That came to be dismissed by order impugned. While dismissing the application, the court has held that the court has observed that in an application, when the suit for specific performance, the rights of the parties can only be decided. Now, whether this is a joint family property or a self-acquired property of a first defendant cannot be decided by the court. It would amount to expanding the scope of the suit for specific performance and accordingly dismiss the application that's filed under order 1 rule 10. Land counsel appearing for the petitioner submits that when it's a joint family property, the father cannot execute a sale deed, cannot enter into an agreement of sale. If these petitioners are parties to the suit, they'd be able to contest the matter and place before the court the true facts. As such, their presence is necessary in the present suit, which was not considered by the court. Next, for having heard the land counsel for the petitioner, peruse the material on record. The suit is for specific performance. A party who is denying the title of the property to one of the contracting parties cannot be impleaded in a suit. And the inter se disputes between one of the contracting parties and a third party cannot be decided in a suit for specific performance. If the petitioners are aggrieved, if the petitioner is of the view that if they are advised that the if they want to file a suit for partition, it is always open to them to file a suit for partition, mentioning this property also, and they can't be impleted in a suit for specific performance. The court had rightly considered the same and dismiss the application. This court do not find any reasons to interfere with the order impugned. Accordingly, dismissed. Come here. Take the printout of this order. Give it to the registrar judicial. Ask him to come to me.
My Lord's liberty may.
That I have already done.
Please, Your Lordship.
Recorded.
Please. Obliged.
Yes.
Seal number 57. Ingraj Maradi.
Please give the file.
Ingraj Maradi. 57.
Notice to the respondent.
Should. Seal number 58. Deshankar Sinde.
No representation for dismissal on Friday.
20.
Yes, 58.
Seal number 59.
Yes.
I'm appearing for petition. Lord, this is petitioner challenging the application rejected by the trial court, which is filed under Lord order 1 rule 10, Lord, impleading application.
What is the suit for?
Suit for partition and separate position.
For the?
Lord,
You are the?
please, she is the daughter. Impleading application is the daughter, my lord. She filed application.
Which you filed? Suit is of which year?
Suit, my lord, is 2015, my lord.
Let's read the order. Please come to the order.
Please. Before that, I request your lordship to kindly see the, my lord, genealogy. It is at page 33.
Read
Please,
and go
please,
to that. Yes.
please. Lord, order is at, my lord, page
27, come to
23.
Paragraph number 7.
Please. Lord, may I read?
Please read.
Plaintiff have filed the suit for partition and separate position in the suit properties. In the plaint, the family pedigree has been shown stating that Shivappa and his wife Timmanna had 5 sons by name Mahantamma Homredappa, Adivappa, Hanumgowda, and Amreshappa. The plaintiff are the sons of Hanumgowda. The defendant number 1 to 5 are children of Mahantappa and Amreshappa. Defendant number 1 and 2 are contesting the suit on the ground that already partition has been taken place in the year 1965 itself, and the case is posted for cross-examination of PW2. The present application came to be filed by the applicant seeking permission to implead her as a defendant number 21 in the suit. Now the applicant proposed defendant number. Lords, one submission. Lord sees the daughter. Now the
Please to the respondent, petition is permitted to take out hand summons.
Lords,
on the
seeking for
counsel
stay
appeal.
for this reason. Only for
counsel
this
appeal.
reason, my lord. I'll make out the case, my lord, with great respect.
You can't grant stay.
Sees
You are
the
a third party.
Lord sees the daughter, my lord. Her share, my lord, the plaintiffs and defendants.
The court says, nowhere you say, who is your father?
My lord, the very plaintiffs, my lord, have admitted in the evidence. Sees the daughter, anta. And my lord, the defendants also.
Take out hand summons on the counsel for the
My lord,
respondent.
the defendants also filed a WS, my lord, written statement. For a moment, your lordship may kindly see the WS. Lord, it is at page 40. Page 40. WSL ಹೇಳ್ತಾರೆ. They have stated, seize the daughter.
Let
Lord,
us see your application. What did you say?
please. Lord, page 48.
40?
Page 84, my lord, sorry. 84.
What did you say?
Lord, para, my lord, first para. Married.
Gauramma. You said Gauramma, wife of so-and-so.
Gausiddappa Honnalli. Lord, it is my husband's name. I have given to my lord marriage to Honnalli.
No, you just say, what is the name of your father?
Please.
Where did you say, who is your father?
Lord, here, second para. I further declare that plaintiff and defendant colluding with each other, they have filed a suit for partition and separate position with an intent to gulf my property, which are exclusive fallen to the share of my father land number so and so.
Who is your father? That's what court is asking. You want to be pleaded in a suit saying that you are daughter of so-and-so, the co-partners of the joint family.
What is happened? My lord, my father and my mother were died. My lord, plaintiffs, they have shown that they are died issueless in the plaint.
That's what I'm saying. They have died.
But both
no
the parties
issue
have
about-
admitted, my lord.
It's very strange. If you want to plead yourself in a partition suit, you should say, my father is a member of the joint family. My father's name is this. I am the daughter of so-and-so. Nowhere you say, who is your father? Isn't it?
Please.
Notice to the respondent.
Emergent.
Petition is
Please.
permitted to take out hand summons on the counsel appearing to the respondent, file a memo to that effect. Once a memo is filed, it's the matter. Yes.
Great.
Yes.
Decree holders writ petition. The impugned order is in Kannada. What has happened is, while deciding an interlocutory application, the court dismisses my application filed under Order 21 Rule 54. However, I would have been given a liberty to take steps for executing the decree. Decree was
The petition shall file the translated copy of the
please.
impugned order.
Previous matter. Lord, I'm permitted to file a dispensation application notice or order of notice to my lord 18 to 31. They are the formal parties.
Dispensation of notice to 18 to
32.
32 memo is taken on record and notice is dispensed with the risk of appellant. For the remaining 1 to 80, 1 to 17.
One, please.
Counsel on the trial court. Yes.
Please. Great.
61.
Yes, 61.
Issue side.
P&SC petition came to be allowed, my lord.
What is came?
Probate petition came to be allowed. And in that schedule A property, as per the original sale deed, had mentioned the measurements. And No, no, my lord. My lordship, what has happened afterwards, I came to know that in CTS records, the numbers are changed. So I filed application for amendment. So that application came to be dismissed by the court, and nobody has opposed, and nobody has opposed the petition also. The court has saying that earlier the amendment application is allowed. It is annexure J, my lord.
Where is it?
Page number.
Where is that page number?
By mistake, I have not mentioned my last order sheet. May kindly listen. Last page number by mistake, I have not listed. P&S number 23 of 20. Orders on application.
How can you amend in respect of the scheduled property after the order is passed?
My lord, the numbers, it is in the CTS.
No, there is a procedure before granting a probate.
Please, ma'am.
For that, they issue notice in respect of a particular property.
Now the property number is not changed, my lord.
That's what
Only
you
measurements of Schedule A property I have mentioned at page number 7, my lord. It may be seen. I have produced the original sale deed. So now what has happened? The subdivision.
Let's read. Please read the order.
Please.
Page 67, read the order. You don't have the file?
Page number I have missed, ma'am.
Order, impugned order.
Please.
Second page of the impugned order, paragraph number 2.
Please, ma'am. The case was filed to issuance of succession certificate. After the trial, the petition came to dismissed on 25/2/21. Thereafter, MFA number 10163/21 was filed, and the said MFA came to be allowed. And it is ordered in this case 13/10/23 to issue letter of administration as per order dated 13/10/23. Thereafter, the case was advanced by petitioner, filed application under order 6 rule 17 to amend the description of Schedule A property on 9/1/24. The same came to be allowed, and amendment is carried out. Thereafter, the application under section 152 CPC was filed to amend the description of Schedule A property in the decree on 9/2/24. The same came to be allowed on 9/2/24. The decree was also amended. Now the present application filed to amend a schedule property in petition and decree and delete the portion of Schedule A property which was already amended petition and decree.
All this be done. How many times the court will do?
My lord, what has happened practically in CTS records, they are not allowing.
No, on your application, an order is passed.
Please,
It is amended.
Please,
It is carried out.
please.
No, why it should be?
Only numbers, there is a mistake, my lord. Not the property, only in the numbers. So for that purpose, I am seeking, and nobody has
No,
opposed.
it is very unfortunate.
Please, ma'am.
When did you file?
I do admit.
No, 13/10/20 so and so. Thereafter, order 6 rule 17 on 9/1/2024.
Please.
Then again you filed another application under 152 CPC that came to be allowed on 9/2/2024. 9/2/2024. Again you come up now.
I do admit, my lord, because of CTS number.
Meeting you can't help it. Whatever is there, you have to. How many times the court
I
will?
can't enjoy the fruits of the decree.
Purpose of this order 6, this amendment.
Fruits of the decree, I cannot enjoy, my lord, unless the property.
For that you have invited. That you have invited. What is the original?
It is at page number 7, my lord.
Huh?
Page number 7 I have produced. Schedule A property.
Because you're taking the course of the.
No, my lord. My submission is in the sale deed. I have whatever is mentioned. I had mentioned the boundaries and the measurement.
So why you want to change it now?
The sale deed, I'm not disputing. Now what has happened is subdivision of the.
Please tell me.
Please.
First of all,
Please.
9/1/2024 order. Before that, what was it? What you have amended?
It is at page number 7, my lord. Schedule A
Page number
property.
7.
That is Schedule A property.
Page number 7 is not, that is the memorandum of writ petition.
Sorry.
Please go through this and have the numbers checked.
Please, ma'am.
Pass over.
Please, ma'am.
Password.
Yes,
61
62.
password 62. Vijay Bhatt.
For petitioner minutes.
Yes.
Once respondent herein has filed suit for partition minutes. Suit came to be decreed minutes. After the decree minutes, respondent again filed FDP number 1 of 2009 for partition by meets and bonds minutes. That after that FDP came to be decreed on 22/10/2024. The said order has been challenged in RFA minutes by the present petitioner minutes. Present petitioner was the defendant in the suit minutes. Meanwhile, minutes in the FDP minutes, respondent herein has filed an application under section 94, read with section 151 of CPC to recall the order dated 22/10, that is of a final decree order, my lords. That came to be allowed, my lords. That impugned order I have charged here in this petition, my lords.
Who are you? You are the?
I am for the defendant, my lords. In the FDP, I am for the respondent. The only provision that helps for the
Let's see the
court
order.
is, my lords, that is the court can review its order under order 41 rule 1 of CPC, my
Let's
lords.
see the order. Where is the order?
Order is at annexure, my lords.
Kannada.
Kannada, my lords.
File the amended copy of the order. Council shall file the amended, the translated copy of the order. Yes, 63.
Please.
63. I have sought for
Meanwhile,
simple writ
interim
of mandamus.
You can't write
Please.
without me understanding what it is.
Please.
63? Srinivas Pinay?
Yes.
63, my lord, I have sought for mandamus, my lord, to reconsider my passport application. Since already the B report is filed and there is no, my lord, criminal case, my lord, criminal antecedent against me. 1 and 2, my lord, Mr. Kanvi appears, my lord, he may be directed to take notice. The case, my lord, against me, my lord, stood closed, my lord, in pursuance of the my lord, B law.
Directing the respondent number 2 to renew the passport. Now, what are these two prayers? First prayer is directing the respondents to straightaway renew your passport.
Yes.
Second prayer is respondent to consider the application for renewal. Which order to be granted?
No, what happened is, Lord, they issued me the endorsement, Lord, wide annexure, Lord, J, stating that, Lord, it cannot be renewed since there is a
Yes,
case
who appears
against
for the
me.
respondent?
Mr. Kanvi, Lord, appears.
So is directed to take notice. Petition
Any-
should serve the copy of the writ petition on the council.
No, it is already served on him, Lord. Your Lordship kindly fix a date, Lord, since.
List this matter. List print the name of so and so. List this matter on 9th February.
Please.
Yes.
Bill number 64. Tunja Halikeri.
This is arising out of an industrial dispute.
Notice. Notice to respond.
Notice.
My lord, the court is proceeding further, my lords, without, I am without legal representation there. My lord, this petitioner, my lord, is without legal representation because he is not giving a consent for representation to a lawyer. So the court is proceeding without assistance of a lawyer from my end. The respondent, my lords. So, my lord, may I seek, my lord, an interview?
Appears for the respondent.
Please.
Who appears for the respondent?
No, this has come for the first time. I'll take a notice to him. In the meantime, I'm grateful, my lords.
Notice.
I seek an emergent notice, my lords.
Emergent notice to the respondent.
Grateful.
Seal number 65. Rajendra R. Patil.
Miscellaneous petition is filed for correction of the, my lord, the final decree. What happened, my lord, that petition was dismissed. Lordship, in the,
The entry for the defendant.
I am the defendant number 2, my lord.
What is the suit for?
So my mother has filed, my lord, suit for declaration against myself and my brother and sister, my lord. In this, their said suit, my lord, the matter was compromised and compromise petition was filed and accordingly compromise decree was also, my lord, the passed, my lord. What happened, my lord, in so far agricultural land, my lord, there is no issue, my lord. In house property, my lord, my mother and her sister, they have two sharer, my lord, in the house property. Instead of, my lord, half share in the southern portion, my lord, the entire house property has been, my lord, mentioned in the compromise petition, and compromise has taken place to the entire extent, my lord. Therefore, I have made an application.
Who are you? You are the daughter.
I am the son, my lord. House property fallen to my share.
You are also party to that.
I am also party to the, my lord.
During that time.
By oversight, my lord, in the plaint also, my lord, my mother, my lord, this entire extent has stated the entire extent instead of half share.
Now, can this court interfere with the compromise decree on this ground?
Admittedly, my lord, we have only half share in the house property, my lord. Another half share belongs to.
Why did you sign that notice?
Notice.
Please. So, emergency notice.
Number 66.
Date may be given. Because other side also have not filed any objection. They have also.
But let they come, we'll see. Yes.
Please.
Seal number 67. 66 urgent 67. By Lakshmikant Reddy.
Your Lordship, we are challenging the entire proceedings filed under section 12 of domestic violence, Your Lordship, wherein petitioners are the in-laws, Your Lordship. That is mother-in-law and father-in-law. Complainant is a wife here.
How can you question those proceedings by filing a writ petition?
A writ petition is maintainable, Your Lordship. In fact, Your Lordship has observed in one of the writ petition. If it is taken tomorrow, I'll place that same order. Please, please.
Seal number 68.
Similar matter listed on 27th, my lord, post this matter.
List along.
47. Seal number 69.
So defendant's writ petition, my lord. I had sought for amendment of written statement, which has happened during the pendency of the suit. The plaintiff files a suit seeking a partition, contends that the properties are ancestral joint family properties. And during the pendency of the suit,
When was the suit?
2014, Lord, during pendency of the suit, my lord,
Read as defendant number.
defendant number 11, my lord.
You are the family.
Yes, my lord, I am the brother. Lord, what has happened is during pendency of the suit, plaintiff has gifted the property in favor of his Lord daughter, and in that regard, my lord, evidence has been recorded. In order to, my lord, plead those facts, I have sought for amendment saying that to bring to the notice of the gift that has been executed by the plaintiff. And also, when he contends that these are the ancestral joint family property, he executes the gift deed in favor of the daughter.
When was the gift deed executed?
25, 11/11/2025.
11/11/2025. What is the stage of the suit now?
Suit evidence of DW1.
Your evidence?
Yes.
The defendant's evidence?
Yes,
Please come to the impugned order.
please. Reasons at page number 19, my lord.
19.
Yes, my lord. Para 6, my lord.
Yes, please read.
The present suit is one for the relief of partition and separate possession filed by the plaintiff against the defendants on the count that the plaintiff and defendants constitute joint Hindu family and the suit properties are their ancestral and joint family properties. Accordingly, they are joint possession and enjoyment of the same. Already the plaintiff has led his evidence and closed his side. The defendants have also put their appearance and led their evidence. When the matter was posted for arguments at this stage,
It's for arguments, not for.
ಇದರಲ್ಲಿ what has a DW1 evidence is completed.
So it says the
So-
matter is posted for argument.
Cross of DW5.
But the court records
Okay.
that when the matter was posted for argument
Cross
at
of
this stage
DW.
has come up with this application under
Cross
order
of-
6 rule 17.
Actually, it is for the cross. Cross of DW5. Actually, my lord, the stage is for cross of DW5. Moderately.
Read para number 7.
At the outset, the defendant Lavan, in the proposed application and in his written statement, pleaded that the properties purchased by the plaintiff and defendant Lavan in their names are their independent and self-acquired properties and they are not the joint family property. Now, the defendant Lavan has come up with the present application that the properties which was purchased in the name of daughter of plaintiff is the property belongs to the plaintiff and he himself purchased the same in the name of his daughter and suppressed the material fact that itself come to the conclusion that the property is nothing to do with the present suit. Admittedly, the said property is purchased in the name of Shilpa, that is daughter of plaintiff who was aged about 22 years. It is specific contention of the plaintiff that with the aid of paternal parents, out of love and affection, the property has been purchased and the same has been sold by the daughter of plaintiff in the year 2025 as contended by defendant number 11. Then by amending the written statement pleadings, those facts which are nothing to do with the merits of the case as stated supra, the defendant 11 specifically contend that the property is purchased in the name of plaintiff and defendant number are not the joint family property and there is no question of allowing the proposed amendment does not serve any purpose and is not made as. No, it is not my, whatever may be the defense of defendant 11, it is the specific case of the plaintiff. He himself has included that the property at the time of presentation of the plaint itself.
No, that is not there. That's what the court
Yeah,
says.
that is the subject matter of the suit, Mullah. properties at serial number 11 and 12, my lord.
No. The defendant number 11 has come up with the present application alleging that one of the property purchased prior to the suit by the plaintiff in the name of his daughter, and the same has been not included.
Well, the same is included. I have produced the plaint.
Oh, but that's what the order reads. Come to your application, let us see, what did you say? Where is your IE?
Please. Application is at annexure G, ma'am.
Page number?
Page 90, ma'am. Annexure F. Lord, page 91, last but 5 lines, my lord.
No, let's read the entire application. We'll
Please.
understand what you are saying.
Please. 12B, my lord, for insertion. It is submitted that the plaintiff has filed this false suit by suppressing real facts and proceeding with the suit by violating the procedure of conducting the case by suppressing the real facts without bringing to the notice of honorable court. Plaintiff purchased the non-agricultural plot bearing number 7 out of survey number 171/E measuring 2 guntas. So 217 square feet from Srimati so and so in the name of his daughter by name so and so aged about under registered sale deed dated so and so. On the date of sale deed, daughter of plaintiff had no avocation, no source of income. The plaintiff, by incurring his amount, he purchased the said plot in his daughter's name. Later on, plaintiff has sold the said plot in favor of so and so through his daughter under registered sale deed for valuable consideration of rupees 25 lakhs. This fact of transaction done by the plaintiff had been suppressed and not brought this fact in this case. The entire sale consideration of rupees so and so has been utilized by the plaintiff only. Further, it is submitted that the plaintiff has filed this suit for release partition on illegal ground. The suit property at serial number 11 and 12, which are bearing plot number.
But defendant number 11 contends that the properties which are purchased by plaintiff and defendants are their self-acquired and separate properties and not joint family properties. What is this statement? Your statement only. From the bottom, 4th, 6th, 7th line.
Yes, defendant 11 contends that the property which are purchased by the plaintiff and defendants are their self-acquired and separate property and not joint family property. During the pendency of this suit, the plaintiff has gift away the suit property at serial number 11 and 12 by executing a registered gift deed on so and so in favor of his daughter by name so and so and handed over the possession of said suit property at serial number 11 and 12 in her favor. The conduct of the plaintiff with regard to above said transaction goes to show.
I think something is wrong with this affidavit.
The
What he
affidavit,
wants to say, and like
actually, my lord, what he wanted to say is plaintiff out of the joint family funds, he has purchased the property. This should have been the approach, my lord, by the of the plaintiff.
What to do? What is the respondent?
I sought for a stay, my lord. At least
It has
for
to be dismissed, but I'm issuing notice in this. Because contrary to your own affidavit, the court can't pass any order.
obliged.
Yes.
Number 70. Ampi Gorpade.
The respond number 156 are availed loan from the respond number 3 lordship. And three, file a case before respond number 4 and the order is passed lordships. And being able to that the respond number 1 and 2 prefer a appeal before the KT lordships. And
Requires the order dated 13/9/2020.
or impleading as respond number 6.
See that order dated 13/9/2025. Page number.
Lordship, the reasonings lordship, the
From 34, your lordship.
34 lordships, the para number 10.
Reasons
Reasonings lordships.
starts from 29. Reasons, please.
The para number 10 lordship, the learned concept for the proposed respond number 6 has submitted written arguments on perusal of the written arguments. The grounds stated in the affidavit filed support of the interim applications are reproduced. It is contended that the appellants had executed agreement of sale in favor of the proposed respond number 6 in respect of the property bearing cities number 322/1B/1 measuring 180.88 square feet situated at 1/4 Hubballi. It is contended that the agreement of sale executed on 22/3/2016. However, the respondent number 2 society has created the charge over the said property, which is subject matter of the agreement of sale. When the proposed respondent number 6 is requested the appellant to execute the sale deed, they started giving lame excuses by saying that the appeal is pending in respect of the property, which is subject matter of the agreement of sale. It is further contrary that the proposed respondent number 6 is aggrieved person has right over the property is under threat. The proposed respondent number 6 is having first charge over the property. The appellants have some other properties and that can be attached to recover the loan amount. Therefore, the learner counsel for the proposed respondent number 6 sought for allowing the applications. The Lordship, the pan number 14. The undisputed fact that the emerge from the records are that the applicants have suffered award order to pay a sum of 30,50,558 being agreed by the same. For the present appeal, the applicants have borrowed a loan from the respondent number 2 society and executed registration mortgage deed in favor of respondent number 2 on 22/4/2016. An agreement has been created in respect of the property bearing number 382/1B/1, measuring 188.88 square meters, situated at ward number 4, Hubballi. The applicants have submitted loan applications before the respondent number 2 on 5/4/2016. The property, which is subject matter of the agreement of sale, offered as a security to the loan transactions. The said property has been attached as per the improvement order passed by the respondent number 1. And the operative question is the pan number 15, Lordship. We have perused the copy of the agreement of sale filed by the London counsel for the respondent number 2. On perusal of the same, it is an unregistered agreement dated sale 22/3/2016. The registered mortgage deed is 22/4/2016 in favor of the respondent number 2, Lordships. In fact, it is wrongly typed. It is the present respondent 1, 2, and 6. They are registered before the sub-registered, Lordship. The opportunity not given to the present petitioner, Lordship. The opportunity is not given to the present petitioner.
What
Lordship.
opportunity?
Though they make an agreement of sale with this.
An agreement of sale in the year 2016.
Yes.
To go before the tribunal in the year 2025. Do you say that you have a preferential right over the property? How can it be? The party has already mortgaged the property in favor of the bank.
My one
Can
submission.
you, even otherwise, if not before that, can you, that agreement of sale, at least can you file a suit for that? Signals for performance
Not
after 6 years?
No. My one
So
submission.
the court, it has rightly been observed that it is a collusion between you and the borrower. Please come.
Yes, may I make a submission, Lordship? At least the emergency notice should be to the respondent, Lordship. The matter is like to be settled. We make a.
What is that?
The matter like to be settled if the notice be issued, Lordship.
Agreed with the orders passed in I number 3. And number 3 in COP appeal number 5 of 2019, dated 30th September 2025, passed for the Karnataka Appellate Tribunal. The claimant, the third party is before this court. It is a case of the petitioner that he has entered into an agreement of sale with which respondent he is?
Respondent 1, 2, and 6. 1, 2, and 6. 1, 2, and 6.
He has entered into an agreement of sale with
Respondent
1,
2, and 6.
1,
2.
1 and 2.
1, respondent 1.
Huh?
Respondent number 1 and respondent number 2. And respondent number 6.
6 on 22/3/2016. The respondents to execute the sale deed, they are denying the same as an award, that an award is passed and the property is mortgaged to the respondent bank. As such, is a proper and necessary party with this petition as its rights are involved. Hence, he has filed an application to implead under Order 1, Rule 10, read with Section 151 CP, and sought to implead himself as respondent number 6 in the present appeal that came to be dismissed by the court, by the appellate tribunal, by order appellate tribunal. The tribunal, while dismissing the application, has observed that the agreement of sale in favor of the proposed party is an unregistered agreement of sale dated 22/3/2016. The registered mortgage deed is executed on 22/4/2016 in favor of the respondent number 2, in favor of the society. Don't say respondent number 2. Apart from that, in the agreement of sale, it is recited that the appellants of decided that they have mortgaged the property in favor of the society as a security to secure loan of rupees 30 lakhs. It is also decided that till they repay the said amount, they would not sell the property in favor of the petitioner herein. The tribunal has observed that agreement of sale does not confer any right, title or interest over the property in question. The agreement of sale is executed in the year 2006. Now, after the lapse of nearly 9 years, the proposed respondent number 6 has filed this interlocutory application that he is an interested person in the property attached with the respondent, attached with the bank. The tribunal has also observed that the proposed party was aware of the mortgage in question in favor of the bank, but still ventures to enter into an agreement of sale. When the property in question is mortgaged in favor of the bank, and it is attached since the bank have failed to, since the borrower has failed to repay the loan. Hence, the court had dismissed the application and has held that the proposed party cannot get any right over the property by virtue of the unregistered agreement of sale. Next paragraph. Land counsel appearing for the petitioner submits that an agreement of sale is executed in his favor. He has a right over the property. He is a proper and necessary party to the proceedings. The court, considering all these aspects, had dismissed the petition. Next paragraph. Having heard the land counsel of the petitioner, there is a material on record. The petitioner has an agreement of sale on 22/3/2016. There is a recital in the agreement of sale that the property is mortgaged to the bank. Until the same is repaid, they will not execute the agreement of sale. They have failed to, the borrower has failed to, borrower and the person who has executed the agreement in favor of the petitioner has failed to pay the amount, and the proceedings were initiated and an award is passed, and the award is questioned before the appellate tribunal. At that stage, the petitioner comes with this application under Order 1, Rule 10. This court has already extracted the observation of the court in the preceding paragraphs. The court has rightly held that the agreement of sale will not confer any title on the petitioner, particularly in the facts and circumstances of the case, where in the agreement itself there is a recital that the party will not execute any sale deed in favor of the proposed party till the amount is repaid to the bank. In the considered opinion of this court, there are no grounds to interfere with the well-considered order passed by the appellate tribunal. Accordingly, dismissed.
Number 71.
The petitioner filed the execution petition for executing the possession of the property or worship. That
When was the suit filed?
suit filed in the year 2007 or worship that.
When was it decreed?
So decreed on (2011) or worship that. 1/4/2011.
When was the execution filed?
So 2017.
2000?
Or worship that.
Yes, please come to the.
24, sorry, or worship. 2024.
That's what.
Yes, execution.
Please come to the impugned order.
So that IA for the possession has been dismissed on the ground that in the suit for partition, there is no specific order for eviction of the tenants.
Let's see the order impugned.
So kindly see that page number 43 or worship that.
It's a suit for partition.
Yes, but they are the tenants are also made as a party.
What happened to the final decree proceedings?
Final decree petition, they have compromised in the appeal. Some of the parties have filed the appeal against the judgment and decree. So during the pendency of the appeal, so
whatever is the decree that is passed.
Yes.
That is only executable.
Yes.
So where is?
So
the
it is
decree?
fallen in their share.
Where is the decree?
Decree page number 71, your worship that. Yeah. (71) OS decree.
Let's read the decree.
Pass a decree for partition and separate possession of plaintiffs' share in suit schedule property B, C, and D properties by meets and bounds, and the plaintiffs to be put in with the possession of their share of property.
This is
Possession of their
decree is in Kannada. What is that?
decree is in English,
Page 72.
judgment is in Kannada.
No, page 72. 72.
72. Yes, it is in Kannada.
What is that? Please read it.
ವಾದಿಯು ದಾವಾ ಶೆಡ್ಯೂಲ್ ಬಿ ಆಸ್ತಿಯಲ್ಲಿ 1/28 ಹಿಸ್ಸೆ, ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸಿ ಆಸ್ತಿಯಲ್ಲಿ 1/14 ಹಿಸ್ಸೆ ಮತ್ತು ದಾವಾ ಶೆಡ್ಯೂಲ್ ಡಿ 15/42 ಹಿಸ್ಸೆ ಹಕ್ಕು ಪಡೆಯಲು ಪ್ರತ್ಯಕ್ಷ ಕಬ್ಜಾ ಪಡೆದುಕೊಳ್ಳಲು. It means that entitled for possession.
Who are entitled for possession?
So the plaintiffs. So according to that, we have fallen that position in that property.
Please come to the field. Where is the reasoning part?
Your Lordship.
Reasoning part.
Page 143, Your Lordship, that paragraph 19.
We will read from paragraph number 8.
18, Your Lordship, that.
8. We'll continue after lunch. Yes, get it?
Your Lordship, serial number 84, due to personal inconvenience, I pray for a short accommodation. Other side, we have informed due to medical.
Sometimes we will take
Your
these
Lordship.
mentions in the morning, in the afternoon,
Due
in
to,
the evening.
due to some medical reasons, I'm seeking
What
for
is the
accommodation.
inconvenience?
Some medical reasons, my senior won't be able to appear. 84. We have, other side, we have informed.
In this also a memo is moved already.
Yes, sir. Please.
Is this man? No, there are no respondents in 84.
We have already informed our respondents.
Seal number 93, my lord.
No mentionings now.
No, my lord.
I'm sorry, I can't entertain mentions at this
My
time.
lord, serial number 29, my lord.
Lordship, serial number one.
My lord, serial number 29.
इधर आ जा
अच्छा
ಸರ್
ಇಲ್ಲ ಇಲ್ಲ ಆಗಿಲ್ಲ ಆಗಿಲ್ಲ
serial number है ना 43 46
ARG सर को दे दे
किसको
ARG सर को देके
Court of sir.
ARG सर ये जाके दे ಕಡ್ರಿ ನಾವು ಇದೆಲ್ಲ
Ministerial order.
मैडम ने दिया
ಈಗ ಹೋಗ್ತಾರೆ ಸರ್ ಇದ್ರಲ್ಲ
230 ಕರೋ
ಮುಂಚೆನೇ ಆಗಿದಲ್ಲ ಅದು ಇದ್ರಲ್ಲಿ ಇರಲ್ಲ ಹೋಗಿದೆ ಇಲ್ಲ ಸೈನ್ ಆಗ ನೋಡಪ್ಪ ಸೈನ್ ಹೋಗಿ ಸರ್ ಈ ಮೇಡಮ್ को दे
ये एज संबंध
जी
ये हैबिटेट आसमा
चलेगा उधर चलेगा
आसमा
उधर चलेगा चेंबर को चलेगा
ये डिस्पोजल
नो
आने एक बात बोलो
ये डिस्पोजल
बंद में ले ಲಿಸ್ಟ್ ಆಗೈತೆ ಅಂದ್ರೆ ಕರಿಬೇಕಲ್ಲ ಸರ್ ಹಂಗೆ
Your Lordship, that 143 para 19.
Please read.
In the backdrop of the said argument, I have gone through the judgment passed by this honorable court, OS number so and so. It appears that this court has ordered the tenants to deposit the rent before the court, but they have not complied the said order. Therefore, this court has imposed 3 months civil imprisonment them. There is no specific finding for eviction of the tenants. This is a finding, Your Lordship, that given. But that decree, what I have read that, Your Lordship, that possession, they're entitled for possession. So though in that suit, they are also party in that proceedings. My submission, Your Lordship, that.
No, that part of the decree, please translate it and file.
Yes, Your Honor.
Day after tomorrow.
Day after, much over.
The petition, list is matter day after tomorrow. By the time the land council of petition shall file the Kannada part of the decree. File the translated copy of the decree, which is in Kannada. Yes.
Cell number 72.
Please. Please, I am for petitioner, my lord. Petitioner seeking the writ of mandamus to consider the representation, my lord.
Where is the representation? Let us.
Please, my lord. Annexure 29, 30, 31, 32, 33, my lord. Given the representation to the respondent's authority.
325. To whom you have given?
Please, my lord. Respondent number 1 to 5, my lord. The petitioner, the respondent.
Only one authority who will consider. All will not consider the
No, ma'am.
representation.
They are the unauthorized, they are constructed the
I
school.
am saying, who is the competent authority to deal with that?
My lord, respondent number 2 and 3, my lord. They have to give the compensation to me, my lord, which they have constructed the school, government school, they have constructed in the my land, my lord, without my prior permission and without still today they have not given any compensation, my lord.
Whatever
Your
it is in
lordship,
accordance with law.
your lordship, what now he is seeking, your lordship, he want to survey that land, your lordship. Now prayer, his prayer is to survey that land against R6, your lordship. As it is his contention that the respond number 1, 2 and 3, education department.
Representation page number, my lord, 29 to 33, my lord. G for.
He has given representation to the DC, your lordship, but wherein survey is to be conducted by the ADLR, who is the respond number 6, your lordship. And moreover, your lordship, at page number 22, it is in Kannada, your lordship, where they have stated in the presence of ADLR, survey has been conducted. It is there, your lordship, at page number 22, it is in Kannada.
The grievance of the petitioner.
They want to survey the entire area, your lordship, wherein it is their contention that respond number 1, education department, they have encroached his property. For that reason, he needs to survey that entire land so that whether encroachment is there or not. If at all encroachment is there, he need a compensation from respond number 1 to 3. That is his contention, your lordship. But the grievance who has to consider, survey who has to conduct survey is from ADLR, he has to, your
Study
lordship.
survey is conducted, my lord,
It is
which they have produced in typed copy of the annexure B, my lord. The sketch map is there, which is the school they have encroached that much, my
So
lord.
survey says that there is encroachment.
Encroachment, they have mentioned, my lord,
The
annexure.
representation you have given now. She
Now,
says
my
you have
lord,
given the
according to
representation
that,
survey.
according to that which they have encroached, which they have encroached, give me the compensation, how much they have encroached.
Without their consent, we have encroached the property and we have constructed the building. It is their, he will seek for a compensation of the amount, your lordship. From DC, he has given, your lordship.
DC, AC and all the respondent authority.
So what
Please.
he is seeking is not seeking for survey.
No.
Survey is already conducted.
Already done.
As per the survey, there is encroachment of his land. And encroaching his land, school is constructed. For
And
that,
it
he
is
seeking
running.
compensation.
Please, your lordship.
In that regard, he gave a deputy commissioner is a competent authority to consider.
Please.
Please, your lordship. We'll consider and pass order, your lordship.
Present petition is filed, seeking the following prayer. It is a case of the petitioner that petitioner is the owner of an agricultural land bearing survey number 4, measuring 5 acres 30 guntas which is situated at Godhi village, Sugi Taluk, Koppal district. The husband of the petitioner has given the representation before the ADLR for the conduct of the survey and also mark the boundaries of the land as per the request of the petitioner. As per the request, the respondent number 6 has conducted the survey and fixed the boundaries of the land and filed the report. In that report, it is mentioned that the property was encroached by the government for high school and also built for high school, and they built was encroached by the government and they built a high school in that. After the death of the petitioner's husband, the land was mutated in the name of the petitioner. Basing on the report by the sixth respondent, the petitioner has given representation to respondent number 3. Then the respondent number 3 had in turn directed respondent number 5 to conduct inquiry and submit a report. It is the case of the petitioner that, in spite of the said representation, no action has been initiated by the respondents. Hence, he has come up before this court. Learned High Court HCGP submits that they'll consider the same in accordance with law. Accordingly, the writ petition is disposed of as per the following order. The writ petition is disposed of directing the first and second respondents 1 to 3.
Please.
To consider the
1, 2 only, Your Lordship. 1, 2 only. DDPI is the authority subsequent.
Consider the representation dated 8/10/2025.
Please.
In accordance with law, within a period of 8 weeks from the date of receipt of the copy of the order.
Please. Much of
Yes.
73. Raghavendra Purohit, please. Lord, petitioner is seeking a directions, writ of mandamus against the respondent number 3 to 6, my lord, in respect of the recreation club matter, my lord.
Recreation Club, Your Lordship, I got the information. I have called him, Your Lordship. What he says, Your Lordship, as per direction, as yesterday also I have submitted, we used to visit the premises, whether any illegal activities are conducting or any something else in the name of his petty Lordship. They may play Remy also and Andar Bahar. For that reason, we used to inspect. Only for that reason, we used to visit that premises.
So I'll record that the respondents are not interfering.
No, but
The order passed by where is that order?
the conditions, Your Lordship, which
Annexure D. my lord. Page number 26. my lord.
The present writ petition is filed, seeking the following prayer. The petitioners is a social club registered in the name and style of Trans Recreation Social Club, which is registered under the provisions of the Karnataka Societies Registration Act on dated 19/11/2025. So you started on 19/11/2025, they started interfering and.
Yes, so one or other, my lord,
petition also.
no, my lord, one or other reasons, my lord, the respondent numbers 3 to 6, they
No,
were
no,
insisting, my lord.
Please tell the court, in your petition, where did you say, on what day they have come, what did they do? Please come to the petition.
My lord, telephonically and orally, my lord, they are insisting to
There
get
should be a date, there should be a date, isn't it? When you say they're coming, you should say, on so-and-so date they called, or the so-and-so date they came to the, no. Just filing a vaccination writ.
No, my lord.
No, but come to the affidavit, where did you say to the petition? It's a bald allegation. Respondent
No, my
number
lord,
3
bald,
to
it is
6.
not a bald allegation, my lord. We
There
are
should
not.
be specific government in the affidavit. What is it they are doing?
My lord, the police authorities will telephonically call the president and insist the president to get the license for playing the rummies and other games, my lord. Otherwise, we will take action against your.
Yes, you can say one on so and so date they have called. Why did you say? The respondent number 3 to 6 have started interfering in the affairs of the club and asked the petition to stop the activities. When did they come? When did they ask you? Are you not supposed to state in the petition?
Sorry, my lord.
No, not is that. No, it has happened. No, now every matter is a covered matter. Because in some other matter or order is granted, you will file similar writ petition without any averments, without it saying anything. What did you write? The club conducts recreation activities such as indoor games, namely chess, carom, rummy, skill games, table tennis, crossword, and to train the members for sports. It is the case of the petitioner that the respondent 3 to 6 have started interfering in the affairs of the petitioner's club and orally asked the petitioner to stop the activities as there is oral direction from the higher authorities. And the petitioners have requested the police authorities not to interfere with the activities of the club as the activities are in accordance with law. It is stated that in identical matters, this honorable court has issued directions not to interfere with the affairs of the club activities. It is stated that they have instructed the petitioner to close down the club and lock the premises. The petitioner approached the superintendent of police and requested to issue direction to the concerned police officials not to interfere with the affairs of the petitioner activities. It is further stated that police authorities high-handedly and illegally are interfering with the day-to-day affairs of the association and causing embarrassment and harassment to the petitioner and its members. Now the petitioner seeks a similar order as that is passed in the other in the NWP number 104309 of 2025. The learned HCGP appearing for the respondent submits that as per the order passed in batch of writ petition, whereby the jurisdictional police have the liberty to visit the premises periodically and on receipt of any information about any unlawful activity being carried on in the petitioner's premises, in the premises, not petitioner premises. And there is a direction that the respondents are directed not to interfere with the lawful recreational activities carried on by the members of the association. Further, the court made it clear that the order would not come in the way of the jurisdictional police invoking the provisions of the Act and taking action in accordance with law when the members of the petitioners are found to have indulged in any unlawful or immoral activities. It is submitted that the respondent police are not at all interfering with the activities, and as stated by the petitioner, they have not asked them to close down the activities. As per the order passed by this court, as per the guidelines issued in the said judgment, they have every liberty to visit the premises to see whether any unlawful activities are going on or not, except that they are not interfering with the activities. Expert, having heard the land counsel on either side, there is a material on record. The petitioner in the writ petition, without even mentioning what is the interference, is seeking an order from this court as it is passed in the identical matters. The respondents are always at liberty to inspect the premises of the petitioners, even as per the earlier order passed in WP number 104309 of 2025. The petitioner cannot object for the same. According to the, as per the instructions of the HCGP, they are not interfering with any of the activities, nor they have asked them to close down the premises as stated in the writ petition. And they will be, and they have every right to visit the premises as to find out whether any illegal activities are carried out. In that view of the matter, this court is passing the following order. The petition is disposed of recording the submission of the CGP that the respondent are not interfering with the activities of the club. Number two, the police are always at liberty to visit the premises, petitioner's premises, and if any illegal activities are carried out, they are at liberty to take appropriate action.
Still number 74, case Patil. Case Patil, please.
Plaintiff's writ petition, my lord, challenging order on IA, plaintiff's writ petition challenging order on IA number.
What is the suit?
Suit for partition, wherein, my lord, the defendant number 3 and 5, they file a written statement admitting the relationship of plaintiff. However, they file a application for amendment of written statement, withdrawing the admission made in the written statement. That in the written statement they have admitted the relationship and admitted that the plaintiff. Please,
Let's see the order.
please. Order is 89, my lord. Order. There is no reasoned order, my lord.
Let's see.
Typed copy of. There is no reasons assigned, my lord. Heard arguments and peruse the same are allowed with cost of 500 each in the interest of justice and equity.
Then counsel for the petition submits that. Suit is of which year? First number 298 of 23.
Please, 23, ma'am.
Plaintiff seeking partition. In that, the defendants have filed their written statement admitting the relationship between the plaintiffs and the defendants. However, they filed an IA number 9
and 10.
9 and 10, seeking amendment of the pleadings. And by way of this amendment of the written statement, they want to withdraw the admission that are made in the earlier written statement. The court, without giving any reasons, passed an order on 8/12/2025, allowing the application. It is submitted that the order passed by the court is not reasoned order. Next, this court has perused the order dated 8/12/2025, which is bereft of reasons. Hence, there shall be stay of all further proceedings. So and so, till the next date of hearing. The petition is permitted to take out hand summons on the counsel appearing for the trial before the trial court for the respondent and file a memo to that effect by 17th of February. If the memo is not filed, on that ground, the stay granted by this court stands vacated.
Please.
Still number 75.
Please, ma'am. This is plaintiff's writ petition, my lord, wherein the defendant number 3 is made. The municipality, town municipality is made as a party. Reason for making the municipality is that, my lord, there is a content pleadings that the defendant number 2 has created a documents colluding with the.
Please come to the improved order.
Please, ma'am. It starts annexure E, my lord, page 51, my lord. It starts at, my lord. Filed application to delete the defendant number 3 from the proceedings. However, my lord, there is no relief is claimed to municipality. The only allegation is that the defendant number 2 has created his name, colluding with the authority. Now, with the intents to delete the town municipality, that application is rejected, my lord.
On what ground? Come to that.
Yes, my lord. Para 12, my lord. It starts in the context of the suit of partition and declaration of heirship. The question whether the defendant number 2 is the legally wedded husband of deceased Parava is central to determining the rightful heir and their respective shares. This issue cannot be effectively adjudicated in the absence of defendant number 2, whose claim or denial of such status is intrinsic to the dispute. His role is not merely incidental but directly connected to the subject matter of the litigation. Furthermore, striking out the name of defendant number 2 at this preliminary stage, particularly when serious allegations have been made against him and government records have been allegedly manipulated in his favor, could not only prejudice the proceedings but also hinder the.
Agreed with the dismissal of an order passed under order 1 Rule 10 CPC
to strike out the defendant number 3, as he is not proper and necessary parties to the suit. And counsel appearing for the petitioners or plaintiff submits that it is for the plaintiff against whom he wants to prosecute the suit and against whom he does not want to prosecute. The court, without considering the same, had dismissed the IA. There shall be stay of all further proceedings. So it's the same order like.
Please, please.
Yes.
Seal number 76. Bahubali and
Please,
Convent.
my lord. I am for the petitioner defendants, my lord. I have filed by the defendants, my lord, seeking permission to file a written statement, my lord. I has been rejected as per,
Which year is the suit?
please, my lord.
Which year?
2025, my lord. June he has filed, my lord.
Did you enter appearance?
My lord, 15/7/2025, my lord. After that, my lord, he met with an accident, my lord.
Come to that order.
Please, my lord.
Come to the order.
Please, my lord. Page number 33, my lord. This is not a speaking order, my lord. Only one line order, my lord. Case taken on 9/12/2025, my lord. Case taken on today's board. Defendant number 1 has filed petition under order 8 Rule 10, read with 151 CPC, along with written statement and memo. It is averred in the petition that defendant number 1
Land counsel for the petitioner, defendant submits that the court, the suit is of the year 2025. And he has entered appearance on 15/7/2025. Later, and the petitioner has filed a written statement on the ground that the amendment version of the CPC, the right for the defendant number is forfeited and dismiss the application. It is submitted that the court has failed to consider all the relevant aspects. This court has perused the order passed by the court. Considering the submission, we shall be stayed. Same like in the other case.
Please.
Summons and memo to be filed. Yes, next.
Please, ma'am.
Seal number 77.
Pass over notice, he end up in the other court.
Yes, 78.
Password 77, 78. Shuraj Baroli.
Petitioner, my lord. My lord, I am impugning the order passed by the trial court, my lord, wherein my applications seeking recalling of the plaintiff's evidence and reopening of the evidence and summoning of the court commissioner to adduce evidence has been rejected, my lord.
Come to that order.
Please, my lord,
Page number?
20, my lord.
Please read the reasoning part.
Please, my lord.
Para 6.
Please, my lord. This is the present suit filed by the plaintiff against the defendant for the relief of declaration and consequential relief of permanent injunction against the defendant, praying to restrain from causing obstruction of possession. The plaintiff in the plaint category contended that the plaintiff is the owner in possession of the residential property bearing VPC number 424B, comprised in ABCD points in the hand sketch to the plaint, and the defendant is the owner in the possession of residential property bearing VPC number 462, comprised in GHIJ points annexed to the hand sketch in the plaint. The plaintiff further contended that there is a public road in between the property of the plaintiff and defendant, and the defendant, being the owner of the property bearing VPC 462, has encroached into the property of the plaintiff at BEFA points as mentioned in the hand sketch. On the other hand, defendant outrightly denied that the contention of the plaintiff and admitted that defendant is the owner of property bearing VPC number 462, which is house, open space and cattle shed shown as ABCD points in the hand sketch annexed to the written statement. The defendant also contended that there is an existence of government road in the property of plaintiff and defendant as per the hand sketches produced by the plaintiff and defendant. The property bearing VPC 424B is situated in eastward, and property of the defendant bearing VPC number 462 is situated in westward of the Haligeri village, and there exists public road in between the property of the plaintiff and defendant. The plaintiff in the plaint categorically alleged that defendant has encroached into property of the plaintiff at BEFA points, and the commissioner in his report dated 4/11/24 stated that
Petition is permitted to take hands of it.
Madam, seeking stay in this, madam. My lord, the matter is listed tomorrow for arguments, my lord.
That's the reason. That's not a case for, yes, no.
No, my lord, though the plaintiff and defendant has admitted that there is a road in between the properties, the court commissioner in his report has given that there is, the road doesn't exist.
Notice respond.
Notice. Issue number 79. Dharwad, there is. Please.
Here, my lord, the deputy commissioner has passed an order directing the Tahsildar to register FIR against me, my lord. I am the society. My lord, first of all, my lord, in the year to, the respond number 5
Where is the order?
at page number, annexure G, my lord, at page number 48, my lord. Impugned order is at 48. The deputy commissioner has directed to register FIR, my lord.
Your Lordship, as per the order of this honorable court, page number 48, Your Lordship, it is clearly stated that there is a misappropriation of 10 lakh rupees, Your Lordship.
My lord, one submission, my
The present petitioner who has availed the amount from the government to construct the building, Your Lordship, and that amount is misappropriated, Your Lordship.
He has
And
not
for,
constructed the building.
no, Your Lordship, there is a misappropriation as per the order, Your Lordship. And that is the reason, Your Lordship, he has issued a direction to the Tahsildar to file a complaint, Your Lordship. And moreover, Your Lordship, it is not yet filed, or it is the inquiry who has to conduct, Your Lordship. Inquiry is to be conducted whether misappropriation is after investigation only. The deputy commissioner has directed the Tahsildar to file a FIR, Your Lordship. And it is necessary, Your Lordship, because as the amount granted by the government is
My lord, the
misappropriated.
amount was sanctioned in the year 2014-15. Thereafter, respond number 5, who claims himself as a social worker, he filed a complaint before trial court, private complaint before trial court. Then trial court, my lord, has took the cognizance, my lord, and FIR has been filed. The same FIR has been already quashed by this honorable court, my lord. That is at annexure D and E, my lord. In respect of same allegation, my lord. Annexure E, page number 31, my lord. There also he alleges the same, my lord, the misappropriation of 10 lakh rupees. Two petitions were filed. Annexure D is the then president of the Samiti, and Annexure E is the other members of the Samiti, my lord. In both petition, my lord, this honorable court has quashed the.
No, this allegation is different and what the present allegation is.
No, my lord, both are same, my lord.
He says now that you have availed the loan but have not constructed.
Pardon, my lord?
Not loan, Your Lordship, but the grant from the government, Your Lordship. To
Same
construct.
amount.
Please,
And
10
they have
lakhs.
you have misappropriated. the amount.
By forging, Your Lordship, by producing the duplicate documents, Your Lordship.
My lord, the same argument were taken before the other coordinate bench, my lord. The coordinate bench, after considering all the representations and my lord, the complaint and my lord, even at annexure D, my lord. At annexure D, para number 6, my lord.
Please come to paragraph number 6 of the order which you are relying on. Please come to that.
It is to be noticed here that if the petitioner had sought, page number 29, sought for release of the funds and the government had in fact released the funds that had been sanctioned, it would have done so obvious after necessary verification on the basis of the averments made in the complaint. It cannot be said that there was an allegation which justified the reference of the police under section 156(3) of CRPC and for investigation into a crime. Therefore, I am of the view that there is no grounds for. Please, my lord.
He's a third party. He's a third party who is unconnected with all this. Now the grant is given by the government to you.
And now, if something, if they find that something is wrong, what is wrong in conducting an inquiry?
My lord, they have
And if
only
the-
submitted, my
if the
lord.
Inquiry, if the inquiry report, if the inquiry reveals that there is any misappropriation, then they would do it. Why should we stop that?
My lord, the government authorities, they themselves have submitted a report, my lord, saying that there is no misappropriation of fund.
When did they submit?
My lord, the first one is report submitted by the revenue inspector to the Tahsildar. And second one is the letter addressed,
No, while conducting inquiry, they will give you a notice, they will not give you notice.
it's not notice, my lord. They already deputy commissioner has directed to,
Is it after inquiry?
no, lord. He clearly says, my lord, that registration of FIR.
Yes.
I'll file my objections, Your Lordship.
My lord, till that, my lord, stay may be.
Your Lordship,
Because, my lord,
as-
You should have got, when is it the matter coming up for the first time?
First time, not really.
Which is this matter on 18th of February, by the time
Please.
the respondent, the HCGP shall get specific instructions, public file their objections.
Please, Your Lordship.
Then counsel for the petitioner submits that. And respect to the very same allegation, when a complaint is, when FIR is registered, the petitioner has filed criminal petition number 103688 of 2022 and coordinate bench of this court by order dated 12th February 2024 has quashed the complaint. Considering the same, they shall be stay of all further proceedings.
much obliged.
To the order dated so and so.
Sadiq and Goodwala.
Appear for petitioner.
Yes.
Respondent municipality called for lease of 52 shops by e-auction. Petitioners are highest bidders for shop number 1, 11, 13 and 14. These unsuccessful bidders, 1, 11, 13 and 14. These unsuccessful bidders files an objection to respond number 1. They could not upload the application. Therefore, filed objection to call for new fresh tender. Now, based on their objection, he has called for fresh tender.
Let's see.
Please kindly turn to annexure H, page 19.
When the fresh tenders are called.
It is on tomorrow, 22nd, it has been called for fresh tender. Page 19.
Who is the council appearing for this municipal council?
Mr. Santosh Mane.
So and so is directed to take notice, list this matter tomorrow, inform the council. The council shall get, the so and so shall get specific instructions tomorrow.
May I make a submission at 10:30 because they will start at 11 o'clock. I'll make it.
Tomorrow is the first matter, print the name of the council, inform the council to get instructions.
Please.
Seal number 81, Sanjay Katigeri.
Appear for the KPI respondent. May make a submission. My request is to be taken up on Tuesday.
My lord, there is an interim order in the connected case. I think he don't appear in the connected case, my lord. 100-42, my lord. There was an interim order by the trial court. Injunction order was granted. Subsequently, I think he don't appear for respond number 11. He filed objection that there is no compliance of the order 39 rule 3B, my lord. Notice is not issued, but we filed an affidavit and they produced the postal endorsement when the interim order was granted during vacation court. We have complied itself by sending the postal with the copies, everything, my lord. Even then, my lord, the trial court has vacated the interim order, my lord. There is no application under order 39 rule 4, my lord, and it is not an appealable. Your lordship, in that matter, stay may be granted.
Tuesday we will hear both the matters.
No, your lordship, the connected matter is only regarding.
It's only Tuesday it's coming.
No, your lordship, yesterday matter was listed, this matter. So I made a submission that it should not mislead because a registrar has put up caveat in the first case, my lord. So I thought that it is bid. Now, what?
Come up on Friday.
No,
Tomorrow.
Tomorrow? Yes,
please.
this is the matter tomorrow.
Please.
Both the matters.
Please.
Welfare matters, or day after tomorrow. Yes, 82.
Shuraj Pim.
Not beg to appear for the petitioner.
Yes.
The petitioner is a society registered under the provisions of Karnataka Society Registration Act. Not by virtue of
the civil court order, my lord, election was conducted. My lord, when the election was under process, my lord, the fourth respondent approached this honorable court, challenging the voter list, my lord, page 40 annexure E, challenging the election process, my lord. And page 46 is the order passed by this honorable court dismissing the writ petition, observing that any, my lord, the election result, my lord, or election, the declaration of election result or the voter list, it can be challenged by way of election petition. Based on this, my lord, writ petition dismissed. Thereafterwards, my lord, annexure of election result was declared. After declaration of result, the fourth respondent once again filed application before the second respondent, seeking to conduct an inquiry regarding conduct of the election process. Well, Section 25 of the Karnataka Society Registration Act, it provides. Section 25. The ingredients of Section 25.
Yes.
Not may I read, ma'am? The registrar may on his own motion and shall on the application of majority of the members of the governing body or less than 1/3 of the members of the society. No, this is the ingredients. Majority of the members of the board or 1/3 of total members of the society have to made a requisition to the authority to conduct an inquiry. In the instant case annexure H page 50, the one person who was a writ petition earlier, my lord, one person filed, my lord, a complaint.
Page number?
Page 50 annexure H. But he sought for, my lord, conduct an inquiry and re-election of, my lord, the election process. Lord, that is not permissible under the act unless the aggrieved party has to file a suit or
What this order reads?
not now. The second respondent appointed, my lord, third respondent as inquiry officer to conduct the election process. Lord, identical matter, my lord, the sum of, my lord, the
Section 25.
Your Lordship, what section 25, Your Lordship?
Yes, let's read.
The registrar may on his own, Your Lordship.
Not on his motion.
On his own, he has given a complaint, Your Lordship, but subsequently, Your Lordship, they have conducted the inquiry also, wherein it was found there are many members who has dead also. After, means in the operative portion, Your Lordship, PTK, preamble.
Include order, what is he saying?
Please, Your Lordship.
Please come to that. What, at the.
Page number 52, Your Lordship, starting.
Subject, what is the subject?
Your Lordship, there is may I read, Your Lordship? I'll read and explain. ಈ ಸಂಘದ ಚುನಾವಣೆ ಕುರಿತು ಬರ್ಮಾ ಇವರು ತಕರಾರು ಸಲ್ಲಿಸಿದ್ದಾರೆ. Person has filed objections. Burma. I will read, Your Lordship.
No.
Please, Your
The
Lordship.
whole basis is that
Please.
a complaint that is given by the unofficial respondent is the whole reason for
Please.
initiating this inquiry.
Please, Your Lordship.
Which he cannot do.
But on his own also he can do, Your Lordship.
It is not, if it is on his own motion, he wouldn't have said about that.
I'll just read, Your Lordship. And ಗೌರವಾನ್ವಿತ so and so ನ್ಯಾಯಾಲಯ ದಾಖಲಾದ OS 824 OS has been filed, Your Lordship. ಅದರ ಆದೇಶದಂತೆ 6 ತಿಂಗಳ ಒಳಗಾಗಿ ನಿವೃತ್ತಿ ಹೊಂದಿದ ಉಪನಿಬಂಧಕರ ಹುದ್ದೆಯ ಒಬ್ಬ ಅಧಿಕಾರಿ.
Identical matter, not considered, not section 25 and stayed, not the order passed by the lords. Another case, not also not identical.
Please come. Then counsel for the petitioner submits that. That the second respondent, at the basing on the complaint given by
Fourth respondent
has initiated the
appointed the third respondent
respondent as inquiry
Inquiry
officer under section
25 of not Karnataka Society Registration Act.
5 of the Karnataka Societies Registration Act 1960. It is submitted that earlier the fourth respondent has filed a writ petition questioning the, where is that?
Not page 40 annexure E.
Questioning the voters list.
And also sought for inquiry, my lord.
Also sought for inquiry about the voters list of the election board or management dated 30/11/2025. That writ petition came to be disposed of by order dated 17th November 2025, wherein The coordinate bench of this court has observed that
Reserving liberty to the petitioner to file election petition, para 4, my lord. Page 46.
reserving the liberty to the petitioners therein to file an election petition if there are so, if they are so aggrieved, accordingly disposed of. After that, the fourth respondent has given a complaint to the second respondent. Basing on that, the second respondent has appointed the third respondent. It is a contention of the then counsel for the petitioner that basing on the complaint of the fourth respondent, appointing the third respondent as an inquiry officer under section 25 is appointing the inquiry officer is contrary to section 25 of the Karnataka Societies Registration Act. It is submitted that as per the same, the registrar on his motion or on the application of the majority of the members of the governing body or of not less than 1/3 of the members of the society can hold an inquiry. In this case, one single member, that is the fourth respondent, has given a complaint, and the second respondent ought not to have initiated the proceedings under section 25 of the Act. Let HCGP takes notice on behalf of respondent 1 and 2. It is submitted that though the section 25 is very clear that the registrar on his own motion also can conduct an inquiry. As such, there is no illegality with the order. Next paragraph. The submission of the HCGP, this court finds no force, as the impugned order clearly says that the subject in the said the order is pertaining to, refers to the complaint given by the fourth respondent. It has to be presumed that the inquiry officer is appointed based on the complaint of the fourth respondent, which the second respondent which the second respondent cannot conduct the inquiry under 2025 of the so-and-so Act. Accordingly, they shall be stay of all further proceedings. So-and-so.
Your Worship, one more submission, if at all, with
The respondent.
it is instead of interim order, Your Lordship, if opportunity is given and
But we can't, because the official
respondent
complainant is there, notice has to go.
Page much.
Yes.
Preliminary hearing B group matter, seal number 83 adjourned, seal number 84. Jagdish Patil, 84.
You there?
Ms. Kini.
For the respondent, my lords, may be permitted.
Short
to-
accommodation.
Even on the last occasion also, there was no representation on your behalf.
Yes.
What is this matter about?
Punishment order which is
Any interim order in this?
no,
No, sir.
This is matter after 4 weeks.
please.
4 weeks.
Seal number
Yes, next.
85. Narayanji Risalkar, 85. Sangram S. Kulkarni.
My lord, I am for the petitioner. This is a petition by way of appeal under GST Act, my lord. Because the Karnataka Appellate Tribunal is not yet constituted over the Appellate Tribunal. Therefore, after passing the order by the Appellate Authority under Section 8, we file the writ petitions here, which are considered as an appeal, my lord. In this case, the facts of the case, my lord, is a very,
Put the memo in this.
pardon,
Well, the
This is
petitioner has,
84.
I am the petitioner and appellant in this case.
No, you have moved the memo.
yes, or he can't hear.
Yes, Your Honor.
What is urgency?
Urgency is, my lord, what has happened is a small dealer in the appeal was partially allowed. Appeal was almost partially allowed, and illegal excess tax collected on some other provision has been ordered to be refunded. and he put application as per the procedure for refund. Then they did not delay the refund.
No, that is on the merits of the matter. I am on the urgency. What is the urgency to move a memo?
My lord, it is 2021 matter. And my views, they have collected the 12 lakh rupees. It is pending with them. They have not refunded.
Come to the order.
My
Come
lord,
to the order.
My lord, I have been appointed as amicus curiae in this case, but on what point I am supposed to assist this honorable court is not made clear, my lord. Because if that is made,
Whatever point he raises.
yes.
Yes.
Yes, my lord. My lord, briefly to tell the facts of the case. He is a small dealer in groundnut seeds, my lord, in the particular Gangavati
First
place.
of all, let us look at the order that is impugned in this report.
Yeah, simple. Yes, my lord. At page number, my lord. Annexure D, my lord, page 49. Order under section 107 of the KPI Act, my lord.
So it has fixed at 1,20,000.
Pardon?
1,20,000.
Yes, yes, my lord. 1,20,000 has been given, but in the appeal order, all the allegations made in the penalty order have been negatived because I produced the books of accounts and invoice raised is under 3BR. That is, unless 3BR is posted, no invoice can be generated because in GST, that is automatic system. Only the authorities, despite giving a driver who is from North India, whose language is not known, they collected the invoice. Only defect was e-way bill was not generated because it was a midnight. He's a small dealer and penalty was given on the basis that no ownership was proved. the ownership cannot be proved by that person because he did not issue notice to either consignor or consignee or transporter, my lord.
Yes, my lord, as far as the appeal that is decided is concerned, my lord, the relief was given to the petitioner against, after the disposal of the appeal, there is an order which has been passed by the Honorable High Court of Karnataka in the case of Mangalji Electricals versus State of Karnataka. My lord, page 71 may kindly be seen. My lord, the department has initiated revisional proceedings under section 108. And on page 71, the Honorable High Court of Karnataka in STRP 47 in the case of Mangalji Electricals versus State of Karnataka have held that when no explanation is offered as to the non-production of the documents at the time of check of the vehicle, later production of documents with explanation would not be a remedy. My lord, by taking into consideration this aspect, the department has initiated the proceedings under section 108, which is a revisional power which is given to the department. And these proceedings are independent than to the appeal proceedings, my lord. And as submitted by my learned counsel saying that no tribunal is yet established. So the remedy which is available with the department to revise its own order, which is prejudicial to the interest of the revenue, that cannot be called in question, my lord. So as far as the department is relying on the judgment of the Honorable High Court, and nothing can be found fault with. And
That's not the impugned order.
my lord, they are now saying that refund order was passed, and thereafter, instead of refunding the order, they have initiated 108 proceedings, and that should be stayed. That is their case.
Yeah, now let's see the prayer. What is the prayer?
The prayer, they have not made any prayer regarding.
Impugned appeal order dated 28/1/2021. This is the order 28/1/2021.
Yes, it is an appeal, my lord.
It is in appeal.
During the pendency, they raised a section revision notice also, which is banned under the section 108.
At page 49.
Page 49. My lord, subsequent to that order, the department has already initiated proceedings under 109 because these proceedings are initiated on 3/9/2021. That is subsequent to the order passed, impugned order is 28th January 2020.
Not question.
This is not question.
No, my lord. It is not question means interim prayer may kindly look into.
No, without questioning the.
How can there be an interim prayer beyond the final prayer?
My lord, my main prayer is setting aside the very appeal order itself, partially allowed. I am seeking entire order is illegal. Then there is no question of partial.
Independent order.
Huh?
This is an independent order as it is.
No independent order, my lord. Under section 18 is perhaps is a wrong impression. Section 108 of the revision powers may kindly be looked into. He should not have told being a amicus curiae.
No.
108, I will read, my lord. What has happened, I filed an appeal. During the appeal has been filed under section 107. When there is no appellate tribunal, this honorable court has a precedent to accept the writ by way of appeal. This appeal is pending, challenging the very penalty order, very appeal order fully. Then they initiate revision power.
This also has to be questioned.
But,
This also has to be questioned.
You have to question that order also.
That revision order has not been passed. Only notice has been initiated.
You should go before that. We will not interfere with that.
No, my lord, 108, I will read it. Section 108.
We will see not.
No, it is a banned, my lord. When appeal is pending, no revision can be taken place. I don't know. My learned friend would have seen 100 section 181.
Yes.
Yes.
March 4th.
Yes.
Seal number 86. Ageshri and.
Yes.
Tanvi.
For the respondent, 3 more, Lord.
The writ petitions are filed by the management bank, my lords. We are seeking quashing of the orders passed by respondent number 1 and 2 produced at annexures C and D, my lords. That's due to certain credit irregularities committed by.
The order dated 15/11/2021.
Page 33.
My lords, 15/11/2020 at Annexure C, my lords, page 33. My lords.
This is the order question.
And Annexure D, my lords, that is confirmed by the respond number 1. Annexure C is passed by respond number 2.
Where is that order, the next order?
Annexure D, my lords, page number 43.
Let's see this order.
Please. My lords, the point involved in this, my lords, is the delayed payment of interest on gratuity, my lords, is the question.
Let's
Please,
read and understand what it is.
please.
Come to paragraph 8.
Please. Page number 47. The respondent employee joined the services of the appellant on 2/9/1984 and retired on 13/12/2019. As could be seen from the documents placed before me, the respondent employee retired from the services of the bank with effect from 31/12/2019. Just the day before his retirement, a charge sheet was issued to him for the alleged charges of certain omissions and commissions committed by him. In the meantime, the respondent employee is retired and the inquiry proceedings continued as if he continued in service as per the regulation 45 of the bank's rules. The inquiry concluded on 22/10/2021. The respondent employee filed form number N application dated 11/8/2020 before the controlling authority and ALC, Mangalore. On the directions of the CA and ALC, Mangalore, the gratuity amount was remitted to the account of the respondent employee on 26/7/2021.
Yes.
It could also be seen from the documents placed before me that the appellant contends that the basic pay of the respondent has been reduced from rupees 71,800 to rupees 67,820 with DA component of rupees 11,346.29. Whereas the CA and ALC Mangalore in his order at page 4 states that the amount of rupees 87,434.19 was claimed in form N by the respondent has not been countered, rather failed to counter by the appellant management before the CA and ALC Mangalore. This authority is of the view that the appellant now cannot portray the issue of last wages drawn before this appellate authority, and hence it shall not be taken into cognizance and is liable to be rejected. Therefore, for all practical purposes, the last drawn wages has been taken as rupees 87,434.19, which is inclusive of the DA, and he is eligible for gratuity of rupees 17,65,498. The appellant bank has already paid rupees 16,92,361 towards the gratuity.
Yes, I've seen this.
Please. For 35 years, my lords, remaining is the calculation. Now, my lords, against this point, my lords, regarding the gratuity or delayed period, interest was imposed, my lords, by the authorities. On that point, my lords, there was a writ appeal judgment against the management. I'm submitting whatever, honestly, my lords, because again, we went for SLP before the Supreme Court, wherein by keeping in question a question of law pending, the SLPs were also dismissed. And now the bank has filed a curative petition, my lords, is what the current status. And yet,
They are entitled for interest on that delayed payment. Of
please,
gratuity.
please, please.
Where is that division bench judgment?
My
I
lords, they
produced it
have
before.
produced it in that.
And at 15 April 2020, along with memo, my lord.
Memo.
Please, ma'am. Memo for disposal I filed. The first page number, 2 is the writ petition order, and writ appeal order is at page number 21.
Where do you get that? 21.
21, that is the writ appeal order, my lord. And concluded by the apex court, that is page number 42, my lord. And division bench is clearly stated at page number 40, my lord. That is explanation of regulation 25 would empower the appellant bank to the withhold the gratuity during the pendency of till completion of disciplinary proceedings. And it also mandate the appellant bank to release the gratuity immediately on completion of disciplinary proceedings. But it
So
would,
here in this case,
please,
is entitled for interest from 31/12/2019 to 26/7/2021.
Please, Manoj. On rupees 16 lakh 92,000.
On rupees?
16 lakhs 92,361.
calculation at page number 40, my lord, in the petition, my lord. The order portion 40.
40.
Petition, in the petition, my lord.
Order passed by the respond number 2, my lords. Annexure C, only page 40, they have given the calculation.
The application is allowed to extend that the applicant shall be entitled for payment of difference gratuity of.
Payment of differential
Please,
gratuity of
Worship.
rupees 73.
Yeah, 73,130.
7 in
Please,
addition to the gratuity amount of. The
Which is
applicant
already
shall
settled.
entitled to
The
payment of
calculation is,
10% simple interest
yes,
for the 10% on delay of 573 days.
please, Mr.
Gratuity. It comes to 2,65,667.
Please,
0.49.
please.
Yes.
Yes, my lords. My lords, my now contention is that curative petitions are
Petition is
pending before the
pending.
Supreme Court.
Yes.
And that is
What
because,
are these 3 petitions, 3 different
Yes.
employees?
please, my lords,
Yes,
three different.
As I calculated, my lord,
Hmm.
as per my calculation,
No, it must have been there in the earlier, all orders.
please.
Please,
Uh,
my lord,
is-
separate orders
is-
have been.
Separate orders
Separate
there.
order is better
Yes.
without any confusion.
Please,
The Karnataka Vikas Gramin Bank is before this court questioning the order dated 15/11/2021 passed by the respondent number 1 and which has been affirmed by the appellate authority by order dated 27/3/2023. The 23, the petition is before the court. As per the order dated 15th November 2021, the order, the operative portion of the order dated 15th November 2021 reads thus at page number 40. Page number 40, extract that order. This order was challenged before the appellate authority under Payment of Gratuity Act and by order dated 27/3/2023, the same was affirmed. Land counsel appearing for the petitioner submits that they're not, the petitioner, the respondent is not entitled for interest on the delayed payment of gratuity. And they have already stated what was the reason for the delayed remittance of the gratuity amount.
My lords, because disciplinary proceedings were
As the
pending.
disciplinary proceedings are pending against the respondent. However, the land counsel of the petitioner does not dispute the fact that the writ appeal and the SLP that is filed by the petitioner bank is dismissed. It is submitted that they have filed a curative petition and the same is pending consideration. In that view of the matter, till the curative petition is heard by the apex court, this matter may be adjourned.
Please.
Land counsel appearing for the respondent submits that in the light of the judgment passed by a coordinate bench of this court, which is affirmed, and the SLP is filed by them. That is in WP number 111099 of 2019 and batch dated 6th July 2021. The petitioner is entitled for the interest and this petition is pending from the year 2023. Yes. It is submitted that in the light of the, it is submitted that the writ petition is liable to be dismissed next para.
A coordinate bench of this court in WP number so and so and batch has held that the employer is entitled. The employee would be, the employer would be liable to pay the interest on the gratuity amount, which has been affirmed till the Honorable Apex Court. However, pending curative petition cannot be the consideration for this court not to hear this matter. In view of the orders passed in the writ petition, the number so and so, the petition filed by the employer Karnataka Gramin Bank cannot be considered, and the same is dismissed, affirming the orders dated 15/3/2021 to and so and so. Now you have not deposited till now.
My lords, we have already paid him the amount of rupees 16,92,000 and we had deposited before the
You have
respondent.
already deposited that amount,
Please, my lords.
that interest amount.
Please, because without depositing, they will not consider my appeal before
In
the controlling authority.
accordingly dismissed. Next matter. Orders are also same, dates are also same in the.
Same,
No,
same.
my lords,
Different,
different orders, my lords, annexures are not
Only the
same.
dates will change.
synopsis.
Dates and the amount might also differ, my lords, because the last.
So, The writ petition is filed by the Karnataka because Gramin Bank questioning the
Same day order.
Same day order.
same order, I think this is
Please.
15/11/2020.
Please.
Please, my lords. Only that amount might.
Amount
differ,
is
my lords.
different, yeah.
That,
So and so, same orders are also same. Where is the first order?
At annexure C, my lords.
The
Annexure C.
ordered as per order, the order dated 15th November 20, the operative portion of the order dated 15th November 2021 reads as, that is at page 43,
Please.
which is affirmed by the appellate authority. So, yeah, remaining are all same. What about the next one? That also same?
Same.
In the next.
Annexure
At page
C is
number-
the,
Have to
Annexure C.
extract the primary authority.
Page number
order.
44.
That's it. Remaining are all one and the same. Yes, accordingly, all these writ petitions are dismissed.
please.
Yes, 87.
87,
Oblan.
number 87.
Lords, petitioner is assailing the award passed by the labor court in Karnataka Industrial Disputes, wherein a termination order as against the petitioner came to be challenged before the labor court. For a moment, LCRs may be produced. LCR, trial court records.
It's there.
It's there now. TCRs have been received.
It's there.
Exhibit R2, my lords, termination order.
We'll see some other day. No time for the final hearing.
Lord,
This matter.
for 4 weeks adjournment. Why? Because I'm supposed to, most of the exhibits are in vernacular, my lords.
But you moved the memo,
Yes,
what
my
to
lords.
do? That's why the matter is listed.
Yeah,
you
yes,
know.
my lords. I'm supposed to file the
Yes, list this matter in the month of March.
March.
Yes.
Seal number 88. RH Changdi.
Wife and daughter are before this honorable court, challenging the order of interim maintenance, where my lordship, the trial court has awarded the rupees 7,000.
On submission, my lord. The petitioner had filed the 498 before the Kotal number 4. That was posted for 97.
It is posted on 3/2, my lord.
3/2.
For settlement, my lord.
List
I
this
can
matter.
request on 3/2.
List this matter on 19th of February.
Please.
Seal number 89. Seal number 89. Sanket Sankara Pambli. PL
The
Patil,
respondent number
B.
2
Mohammed Ali.
institute is a Waqf institution. It's not a general Waqf institution. In fact, it is a union of Waqf, all the Waqfs in its locality. There is a collective participation and it is managed by a managing committee of 52 members. And there are several other standing committees later appointed in a different fashion, my lords. My lady may directly have page 24.
I seek
Or-
a week's time to file statement. of
Please have
objections.
March 2025 order.
I seek week's time to file statement of objections to this. petition.
I will also be filing
When
statement
did you
of.
file wakalat?
We have filed local.
No, when was the wakalat filed?
Please see the order of March 2025. Two more adjournments, the term will be over. 4 March 2025.
Then council seeks 2 weeks' time to file statement of objections. That is as long as back on
Yes.
21/2025.
If not filed, will be taken as nil. That is recorded.
Objections to be filed, but then again 4/3/2025, 23/8/2025.
Order says if not filed, it will be taken as nil. And the case is open and shut.
Next week only, within a week's time, I will file. Let it be there.
Does this matter on 17th?
May I please place the grievance? That doesn't require their objections
Does
also.
this matter on 17th?
Great.
The request of the respondent, no further time will be granted. Yes.
Number
93.
90, adjourn till number 91.
91 may also be kindly listed with the same matter.
Along
Please.
with that.
Great.
17 February. Seal number 92. Regard DB.
May I please? And for the petition. My lord, at the outset, I would like to bring my lord's attention to Annexure A. Annexure A is the notification issued by the respondent number 3. It is at page number 21, my lords. Annexure A is the notification issued by the respondent number 2, inviting an application from the eligible candidates.
Come to this order of 25/1/2024.
25/1/21.
2024.
Annexure N, my lords.
Page number?
Page number 47, my lords. 49. The written order.
This is in Kannada.
Yes, ma'am, it is in Kannada.
Before that, my lord.
Ma-
The direction by the Honorable Court dated 8/9/2025. The fact is, my lords, he being a my lords, one of the member of the society, holds my lords 3 shops, 3 fair shops. That has been directed to the government advocate. Whether the my lords being a president of the society, having right to my lords hold more than my lords 1 shop. That was the direction to get the instruction. But it is not permissible.
What is your grievance?
My lords, let me submit before this honorable the brief facts which leads to file this petition. That's why I would like to bring my lord's attention to Annexure A, my lords. So I may kindly be permitted to submit. My lords, respondent number 2 hearing has published the notification inviting an application from the eligible candidates for the post of, that is, to distribute the fair price shop license to be given. My lords, in the notification, it is clearly mentioned that who are eligible to file an application. My lords, it is very clear that Rajya Sarkari Swamitva Nigamagalu like that, and the Sahakara Sanghagalu, cooperative societies, and the others, my lords. In this way, they can file. In this case, the petitioner is one person who is the president of the cooperative society, who is running the fair price shop. 1 point. Second point is that the respondent number 6 is also one of the candidate who has filed an application, and other 2 persons have been filed an application on the basis of this notification, my lords. My lords, in the page number 23, it is very clear. It is very clear that those who have applied for the said post, so they must file the SSLC passing certificate. My lords, in this case, the respondent number 6 herein has not complied with the notification, my lords. He has not completed the SSLC, not passed the SSLC. He has just passed the 7th standard, my lords. So his statement is very clear. Checklist is there. In the checklist, he has submitted, and there is also a statement of all the persons, candidates, that they, particularly says respondent number 6 is concerned, he has passed the 7th standard only. He has not completed the SSLC minors. Such being the case, the respondent number 3 has given permission or license to him to run the fair price shop minors. Being agreed by that, the petitioner is before this honorable court.
Yes, whatever instructions. Have you filed your objections?
I'll file a lot of worship objections are ready.
Which year is this petition?
One more submission, my lordship. If your
2020.
lordship permits me,
25.
one more submission is there, my lords.
This is very
Worship,
simple
as per
issue.
instructions, your lordship.
Whether the 6th respondent
He is
is, whether his, the eligibility criteria, whether he is matching up to that or not, is the
Your
only question. One simple instruction from you.
Your lordship, he has, as per
From your
instructions,
client.
your lordship, 10th, he has passed a clear 10th SSLC also, certificate is there. And that 80%
If it is there,
disability.
you can place before the court. That's the only thing. Please. If it is, if he has, if he passed 10th, the petition is out of court. Please.
That all has been done, my lords. That all has been done. It has been submitted.
Done.
It has been submitted, and thereafter only 8, 9 minutes, there was a direction.
Certificate is already placed before the court.
It is in the, along with the Miller's writ petition, they have, their contention is that, Miller, I have passed the SSLC,
You are
but
the 6th respondent.
that's it, sir. I have passed the SSLC, but that SSLC marks card was obtained by way of Open University. That is the contention is. That is not the Miller's fair contention. Because of that submission, the sum court had directed to instruct the Miller's the whatever that regarding Miller's dispute. That has been got the instruction, and instruction was placed before this. Thereafter, Miller's 8/9/2025, there is a further direction by the Salva court saying that Miller, whatever the contention is regarding Miller, the obtaining of fair pay shop, whether this person petitioner being a president of one society, holding already 3 shops, another shop they are claiming.
That is beyond the scope of the petition. Why should we go into all
No,
that?
no, that is what the Miller's.
Your appointment.
That has been.
No, why should we pass?
No, I have placed in my honor's objections.
Where is your certificate?
Certificates he has produced.
Page number 38, your lordship. He
38,
himself, petition itself, your lordship.
Page number 38, my lords, is the is the 7th standard certificate. My lord, my respect submission before the court is that when there is a notification fixing the SSLC, that's only one point, sir. This respondent number 6 has filed an application only with the 7th standard mass card. After 1 or 2 months, he has produced the SSC mass card, my lords.
When is it? When he has passed 10th?
Yes, my lords, this is the certificate, my lords. And
Passed, when he passed 10th.
he has passed in the
2016.
April 2016. When is the notification?
notification is up to 2021.
Please come.
1 month,
Yes.
one more submission, ma'am. My lords, when the petitioner has submitted an objection as far as his appointment is concerned, that is giving a license to him to run the fair pay sale, then the concerned authorities, respondent number 2, respondent number 3, they have given a letter, addressed the letter to the other persons to consider whether it is genuine or not and submit the report as far as that genuineness is concerned. But the SSLC and the Hadar Madhar, it is not equivalent to the SSLC, my lords. I would like to bring my lord attention to.
We will not go into all those aspects. If you have any other grievance other than the prayer that you sought, it is open for you to, what is the prayer? Come to the prayer and read.
Please, my lords.
Yes.
My prayer is that the necessary order or direction or writ in the nature of certiorari may kindly be passed and thereby set aside the impugned order or proceedings issued by the respondent number 3. Respondent number 3 on dated 25/1/2024, bearing its number so and so 23/21/22 wide annexure N, and thereby granted permission or license to the respondent number 6 to run the fair price shop at so and so village. This is one prayer. Second prayer is that the necessary order or direction or writ in the nature of the mandamus may kindly be issued, and thereby direction may kindly be given to the respondent number 3 to cancel the license because the respondent number 6 is not a competent and eligible candidate, and the same license may kindly be given or issued to the petitioner's society.
Please come. The present
And,
report is filed, seeking the following prayer. It is a case of the petitioner that the respondent number 2 has issued a notification on 2012-2021 inviting application from the eligible candidates to allot the fair price shop with some conditions in respect of the Hire Hadligi village of Ballari Taluk and district. Basing on that, the petitioner, the official respondent herein, and some others have submitted their applications. It stated that on 22/4/2022, all the 4 candidates have given the statement stating about the particulars furnished while filing an application for allotment of the license to run fair price shop. On 19/9/2022, the respondent number 2 has written a letter to the Karnataka Primary Education Examination Board, Bangalore, requesting to review the marks cards of SSLC produced by respondent number 6 and submit the report about the genuineness of the marks card. On 19/10/2022, the Assistant Director has written a letter addressing to the respondent number 2, given the report. According to the petitioner, the second respondent has granted license to the
Sixth,
which respondent you are?
sixth respondent.
To the 6th respondent to run the fair price shop. It is a contention that as per the notice, a person should have completed, should have the qualification of SSLC. According to the petitioner, the 6th respondent has completed only his 7th standard. As he is ineligible, he is not entitled, he cannot be appointed as a fair price shop dealer. In this regard, they have also given a representation to the respondents. The respondents have failed to consider the representation, and which made the petitioner to come before this court by filing the petition. Expert. The 6th respondent, after notice, the 6th respondent had appeared before this court and also placed before the court the marks card to show that he has passed the SSLC exam in the year 2016 itself. Then counsel for the petitioner has raised the respondent thing. It is submitted that the respondent is.
Sorry for the interruption, my lords. The SSLC certificate which is produced by the respondent number 6 is not a genuine. It will not be equivalent to that of the SSLC, my lords.
Who told that?
Yes, it is there, my lords. I would like to bring my lord's attention to.
It is not so.
The page number 46, my lords.
The notification says that the exam should be, it's not, the exam, the certificate should have been given by so and so.
No, ma'am, the notification is very clear that the candidate has to complete SSLC, my lords. It's my submission. It's there in the notification issued by this.
What is this certificate?
My lords, page number 46 may kindly be seen.
Yes.
So,
Not this.
ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ನೃಪತುಂಗ ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ, that is the SSLC board has given its opinion that the certificate which is produced by the respondent number 6 is not the equivalent to that of the SSLC. They have not completed SSLC.
See the certificate
Pardon, my lords.
Let us see the certificate again.
Please, my lords. Karnataka State Open Education Examination Board. This certificate has been sent to different authorities, concerned authorities by the respondent number 2, my lords. They have not examined it. They have not given any opinion.
To the the eligibility criteria. Where is that?
That is page number 23, my lords. In the notification, it is very clear, my lords. The first one is the candidate has to submit SSLC and he must pass. SSLC uttirana agirabeku. Here, my lords, my submission is that if the respondent number 6 had completed the SSLC when the notification was issued, who prevented them to submit along with the application the SSLC mass card? And he has given a statement. He has given a statement also.
You are making two different statements. Either you have to stick to this or to that. First of all, either you have to accept or submit that the certificate that is produced by him is as per the qualification as set out in the notification or not. If that is the case, when you are not accepting that this is
not a genuine one, my lords.
Not genuine.
Not genuine one.
Who said that it is not a genuine one?
That's why I have given objections to the concerned authorities, my lords. He has not passed because he is my native place. He is the resident of our own village. I know him very well since his birth. ನಾವಿಬ್ರು ಸ್ನೇಹಿತರು ಅಥವಾ ಒಂದು ಊರಿನ ಇರೋರು. ಅವನು SSC 7ನೇ ಅಷ್ಟೇ ಪಾಸ್ ಆಗಿದ್ದಾನೆ. He has not completed even SSLC. 7th ಪಾಸ್ ಆಗೋದು ಅವ್ನು ಲಗಾಟ ಹೊಡೆದಿದ್ದಾಗಿದ್ದಾನೆ ಮೇಡಮ್. ಸಾಕಾಗಿ ಹೋಗಿದ್ದು. ಕನ್ನಡ ಬರು. Oh, sorry, my lords. Yes, ma'am. My submission is that, my lords.
Because I'm not able to understand your submissions because you are taking A, B, C, D, E, so many alternative submissions you are making. You have to clarify yourself.
Please, first, ma'am. So
whether this certificate that is issued by the Open University doesn't amount to SSLC.
Equivalent to SSLC. This is the remarks given by the SSLC board.
That's what, if that is the case, why should you say he has not studied? This is not genuine.
Please.
Genuine or not?
Oh, sorry, my lords. Sorry, my lords. Yes, ma'am.
Why I'm not able to understand why you don't people file any counters in any objections in any of the petitions. Not even one I have seen the state filing the objections. Why? When the state is a contesting party. Please, Your Lordship. No, what is the procedure here? What happens is the moment you have the papers are served, you should call your officer and he should give you he should file the objections within at least 2 weeks, 3 weeks. From the last 1 week, in all the writ petitions I have seen, not even in one writ petition there are objections by the government. Why?
Used to file.
Where is your AAG? Ask him to come. Ask him to come.
Please. We used to file.
It is not like without filing any objections, without filing anything, everybody comes up with a order covered matter. And we are unnecessarily creating litigation by passing these kind of orders. In writ petition, state is a party. The moment the papers are filed, you should send it to them. Within a week, they should send you the objections and you should file before the court, irrespective of whatever is the outcome. It's very strange. No, this is an issue, simple issue. Your officer should have filed the objections by this time. How many times this matter has come up? Why should the court pass these many orders in this? Ask AAG to come.
Along with my objections, my lords, I have filed the whatever that contention certificate.
Pass over. Ask AAG to come.
Pass.
Yes.
92 pass or number 93. Jagdish Patil. Surabhi Kulkarni. Sanjay Chan.
No, I seek week of accommodation. Please, since
Does this matter in the month of March?
please.
Yes.
Number 84. Sorry, 94. Ashikar Gunj.
Petition.
84. Chetan Murwali.
Yes.
See, a short for Malad, mandamus directing the Malad respondent to Malad. They have issued the Malad Sokas notice to the Malad respond number 3 and 4. Till today, they have not taken any action to Malad. Wherein Malad respond number 3 and 4, without
What is this criminal action? Why should they take criminal action?
here Malad, as per the section 61 of the Irrigation Act,
Let's
if
see.
anybody Malad obstruct the Malad flowing of the water Malad through proper channel.
Act, irrigation.
Please Malad. Karnataka Irrigation Act.
Under which provision?
Provision. Sir, provision.
Please, 61 Malad.
Power to remove obstruction or damage to work.
Please. Any person in charge of employed upon any irrigation work may remove from the land or buildings belonging to thereto, or may take into custody without a warrant.
Yes, what
And with-
are your instructions?
Notes, in this case, what has happened is, notes, this is a field channel. The issue is with regard to field channel. Notes, may I request to take up the sketch, my lords, at annexure, page number 13, my lords, sketch.
Annexure A is also Malad.
Yes.
Notes here, there are two lines, my lords. May I? This portion. This is, my lords, field channel. This is main canal. This canal is, my lords, maintained by us, KNNL. But this field channel is, my lords, constructed and maintained by CADA, Command Area Development Authority. They are, my lords, looking after this.
You have nothing to do with the.
I'm not nothing to do with this field channel. However,
Obstruction is with the field channel.
obstruction is with the field channel by the adjacent land owner. What has happened is, my lords, in the plan, this field channel diverts here. But in actual, this goes like this, my lords. They are using like this from many years. However, though, my lords, it is not belongs to us, previous officer has conducted the survey and opined that from last 30 years, channel is being used like that only. But however, it is as per this plan. And he had issued notice in the year 2023. Thereafter,
His representation is when?
there is no representation. He is, my lord, seeking mandamus based on this annexure E, my lords.
Oh, you are not, are you
Based
not-
on my representation, they have in spot inspection was done and Shokas notice was issued.
When was your representation?
2/7/2023.
2/7?
Annexure in D and E.
No, 2/7/2023. To whom
Please,
you have
please.
given the representation?
Please, Malad.
To the?
To the Malad, Karnataka Niravari Nigama, Malad, assistant executive engineer.
Then what happened there?
Malad, they have spot inspected the Malad and submitted the report. Thereafter, Malad, they have issued the Shokas notice to the respond number 3 and 4 as per annexure D and E. Wherein, Malad, they are D and E, Malad. Page 70, 18 and.
Then what happened after that?
Thereafter, Malad, they have not taken any action.
Show cause notice.
Malad, it is on 12/7/2023.
You find your objections?
No,
But I have
Malad, they
to
have
file,
not
my lords.
filed.
I have to file. And civil suit is pending in this, in respect
Although
of this very channel.
It was dismissed, Malad, since Malad.
At least after, at least 2-3 weeks, after the writ petition is, the papers are received, objections needs to be filed.
Apologies.
This is matter on February 25th. By the time the respondent shall file objections, or else basing on the material on record, order shall be passed.
Please.
Number 95, Narayan Kumar. Nayana Kumar. Malkar Swami, Badnaam.
In this matter, my lord, I'm appearing for the petitioner. The petitioner in the year 1991 had set up a trust under the BPT Act. And under the trust, he was running 4 schools.
Let me look at your prayer.
Yes,
Please
ma'am.
come to the prayer.
Prayer is page number 26.
Permission to renew the society.
Respondent number 9, who is respondent
Registrar
number
of
9?
Societies, my lord. Deputy Registrar of Cooperative Societies.
Hmm.
Now, what has happened in this matter, my lord? From the year 1991 till date, the
Cooperative Societies Act, please give the act.
On submission, my lord. In this, my lord, trust is registered under the Societies Registration Act, my lord. Since, my lord, there is an alternative remedy is to be the petitioner to file a suit, my lord. Section 15 of the, my lord, Cooperative Societies Registration Act, my lord. He claiming as a president, my lord, but he is not a president, my lord. Earlier, his wife is president, my lord.
See, under which provision this order is passed?
Please, ma'am.
Which provision?
My lord, section 27 clause 2, that order has been
7. Let me look at it.
My lord. The trust was registered under the BPT Act.
Let's see
My lord.
what it is.
Kindly say
Before
section 15,
going,
my lord.
before going into the question, my lord, after the repeal of the BPT Act in the year 2005, government issued a circular directing that all the institutions, charitable and education institutions registered under the prior BPT Act would be governed by a circular. That and all the organizations were brought under the Charitable Endowments Act 2007. 2007.
Why, how can everything be brought under?
It was brought under the circular is passed, my lord. Yes, Charitable and Endowments Act 2007. It was brought under that particular act. Thereafter, in the 2010, a society was formed with the name of the trust, and that society was lying dormant from the 2010 to 2025. Few of the members of the trust tendered their resignation. Their resignations were accepted. Later, they went outside and tried to.
Whatever it is,
Yes.
you're questioning an order passed by an authority.
Yes.
Under which provision?
Yes, my lord. But the issue is not with regard to that, my lord. The main issue in this petition is that once the BPT Act is repealed, the respondents contend that the trust ceases to exist. And they claim that now they have formed a society. The society was formed in the year 2010. It was lying dormant. In the year 2025, they revived the society using false and fabricated documents. All AGM reports and audit reports were fabricated.
Problem is, if you answer my query, I will be able to understand the case.
Yes, ma'am, please.
So
Please.
now you're questioning an order dated 15/4/2020.
Yes.
Isn't it?
Yes.
That is passed by the authority under
Yes.
which provision of the act?
Yes.
That I want to know.
Page number 121.
Section 13 of the, my lord,
Section?
13 of the Societies Registration Act, my lord. It is renewed, my lord.
Let's look at this.
Yes.
Annexure P is the, my lord,
Karnataka Societies Registration Act, section 30.
13, under
13,
13 it is, my lord,
13 or 30?
13, my lord.
I don't think it is 13. It's balance sheet and annual list of governing
Please,
body. to be
kindly
filed.
see, my lord, annexure P is in the Kannada version, my lord.
121, page number 121, Your Lordship.
121 of it is
Petition.
Particular section is not mentioned in that particular order, madam.
No, it
My
is
lord,
not mentioned.
It is not mentioned.
If they register it under some
Yes.
provision of that, there should be some source of power.
Yes.
Where is it? That's what I'm
My
asking.
lord, is, my lord, he is seeking, my lord, cancellation, my lord. If cancellation is there, my lord, under section 27 clause 2 of the Karnataka Societies Registration Act, my lord, he has to file an appeal before the EAT, my lord. Section 27, my lord, cancellation of registration. Clause 3, my lord. He given an application before the registrar for conducting the inquiry, my lord. He has replied that you are not the president of the said society. He has given a reply, my lord. That has not been produced by the petitioner, my lord. Section 27, my lord, cancellation of registration. Clause 2, my lord. Clause 2 and clause 3, my lord. This renewal is passed by the registrar, my lord.
My lord.
Yes, no,
Yes,
please support.
Sorry, my lord. Madam.
You already given one judgment.
Oh, that is, yes, sorry. In this judgment squarely covers the issue in this petition, my lord. Kindly turn to page number 17. So division coordinate bench order.
Forget about the judgments.
Yes.
First, you have to be clear on facts.
Yes.
According to you.
The issue in this petition is whether two entities can be registered using the same name. The first trust was registered in the year 1991. Using the same name, another society came to existence.
If you say that all those words, what you are submitting now,
Yes.
point out from your petition.
Yes, it is there.
And what is your representation to the authorities? You say
Yes.
somebody
I
else
have
is
I
going
have
to
made
give
two
you-
representation to the authority. One was made on page number 10. It's in Kannada, my lord, wherein I have I made a representation to the registered society not to revive the society using the name of the trust. Let them register the society with a different name, but not using the name of the trust. That will again, what they are doing is now the society is revived. Now they are claiming ownership over the assets and the schools run by the trust, and they're causing interference in the affairs of the trust.
You say respondent number 9 granting permission to renew the society bearing registration.
Yes.
That's what is the relief you are seeking.
Yes, the order which is passed, I have sought to quash the order in this petition, and in the interim prayer, I have sought to stay the operation of that order. And using that order, now they have passed one more order stating that now directing the respondent number 1 to 4 to take over the management of one of the schools run by the trust. Now they are causing a lot of nuisance and issues to the president and the members of the trust who are running the schools. And the schools were set up by the petitioner using his hard-earned money in the 1991. For 3 decades, he has run the schools, and in 2012, the government of Karnataka.
All those things we are not
Yes.
concerned at all.
Yes.
If you are coming before this court is the only concern.
Yes. In that judgment, it is held that in section 7 of the Societies Act, kindly turn to page number
27 of the.
24. Kindly turn to section.
Section 27 also. why
Yes,
you didn't
it is
go
there, madam, but this 24 and under that section, it is the registrar that has to look into the matter. The registrar has not taken any action despite the petitioner making several representations to him. That's why we are before this honorable court.
No, if
Kindly.
registrar is not taking, you should seek a direction from this court to the registrar to act upon.
Yes, my
Why,
lord.
if the registrar is not doing something, this court
Lord.
will not take up the exercise and do it.
My lord, on submission, my lord, he is making a wrong submission, my lord. On 6/6/2025, my lord, registrar given a reply, my lord. He is to the petitioner, my lord. Petitioner is not a president, not a secretary, not a committee member.
Yes, Mr. Smarta.
My lord.
Please, my lord.
Month of March.
Please, my lord.
Yes.
Here for the respondent in this matter, my lords.
Yes.
Lord, may I kindly peruse order dated 26/9/2020.
For the petitioner to argue.
No, Lord, there was order by this honorable court, my lords, which has been not followed.
What is order?
Lord, this honorable court directed to file an affidavit in the manner which they want to pay the amount. My lord, the attachment order in the execution proceedings is called in question before this honorable court.
We will hear the matter on the merits.
Please.
Yes.
Actually, there is no contact from the party, my lords. There is no contact from the party, my lords. There are no instructions
So
as such.
that's why we will please argue on the merits of the matter. Yes.
My lords, the respondent had filed a claim petition and it was allowed and the compensation was awarded for what 21 lakhs. And later we filed an appeal and the
We will read the order. Please come to paragraph 18.
The decree holder appears to be an injured person and he has filed claim petition bearing so and so on the file of this court. The petition is allowed in part and accordingly disposed of on 24/9/2016. Perusal of the certified copy of the order in MFA so and so dated so and so, it appears that the judgment debtors or opponents are filed miscellaneous first appeal and same is allowed in part by the Honorable High Court of Karnataka Dharwad bench and the award passed by this court is modified. Now the judgment debtors are liable to pay a compensation amount of 14,39,870 with the interest as per the award passed by this court. The judgment debtor has taken the contention that the decree holder has filed petition for recovery of amount and now the present application filed for the attachment of immovable property stands in the name of judgment number 2. The judgment debtor 2 without exhausting available modes. In my view, the judgment debtor cannot insist or direct the decree holder to take a particular steps. In this case, since last 10 years, the petitioner or decree holder before this court as well as Honorable High Court seeking compensation instead of complying the order, the judgment debtor number 2 resisted the application raising objection that the decree holder has to take steps one by one modes as contemplated under CPC. It is the duty of the court to satisfy the decree or award passed as by the court by taking into consideration the mode which the applicant or decree holder is exhausted.
Yes.
I read the order, my lords. I number 3 filed under order 21 rule 54 of
Why should the court interfere? You are the judgment debtor.
Yes, my lords.
He has filed the execution. Whatever is the mode of execution, they will execute. What is wrong in it? It is a motor accident claim where he has, when was the MFA order? MFA order was on 2/7/2025. They have filed the execution. Why should we interfere? What is wrong with this?
Only in 4 days the execution was ordered, my lords. The execution was filed on 18/8/2025 and I number 3 was filed on 22/8/2025. There were settlement talks going on in the middle.
When you were enjoying the order right from when?
26/9.
So that's enough now. We will no more extend it. Please come.
Yes,
Agreed with the orders passed in I number 3. In execution 107 of 2025, by so and so. The judgment debtor is before this court. The respondent herein is filed the EP with a prayer to attach the landed properties belonging to the JDR. As a JDR is awaiting the payment of compensation amount and he is not ready to comply with the decree award passed by the court, as well as the High Court, passed by the trial court as well as the High Court in MFA number 101625 of 2017. The application filed by the decree holder is resisted by the JDR, stating that the application is not maintainable as there is no ITO evidence on record to show that the JDR has not complied the award passed by the court of law. The decree holder has filed application directly seeking attachment of the property without exhausting other available modes. Hence, the application deserves to be rejected. The court, by order impugned, had allowed the application, and while allowing the application, the court has observed that the seriousness of objection as raised by the JDR number 2 itself indicates that he is not ready to satisfy the decree. Per contra, it is the apprehension of the decree holder that the property stands in the name of the JDR number 2 is only a source for satisfying award, and same is not attached, and the property is disposed of. It will affect the right of the decree holder. The court has observed that the property now intended to attach stands in the name of the JDR number 2. If the said land is not attached, and then even the JDR number 2 disposed of, certainly it would affect the right of the decree holder. The JDR has not filed an affidavit stating that he has no such intention to transfer the property in favor of the third parties or create any right and interest of third parties, or he has no intention to create charge over the said property. And accordingly, court had allowed the application. Initially, when this matter came up before a coordinate bench, an order was passed on 26/9/2025. Extract that order. And the interim order is extended from time to time. When counsel for the petitioner submits that the client is not in touch, as such they could not file an affidavit. It is further submitted that the executing court has failed to consider the contentions raised on behalf of the JDR. And within a very short time, the execution proceedings were closed and no reasonable opportunity is given to the JDR. As such, the order impugned needs to be set aside. Next para. When counsel appearing for the respondent decree holder submits that in spite of an order passed by this court, the petitioner has not filed any affidavit. Even the trial court has also observed, the executing court has also observed about the bona fides of the petitioner. It is submitted that the petitioner, there are no grounds to interfere with the order passed by the executing court. Next para, having got the counsels on either side. There is a material on record. When a judgment and decree is passed, the judgment, when the judge and the same has attained finality, it's the duty of the judgment debtor to honor the decree. He cannot find fault with any application that is filed by the decree holder. No law specifies that first the petitioner has to execute, has to exhaust one remedy, and then has to come before, has to take up the other remedy available to him. Even before the court also, he has not come up with any affidavit, like when he is going to pay, nor before this court, in spite of giving a reasonable opportunity, he has also not filed an affidavit. In these circumstances, in the considered opinion of the court, the petitioner is not entitled for any relief from this court, and the executing court had rightly passed an order. Accordingly, the petition is dismissed. Yes.
Lords, I am appearing for the petitioner. It is a matter of certiorari and mandamus, my lords. Lords, the petitioner is challenging the impugned order date passed by the trial court dated 26/11/2025, my lords. What has happened in this case is that, my lords, on 10/3/2025, the respondent number 2, that is the passport authority, has issued a passport to me. And thereafter, my lords,
Where is the order?
My lords, at page 16.
This order can be questioned before this court.
Please.
In a writ petition under 226.
Please, my lords, yes.
How?
My lords, it is covered by judgment. It is covered by judgment of Justice Nag Prasanna, my lords.
It is, the petition is knocking the doors of this court, calling in question the acknowledgement dated 29/2023.
Yes, my lords. That is
who questioning before this court.
The impugned order and the.
You cannot question this order dated passed in a criminal case.
My lords, one submission. What has happened is that the trial court judge made an observation while rejecting my application before the trial court, my lords.
So what you have to understand is, if in a criminal case,
an order is passed, you can't come in a writ petition. You have to file an appropriate petition before the court.
We filed, my lords, already. For that, this honorable court has already stayed the matter, my lords, in criminal petition 101127.
Why are you seeking the same order in this court?
My lords, the trial court has rejected my order, my lords. That is why we have come before this court.
I think there are a hierarchy of courts. There is law, there is procedure where you can question it. Can an order passed in a criminal case be questioned in a writ petition under 226?
My lords, in the case of Nandita Kumari versus the state of Karnataka, my lords, in the writ petition number 13176 of 21, the Honorable Court, High Court of Karnataka has allowed the petition. What has happened in this case, my lords? The trial court judge has rejected the application, my lords.
Please don't go into any of the matters. Please tell the court where is the maintainability of a writ petition against an order passed by a criminal court is decided in any of those writ petitions. Please tell the court.
My lords, kindly post this tomorrow, my lords. I'll get the proper instructions on this.
List the matter on Tuesday.
Grateful.
Difficulty is for everything covered matter. First of all, you have to see what is your case, what is the judgment.
My lords,
Point
my
is-
prayer of mandamus is for directing the respond number 2 with regard to travel permission. My lords.
Let's see. That's
Yes,
not
my
the
lord. It is
relief
there.
you're seeking.
It is there, my lords.
What is the prayer?
My second prayer itself, issue a writ of mandamus directing the respond number 2.
First prayer is issue a certiorari quashing the order dated 26/11/2025 passed by the JMC.
Please, that is first prayer, my lords. The second prayer is mandamus.
This is a consequential to this. Unless this is set aside, how can this be interfered?
My lords, I'll get it tomorrow.
Yes.
Tuesday. Grateful.
Parole matter, Your Lordship.
You there?
The report
Straight away they come here.
No, Lordship, report has been sought by the department, Your Lordship, wherein page number 62. After visiting to his house, Your Lordship, they found that somebody is there to look after his
Any
father.
order is passed.
Report is given and he has issued endorsement, Your Lordship. Okay,
It should be an order by him.
please, Your Lordship. Order is not there, only endorsement has been issued, Your Lordship.
No representation for the petition. Is this matter for dismissal tomorrow? Not tomorrow. Whatever tomorrow, I said all day after tomorrow, even from morning also. All matters day after tomorrow, because tomorrow we have to have that MFA list. Yes. Yes, 99.
Please, Lords. But concerning representation of Annexure C.
Same order like yesterday.
Please, Lords.
What are those matters? Yesterday's matters. are
Serial
there?
number
Mega has taken.
6162, Lords. Previous day.
Mega has taken yesterday. The present petition is filed. Seeking the following prayer. The petitioner is the wife of the convict who is lodged in Central Prison Dharwad and who is undergoing sentence for life imprisonment for the offences under Section 6 of the POCSO Act 2012. It is a case that the petitioner's husband has already undergone the actual period of 15 years, 5 months, 4 days as on 29/11/2025. The occupation of the petitioner's family is agriculture. Petitioner is growing mango and other crops in their agricultural land. Now the harvesting season. When is the harvesting season? Hence, presence of the convict is necessary to harvest the crops. It is submitted that the husband of the petitioner has made representation on 24/11/2025 to respondent number 3 for grant of general parole for the purpose of the harvesting of the crops. The respondent number 3 sought report from the respondent number 4.
Until date, the respondent number 4 had not submitted the report to respondent number 3. Now, with these facts, give it to Mega Shilda, same order. Yes. Disposed of. Yes, next.
Lord, I am appealing for the petitioner. Lord, writ of mandamus, my lord, to consider my representation at Annexure C, page number 21.
What is the representation?
Lord, that since totally, my lord, 13 directors were there in respect of, my lord, the society. And out of that, my lord, 2 directors died. And, my lord, 7 directors, my lord, they have given resignation.
No,
And,
your representation to whom?
my lord, representation is by the chairman of the said society, saying that he is unable to, chairman of the society.
To which respondent?
My lord, to all the respondents, my lord, because as per the annexure E, my lord, lordship may kindly see.
Authority to consider your representation. To him only you should give. If you give to everyone, how does it matter?
My lord, even it is, my lord, the respondent number 2 and 3, my lord, they are supposed to consider it, my lord.
Stated your lordship, Sahakari Sangha Upanibandhakara Kacheri office. Yes, given your lordship. To the office, not stated.
Lord, even the respondent number 3, my lord, has made a forwarded the representation given by, my lord, the petitioner to respondent number 2. Even then, my lord, it has not been considered and no necessary
Your
orders
lordship,
are being passed.
I have got
Petition
instructions.
filed seeking the following prayer. When counsel for the petitioner submits that he has given a representation to the third respondent dated.
My lord, it is dated 2/4/2024.
What is that?
Annexure C, my lord, page number 21.
Date
2/4/2024, my lord.
2/4/2024, and the third respondent in turn has forwarded the same to the second respondent. It is a grievance of the petition that the second respondent has not considered the representation. Hence, it compelled the petitioner to come before the court by filing a presented petition seeking a mandamus, and HCGP appearing on behalf of the respondent submits that they will consider the same in accordance with law.
Please.
Considering the submission of the learned HCGP, the petition disposed of in the following manner. The petition disposed of directing the second respondent to consider the representation in accordance with law within a period of 8 weeks from the date of receipt of the copy of the order.
Please, oblige, my lord.
Yes, Mr. AG. Oh,
Yes, in this case,
what is the procedure? Not in that writ petition. What is the procedure for the government? Whenever a writ petition is filed, when will you file the objections?
But the writ petition rules is applicable to the state also, madam.
Huh?
Writ petition rules is also applicable to the state.
What is the state doing? No, I have seen,
Yes.
not even in one writ petition, I have seen the objection filed by the state. State is a mute spectator to everything that's happening in the court. You will only get instructions on insistence. It is not on insistence.
Yes.
You are a party to the writ petitions. Their duty is cast upon you to
Yes.
file your objections.
Yes, we
You have to give instructions to all your.
yes, we will file, madam. We see that one.
When you receive the papers,
Yes.
no, the procedure is generally, like, I don't know how it is followed here. In a writ petition, the official respondents are the parties. Now, unless and until the papers are served on them, it will not, the writ petition will not be numbered.
Yes.
It will be appearing. By the time you come up for the
Yes,
first
yes,
time,
same procedure.
you should get instructions. And
Yes.
by the second time, you should send it to the concern, call for the remarks, file the objections before the court.
Yes.
Otherwise, there is no purpose.
Yes.
The writ petitions are pending for that reason. No, if you look at this.
Yes, this
petition,
case,
there
my
is
lord,
a-
this case, madam, not less than 3 to 4 courts orders have been passed in the past, so directing this specifically to take the instruction on that aspects. And it is urgent at our request only, madam.
Why should when a writ petition is filed and it is a case of the writ petitioner that he is not eligible, it's your duty to consider.
Yes, ma'am. There is a directions. Yes, ma'am. It is our duty to do it,
What
madam.
will happen is then the state
There
will
is
be
no
contributing
assistance.
to the litigation by
Yes.
keeping quiet.
Yes.
In all the matters, please instruct.
Yes.
Please
I
ensure
ensure that,
the
madam.
petition is filed
Yes.
within 2 weeks.
Yes.
Objections have to be
Please,
filed.
I ensure that, madam, in all these cases we'll file.
Yes.
Please, sorry.
Next. Pass outs.
Please. Lordship, we have carried over the amendment, my lord. Zonal 3, that corrected in the court title.
The petitioner has corrected the cause title. The interim order, by correcting the same, the interim order shall be, the registry shall give the upload the corrected copy.
Please.
Yes, next.
Lord, I had filed a memo. The constitutional validity of the domestic violence is challenged. Long back itself is upheld, though the word of struck down is the male adult member is struck down, and the act has been held to be continued, my lord, para 44. And in addition to that, the petitioner has challenged that the amount awarded 50,000 is on the higher side. But in the connected, in the MFA, in a domestic, sorry, in a matrimonial matter, they have settled page 41, my lord.
Representation on behalf of the petitioner. This is matter for dismissal on Tuesday. Yes.
Post the matter tomorrow, madam, since the senior is engaged in other.
Tomorrow,
Yes, tomorrow. Yes, not day after. Let's just matter on 10th of February. Yes.
My lord, this is also same, my lord's matter. My lord's fifth respondent, my lord's moved an application before the, my lord's third respondent. My lord's on account of death of his father, he moved an application for transfer of the license, PDS license in favor of the fifth respondent.
Acceptable one.
My lord.
As per the.
Please,
Acceptable one.
Your Lordship, this is first time matter, Your Lordship, I'll take notice. Please, Your Lordship.
So and so. For respondent 1 to 4.
4, please.
HCGP takes notice and shall get specific instruction in this regard by Lissus matter on 5th of February.
My lord's interim orders, my lord, I am seeking for interim order. My lord, what's a government notification says that my lord, there should be a three condition he has to fulfill. One, my lord, he has to pass in the 10th, and my lord, he has no source of income.
Stay you're seeking.
Stay of the order passed by the third respondent, my lord.
Order passed.
Annexure K, my lords, wherein my lords, license was granted in favor of the fifth respondent. That I am seeking for. My lord, for a moment, my lords.
Let him get instructions. I'll not grant.
My lords, if my lords license was granted, my lords, my
This
petition.
matter on 29th, get instructions. No
Please.
interim order. Yes, 29th. Yes, get instructions. Finally, Lissus matter on 3rd of February. No further adjournments will be granted. HCGP shall get instructions. Please. Yes, next.
Obliged.
Call the list. No, final hearing matters. Yes.
My lord, serial number 101, my lord.
Yes.
I am appearing for the appellant insurance company. It may
Yes.
kindly be posted tomorrow, my lord. Tomorrow is MFA day.
Then why did you move the memo if it has to be posted?
No, I did
tomorrow?
not move the memo, my lord.
Who moved the memo? This is matter in the month of July. In spite of moving a memo by the respondent, there is no representation. It's 450 already. Yes.
Tomorrow,
no.
my lord.
Not tomorrow. This is matter on
Legal.
second. All these matters, if in any of these matters, if there are any death cases, list it tomorrow. Or else give the date.
This is a 101 is a death case, my lord.
Cases listed tomorrow. Other matters, it will come, give some date in the month of February.
Please, my lord.
Hundred
107 to 110 are injury cases.
Order is there extend? Yes.
There
If
is interim-
interim order is there extend?
Please.
Yes, memo is filed in two. Memo is filed seeking dispensation of notice to R1, R2 and R4 to R10.
Memo is taken on record, notice is dispensed with, then
Needful is done.
is done.
It is done.
It is submitted that the needful is done as far as R3 is concerned. List this matter after service of notice. Interim order, if it is there, extend. S3,
Three, my lord, tendered appearance for the respond number 16.
await service of notice.
In fact, my lord, this is
As
final
far as
decree
10
proceedings.
is concerned, the needful shall be done within a week.
Final decree proceedings has been stayed, my lord. Final decree proceedings has been stayed.
But
By,
what to do? It has to be served to all the people. Yes, next.
Serial number 4, my lords.
Yes,
In-
list after service of notice.
Interim order, my lords.
If it is there, please verify and then extend.
Please.
My lord,
Same order.
serial number 5, my lord, in addition to my lord, await notice, I am permitted to take my lord hand summons because my lord,
Permitted to take out hand summons and counsel appearing for the respondent and file a memo to that effect. Yes, 6.
please, much of.
A week's
My
time.
lord, needful done, my lord.
It is submitted that the needful is done.
Interim order may be extended, my lord. Right.
List of
serial number
service of
7, my lord,
notice.
I have petition. Interim order may kindly be extended.
Yes. Yes, 8 also same.
Interim order may, other.
9.
Please. Please. The PF has been paid, my lord. Take weeks.
Submitted the needful is done. List after service of notice. From order
Interim order.
is there?
Please.
Yes, extend.
Please.
Yes, next.
Serial number 8, my lord. Serial number 8, interim order may be extended.
In all the matters, it is extended.
On
Yes,
serial number 10, my lord, I have filed an IA seeking substitute service against the unserved respondent number 4.
Is filed seeking substitute service of notice on R4 in so and so.
Lokmata
The
newspaper.
The IA is allowed permitting the petition to take out notice in so and so, mentioning the on or before so and so, and mentioning the date of hearing as so and so.
What you
7.
For the petition, yesterday's matter, my lord, regarding the transfer, my lord, of the class 4 employee in the KSRTC corporation, my lord.
So, lords, I was directed to my lords produce the transfer guidelines. Where my lords pass on transfer guidelines.
This is matter on Tuesday in the first list.
My lord,
Yes.
Tuesday, may I request on Friday, my lords, if possible.
Friday may not be possible, that's why.
It's Tuesday, my lords, the connected writ petition. Contempt is also listed on Tuesday.
Monday
Monday
is
is a holiday.
Friday, I think Friday may not be possible in your list.
I'll take my chance on Friday, my lords.
Yes,
Please.
12
Both matters. Wait.
and 12.
Interim order.
Yes, interim order earlier granted is extended.
Lord, 12, 13, 12, 13. Yes. 12, 13 and 14. All three are connected.
12, 13 and 14.
Yes. 12. Moved a vacating stay application. And another two matters are there, my lord. That is not listed today, my lord.
What is this matter about?
Lord, this is cooperative society matters, my lord. May I request for an adjournment, my lord. Another two matters are there.
List along with so and so on 10th February.
Please, my lord. May I request it? Another two matters because of there is
Along with
urgency
that.
because.
Along with it, 10th February.
Lord, may I request it on 13th, my lord, not 10th, 13th. Massive misappropriation, my lord, in the
13th.
society
13th, it's not possible.
and recovery
Or
process.
it's 11th.
Lord, 10th, 11th, I have inconvenience. 14th is also.
9th.
Please, 9th is.
Yes, next. Next.
Lord, along with those two matters. Please.
Yes.
Diversion finding on injunction. Lord, the trial court, my lord, had granted an order.
Vacate stay is that this.
I have
matter-
filed application for the vacating.
Matter in the first list on Tuesday. Not Tuesday, Wednesday. Wednesday in the first list.
Interim order.
Interim order earlier granted is extended. Yes, 16.
Represent the respondent. Petition. Represent the respondent. Order passed by consumer forum is challenged on merits.
This in the first list tomorrow.
Please, madam.
Day after tomorrow.
Please. Interim order may kindly be extended.
Interim order is extended in the first list tomorrow, on a day after tomorrow.
Please,
Yes,
madam.
17.
For the petition. It's a divergent orders.
I filed,
injunction which was granted by the trial court, under the,
By the-
reversed by the appellate
I
court.
filed an application for vacating stay
Vacating. This in the first list on,
Tuesday, my lords.
on 9th. Not possible next week. Yes.
Interim order is existing.
Interim order all granted is extended till then.
Obliged.
18.
Tender matter, my lord. Tender matter, my lord.
In this matter, work order is already allotted, your lordship.
File your objections.
Please, your
This is matter on 17th of February. The
My lord.
LCCP shall file the objections.
Lord, interim order may be extended, my lord.
Before granting your lordship, a work order is already.
It is a submission that the work order is already extended, already granted in
Granted
favor
to
of the,
other person.
yes, the other party. Yes. Yes, next. 19.
In all these cases, my lord, the dispute is that whether the temple is Hindu endowment registered temple or not. Before, in the 1904, my lord, there is a scheme was framed under the Bombay Trust Act to look after the temple. Now the principal district session judge of the Dharwad is the chairman of the temple, my lord, at present, my lord. So in these cases, my lord, the batch of cases, the main dispute is that whether temple is a registered temple or not, my lord. But in the 19.2, my lord, there is a restraint order by this honorable court to not to open the undi, my lord. That is the donation bags.
Matters
No,
Monday. We'll have it on 4th February.
only small request is that, my lord, that undi is filled with the currency, my lord. It is chairman is the district and principal judge of the Dharwad, my lord. Let the undi be open and the same will be kept in.
We'll hear it and dispose of. Why should we keep
Please,
it pending?
please,
It's the matter on 4th February.
please, please,
Yes.
please,
Interim order is there, must kindly extend.
Interim order all granted is extended till then.
please.
Yes. 23. Yes, 23.
It's 23. I appear for the respondent, my lords. They have obtained an interim order. Your lordship may have it in the next week, my lords, for B group, in the first
This
list.
matter on 10th of February.
Interim order may extend.
Interim order all granted is extended. Yes. This is adjourned. Yes. 27.
Your lordship, I am appearing for petitioner, your lordship. Interim order may be extended, your lordship.
Lordship, serial
Serial
number
number
27.
27. Serial number 27, your lordship.
27.
Your lordship. May I seek next week, your lordship?
Any date may fix for the reason that execution proceedings are stayed, my lord.
12th February.
Grateful. ma'am.
Please.
Interim order may be extended. Your
Interim order will be extended.
Great.
It's 29.
Please, your lordships. Lords,
Respondent in this matter, my lords.
the impugned order is at page 52, your lordships. The matter is pertains to,
Hearing it now.
yes, please.
When it
Lords,
can be taken up.
any date in the month of Feb, my lords. Have it on,
The matter the other day argued.
no. This is a different
The
matter.
matter on 19th February.
Please. Lords, some early date may be given, my lords. Some early date. Yes,
How
19th.
many matters early
Yes.
days be granted and
Lords,
how the court can hear?
on the previous date, my lord, the council has submitted that there is a corrigendum order.
Right, there is a corrigendum, my lords. I will clarify when it hurts on merit, my lords.
Yes. Therefore, my lords, direct them to, my
As
lords,
writ
produce the
petition is not
corrigendum order.
maintainable, my lord, because
If there
no
is,
locus in the matter.
There are so many matters.
at least, my lords, otherwise,
Lords,
please.
sorry for indulgence, my lord. My lords, one submission. Sorry for indulgence, my lord. My lords, matter at serial number 16. They are list 2, my lord, serial number 16. They are informing.
My lord, the 16 may be disposed of with the liberty to challenge this, file an application before EP court, my lord.
That's coming up to day after tomorrow. We'll pass orders on the
My lords,
day.
in my matter, there is an interim order. It may kindly be extended. There is an interim order in the matter, my lords.
All the matters wherever interim stays, there will be extended.
Please, gratefully, lordships.
Sir. Sir. The list to serial number 8 ನೋಡಿ ಮೇಡಮ್ ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಾರ ಏನಾಯ್ತು ಮೇಡಮ್
Court officer. Excuse me.
List
Serial number 98.
serial number 8 ನೋಡ್ರಿ ಏನಾಗೈತಿ ಲಿಸ್ಟ್ ಟು serial number 8 ಡೇಟ್ ಯಾವಾಗ ಕೊಟ್ಟ
Sir, list 1 serial number 98.
List to serial number 8 ಡೇಟ್ ಯಾವಾಗ ಕೊಟ್ಟ serial number 8 ಬೇಕು 4 okay
ಇಲ್ಲ ಅದೇ ಮತ್ತೆ ಮೆನ್ಷನ್ ಮಾಡಿ 27 ಕರೆಕ್ಷನ್ 27 ಕರೆಕ್ಷನ್